No, it was in the combined list. Previously, your lordship fixed it, but it has not been taken up. He is very elite person, he could not extend. He is very 71 years age. No pension has been given.
Pension?
No pension has been released.
Which department?
Education department.
So why before this court? If the education department pension is not
So
there.
it is in the list of my lords.
Huh?
My lord list. It is in your list, my lord.
Might be list, but how this court can take the education matter pension? How this court will take? Go to the determination. The court having.
Then it is released.
Huh?
It will be released.
Which matter? Give the number.
198 of the combined.
198 of the
combined list.
Combined list means monthly list.
Yes. Irrespective of classification hearing, like 198.
On prosecution.
Irrespective of classification.
I got a note. Learned. The matter is listed as item number 198 in the monthly combined monthly list of August 2026. And counsel for the petition submitted. This court is not having examination according to release of the matter from the list of this. In view of the submission made by the counsel for the petitioner, WPA 23962 of 2024 is released from the list of this court with the liberty to the petitioner to mention before the appropriate court having determination.
May I have minutes kindly to mention, Madam, I am praying for the inclusion of a CAM in connection with the writ petition. Writ petition is challenging an order of blacklisting. I have an interim order in my favor that I would be allowed to participate in the tender. New tender has come, but we have sourced that because of the pendency of the writ petition, we can submit the bid pursuant to the order, but it will not be entertained because of one paragraph in the order that ad hoc order will be subject to the writ petition. So, I filed for the subsequent development, I filed a CAN, but if your lordship kindly includes the
tendency of the writ application, blacklisting, how you can be allowed to?
I have been. That is the order, kindly see, because it was ex facie illegal, kindly seize this order. We are enjoying this order. But, because of paragraph 5 is, where I have been
order subject to the ultimate.
Yes, but kindly see paragraph 5, participating in the tenders floated. So, I have been permitted. But citing this, paragraph 6, they are preventing me. But I will be allowed the fate is known. So, kindly permits the can after tender of Coal India. If the lordship kindly permits, I am mentioning upon notice, I am giving the mention. I'm sorry.
May I mention one urgent sir matter with notice and service?
What matter?
Sir matter. Special intensive division.
May I have your lordship's kind leave, my lord, to mention one. I'm sorry.
SIR matter है कल के रख दो.
May I have your lordship's gracious leave to mention one matter, my lord, of grave urgency, my lord.
Inclusion.
Yes. How many years you are having practice? How many years you are having practice?
26.
One person is mentioning the matter, you're coming in between. I will not take any of the mentioning matter.
My lord, sir. My lord,
Yes.
My account has been frozen, my lord, by the bank without following the procedure under section 107 as indicated by your lordship in your lordship's judgment. Now, my lord, I have a travel plan to go abroad, my lord, for medical purposes, which was allowed by the Honorable Supreme Court of India. My lord, I am seeking leave, my lord. I don't say unlisted, my lord. If I may come back tomorrow, day after, whenever it's convenient to your lordship, my lord. My account has been frozen by the bank without 107. I have challenged that action of the bank before your lordship, my lord.
The investigation is going on.
There is no, my lord, there is no investigation so far. I am concerned, my lord. The investigations are taken care of. That, my lord, no coercive action. There is no police order, my lord. I have written it to the bank. Bank reply, there is no police action, my lord. This bank did not indicate anything, which is why we are before your lord.
Bank.
The HDFC Bank, my lord.
They will not come. Okay, day after tomorrow, within
most of them. Effect service, my lord, in the meantime.
Serve the notice day after tomorrow within 10 minutes.
May I mention the material of Your Lordship, in this matter, your Lordship has directed the respondent bank to submit a report by 37/2020. But they are yet to submit any report, your Lordship. The matters are already in 110, 111, 112 in this honorable court, your Lordship. If these matters may be upgraded, your Lordship. Because petitioner's 3 current account has been put to lien and the huge sum of money has been deducted in lieu of flimsy ground, your Lordship.
Item number?
Item number 110, 111 and 112, your Lordship. Bank of Baroda, Chandni Towers versus Bank of Baroda.
Okay, we'll sit.
Deeply obliged.
Yes. Yes. So what is the urgency? Okay, you go and file it. There is no urgency. Please, urgency.
CK Lordship.
You file it and we'll sit.
CK Lordship.
Yes.
CK Lordship, this matter, CK Lordship, and yes, to sense this matter. Last Friday night, I was allowed to try to annex the resolution. Annex number. Can you take
Already 4 matters, 5 matters. It's allowing to withdraw, then you're withdrawing, you're coming with the same plea.
my prayer is different. My prayer is different. Kindly,
First week of September.
can explain it?
2nd September. After note.
So,
It is listed.
yes,
Which
yes.
number?
WPA
Which
1247.
number? Serial number.
Item number, I'm not aware, Your
So
Lordship.
why you are mentioning? If you are mentioning, I am
This is
dismissing.
for
No.
non-prosecution, Your Lordship.
Which give the number I am releasing here, dismissing herein now.
Okay,
Which
okay.
number?
I am not aware. I
Then
don't
you
have
give
the
me the
instruction.
number. Several matters are pending long. What is the urgency? You tell me only.
Tender is completed and award has been,
So you want to withdraw?
but the payment is stuck off.
Payment you will get. Yes. Hmm. Hmm. It is not in the list. बीस तारीख को 20 September August.
Your Lordship.
May I please permit it to Mr. Ricardo?
So what is a prayer? What is your prayer? Here I will hear you. But what is the prayer? What is the urgency? 50 item number 50 is there. Please wait 2-3 days. It will come up.
Your Lordship, I am. Your
Correct. Within 10, so like this, if the 10 advocates are mentioning 10, so what is 50? It will come. Yes.
Lordship, you're mentioning for a new motion matter. It was.
Madam, it is in 50. Please wait 2-3 days. It will come up automatically.
My lord, SIR.
Your Lordship.
What is the urgency?
SIR.
What is the urgency, SIR? There are lots of SIR matter.
appeal pending. before
Maybe
tribunal.
pending, you
Your
go
lordship-
file and we'll see to that, yes.
Lordship, I'm mentioning for a new motion matter.
What is the urgency?
It was for listing. It was last year. It is for inclusion, your lordship.
Why?
It's last year before Honorable Justice Om Narayan Roy on 6th of August, and since it has been delisted because as per the justice has observed, it is not pertaining to surfacey matter. With the liberty to mention before appropriate court, that's why we are approaching this court for listing. We have last issued on 10th of August. and-
September monthly list, new motion.
I have my lord's leave to mention this matter, my lord, for inclusion in the monthly of September, my lord, the petitioner's manufacturer of the vehicle location tracking devices, my lord, for public transport vehicles, my lord. The such license was suspended, my lord, by the respondent authorities. We had listed this matter before the court, my lord. The court had released it for lack of determination. This is the bench which has determination, my lord. If this matter may be allowed to be read in
September.
September.
Lordship,
New motion.
Lordship, I'm praying for leave in this matter, Lordship. I'm the need aspirant, Lordship. SDO did not issue the domicile certificate. Now, council, SDO did not issue the domicile certificate. I'm cancelling
Certificate?
domicile certificate, Lordship.
Domicile certificate.
Lordship, cancelling started today from Lordship. Today onwards,
Still is
Lordship.
pending.
Lordship.
So what the court will do?
My name is delayed, that's why they have not issued the domicile certificate. I'm cancelling person today, Lordship. Tomorrow, Lordship. Tomorrow.
Huh?
हाँ, domicile certificate is no.
Yes.
ऐसा यार नहीं है.
No.
Domicile
Okay.
certificate.
उसका ले लो 2nd September. Within 20 matters. 2nd September, 20 matters. Huh? Huh.
বল তোর কি আছে তুই বলছিস না কেন?
Who has directed? 10? हाँ. Okay, उसका ले लो फ्राइडे रखो. हाँ? हाँ. Restoration application. Okay. Yes. What is the correction? कल की correction. कल के रख. When is the last date?
Last date is within first of September.
When you file the writ petition.
Around 2nd of July.
এটা কাল के করি না. কাল के আসাইয়া করি না. Yes. Monthly list of 1. Though the matter is listed as item number 158 in the combined monthly list of this court, but the land counsel for the petitioner press for submit that this court is not having determination, wanted to release or withdraw. But the land counsel for the petitioner submitted, she has got the instruction from the petitioner that the petitioner not intending to proceed with the matter, press for withdrawal of the writ application. In view of the submission made by the counsel for the petitioner, WPA number 21302 of 2025 within bracket Nirmala Roy versus State of West Bengal and others is dismissed as withdrawn. Yes. What is the urgency? You tell me the urgency now.
Although she has made the payment, but of this correction, she has progress in order, and she has to make the or comply for income tax exemption of
3 September को रखो. Flip छोड़ दो. Yes.
My lord.
No, bolo.
I'm mentioning for correction in the cause list.
Correction in the cause list.
Well, they are permitted to mention a matter.
Lot of correction.
On a new motion, the urgency is that the petition due to the debit freeze, the petitioner is not getting his salary for the last 3 months. He is a very
Debit freeze, many matters are there.
filed this to appear the matter on 12th May.
हाँ.
It has not been appeared.
3 April, 3 September.
My lord, I mentioned a matter in July. This court needs to direct it listed in the monthly list of August, but it is not listed. Matter is 2023 matter. Kindly inclusion in monthly list.
Monthly September.
Lordship, may I be?
Regarding the SIR matter, lordship, petitioner is not in a position to apply for passport.
Not-
The two
First you get your name included in the voter list, then you apply for the passport. Yes.
So, appeal is pending. Since
Yes, I am taking every day 1800 matters, it will come.
Can you give the direction so that matter can be listed, lordship?
For modification and clarification.
Who will search the all files? If you mention 5,000 filing is there, who will search the file of the SIR matter?
May I have your lordship mention a matter for modification and clarification of the lordship's order matter. Urgency is that I had given a limited time direction for a disciplinary authority to conclude the proceedings, and there was a specific direction that no further evidence can be taken. Now, my lord, the accused person is interpreting as if that has debarred me from even cross-examining the witness who has given evidence. My lord. That is the clarification I is kind of trying to.
What, you file an application?
My lord, I filed an
What application?
application for clarification.
Application में रख दो.
So
Application.
it's a type of direction.
Application में रख.
Matter. So there was a direction by your lordship to list in the matter, but did not come.
What is the urgency?
My
Might-
urgency is that worker of the port, dock worker, were doing their job in a most unsafe manner, my lord, without any safety and security in the
So who
thunderstorm.
are you?
My lord, we are the worker.
Ah.
Worker, my lord, seeking some relief. for
What
safety.
your prayer? What is your prayer? And what is the urgency?
Prayer during the thunderstorm, there should be some direction so that we can do our job safely.
After thunderstorm you come, I will see.
My lord, this is a new motion. My lord, deed of conveyance, they're given it for registration. They are not giving it back. When I give a demand for justice, they reply saying that it seems that we have lost the original conveyance. My lord, immediately, unless the paper publication is made and a police complaint is made by the department, that property can be mortgaged, anything can happen. My lord, I've served everybody, I'm moving it upon notice.
So what is the urgency?
The urgency is that unless the matter is taken up and a direction be given to the authorities to at least make a police complaint and a paper publication, I mean, somebody else can just misuse my deed.
8 September.
Permitted to mention one matter.
Seeing a matter, which is due to appear 29 July. The urgency is, this is against the bank. I have today, no fraud, no LOC, no willful default against me. Yet, the bank has filed a complaint, before the authorities, without any basis.
Which authority?
The CBI, but I am not proclaiming anything against them. I am saying the bank, after taking the money in a bank, there was a settlement. I am willing to pay off the dues. Despite, they have filed a criminal complaint. We filed a.
So what the court will do? What prayer you make? What is your prayer here?
Direction on the basis of this to withdraw the complaint. Kindly, see,
You challenge the complaint before the appropriate court. How this writ court can entertain all this?
It is a mandate.
If they have made a complaint against you, so you and any FIR has been made or chalked out, then you go to the appropriate
That
court.
is a different mechanism which is available to me
Correct.
for quashing of the FIR.
Correct.
Forum.
Correct.
But what I am here, is that the bank did not have any fundamental basis, to go and file the complaint. Your lordship has dealt with matters, under the RBI circular, where, first of all, there has to be a fraud to initiate a complaint. Now, I will show you that there is nothing, everything has been
So
said.
what is your case is a violation of the master guideline, master direction?
Yes, master direction. In breach of the master directions, they are proceeding. And your lordship, in this matter also has dealt with several times, it should not take too much time.
But the court is not having time.
I am.
Correct. 23. 26. I will easily you mention, I am totally full day, I will hear the mentioning, no problem. But you will say the 10 matters, I will fix the 10 matters on 10 October afterwards. Every day I will take your all mentioning till 4:30. See, you're mentioning 2 persons are coming with the list. You are mentioning 2 persons are coming with the list. I will hear, no problem. But mind it, I will not take the list which is fixed for hearing. Till 4:30, if you will continue to that. Not a single urgency is there, but you persons are mentioning. What is the urgency? What is the dictionary meaning of urgency? Yes, call the list. Kindly.
My lord, unauthorized detention. My lord, sentence. Period of sentence has been over, my lord.
My lord, I have an urgency, my lord.
My lord, unauthorized detention.
Extremely
My lord, even after the sentence period is over, my lord.
Who is number 1?
Well, I am for the petition, my lord.
Stop over.
My lord, this matter was fixed by your lordship on 9th July, my lord. Therefore, you will be same to the.
Who is the other number 1?
The list for inclusion.
Yes. Why it is mentioned?
Urgent
For
matter.
extension of interim order is going to expire tomorrow, my lord.
Which was the other side?
Mr. Onivan Mitra is appearing on behalf of the respondent, my lord.
Urgent matter.
Huh?
In 1 and 2, my lord. My lord, last question, my lord, there was direction to file a supplementary affidavit, my lord.
No.
My lord,
There is a direction for filing opposition by them in our can see. They have not yet served any copy, my lord.
Yes. Have you filed the affidavit opposition?
the draft is ready, my lord, for going for vetting, my lord.
Huh?
Well, draft is ready, going for vetting, my lord.
What is the submission?
My lord, kindly take it after 2 weeks, my lord. It will be filed, my
May I
lord.
beseech one thing, my lord.
And
Instead of traveling your lordship in a piecemeal, my lord, kindly extend the interim order for as your lordship thinks fit up to that time, and in the meantime let it be fixed for hearing so that the matter can be settled, my lord.
The Land Council for the respondents prays for extension of time to file affidavit in opposition in respect of Can 3 of 2026.
My lord.
And let affidavit in opposition be filed within 2 weeks. Reply, if any, that be filed within a week thereafter. Land Council for the petition submit the interim order still today and paid for extension of interim order. In view of the submission made by the council for the petitioner, let the matter appear on acta date then, fixed matter. 6th October at 2 p.m. 2 p.m. Interim order is extended
2 p.m.
till 8 October 2026 or until further order.
Grateful to you.
Next.
1 and 2 same, my lord.
Yes, next.
Great.
So you're given the order for 30th of August, in the first 5 months. In every 50, 60, 47 like that.
May it please, my lord.
Yes.
Lord, at the outset, my lord, I must express my gratitude for this urgent listing, my lord. Now, the matter that arises for your lordship's consideration today is whether the exclusion of a parent's name from the SIR 2026 would cause an impediment in the issuance of an EWS certificate to a candidate who is otherwise enrolled in the 2026 SIR, who has previously been issued the EWS certificates on 2 occasions. Coupled with the fact that, my lord, the EWS framework also does not anywhere recognize that the parent should be enrolled in the electoral roll. That is not a condition. Now, I'll satisfy your lordships in the event that the other side opposes, my lord, but I don't see anyone appearing.
Where is the affidavit of service? Please. Have you served?
Lord, the learned GP has been served.
You're not served to the authorities?
No, the authorities have also been served, my lord, but I don't believe it's reached them yet.
But there is no.
Lord, the learned GP, I believe, would be appearing on behalf of the area.
He is very busy. He will not assign any matter for the 20 till 2028.
Not, but the urgency.
I am giving the assurance here.
May I satisfy your lordships on the
Every
urgency?
advocate is serving in the PP office, GP office, but the GP is not able to tackle this.
Lord, I'll not be.
I am appointing every day one of the advocates to be have tax the GP here.
But would your lordships, my lord, kindly permit me to express the urgency?
So you
Very well.
because you are not served to the department. You serve the department. Where is the service?
As the departments have been served, it's yet to be received by them.
Yes, where is the report? Tracking report.
It's yet to be served to them.
So when you will come after service? Come, I will fix the date.
As the issue is tomorrow is the last date for
So what
document
can be
verification.
done? You're not served.
Means I have.
You have taken the
the date-
shortcut method by
No,
serving
Lord,
the
no,
copy to
absolutely.
the GP office
with-
instead of serving to the authorities.
With great respect, my lord, the GP office was served on the same date that the service was also effected to the department.
The sub-court is having good experience with the GP office for the last 3 months.
I'm really sorry that your lordships are having to go through such a trouble, but my lord, kindly allow me to satisfy lordships on my urgency.
Yes.
Because I'm an EWS candidate, my lord. Kindly allow me, my lord. I'll just, for your lordship's reference, my lord, I've prepared just a 1-page short note, which will give your lordships a very brief idea of the matter.
Yes.
My lords, I'm a NEET UG aspirant, having secured 471 marks out of 720. My category rank is 16,401, general EWS. That is at action minute P1, page 26. Your lordships will find in the petition itself. Not my father had expired in the year 2008.
Correct.
His name appears in the electoral roll of 2002. He's there. So far as mother is concerned, my lord, the mother's name was this year deleted into 2026 SIR. However, her name appears in the 2002 SIR as her maiden name. The contradiction that appears before the SIR tribunal seems to be that there is a difference in the name. Her maiden name was Kakuli Mukherjee, and after her marriage, her name came to be Rekha Mukherjee. In her present election ID card, her husband's name is reflected as Prasanto Mukherjee. Secondly, I was allotted or issued EW certificates on 2 occasions. Firstly, my lord, on 8th of July 2024, that is at Annexure P4, page 41 and 42. And secondly, my lord, on 18th of July 2025, which is annexed in this, my lord, the reference note that I have circulated. Secondly, my lord, I applied for my EWS application way back in the month of June, 24th of June. That your lordships will find on Annexure P5 at page 43. Now, my lord, having made this EWS application, I visited the ADM office duly within 60 days. The requirement under the EWS application acknowledgement slip was that you need to visit the ADM office or the DM office within 60 days on the allotted dates. I duly visited them, but to no avail. I was given verbal representations, but nothing in written that your mother's name is excluded from the SR, so therefore you will not be issued EWS certificate. Nonetheless, my lord, I preferred a representation. I prefer 2 representations, in fact. Those representations your lordships would find on Annexure P6, pages 45, 44 and 45. Lordships was find at page 44, it's a handwritten. I have prepared a typed copy also for your lordships ease of reference. And at page 46. So these issues and also an email to the DM. And lastly, my lord, I have annexed the counseling dates at Annexure P7 at page 46.
Yes.
I have made an application. I am duly registered in the NEET portal. So once I register and I have made the payment, I am required to appear before the necessary authority for document verification. I have been issued that document. My document verification is due tomorrow at SSKM hospital on the 18th of August. Now, my lord, without the EWS certificate, I will not be able to permitted to even proceed further with my counseling. Being a meritorious candidate, my lord, I have a good chance of getting selected in a government college. Because my only predicament is if your lordships would only permit me.
Your name has been included in the
yes, my lord.
list.
Absolutely.
Where is that?
Kindly see the reference note that I have added, my lord, the last flag, the last page. Top left, my lord, item 280. It's written in Bengali, my lord, Priyanshu Mukherjee, Mayer Naam, Rekha Mukherjee, and residence and age and sex.
Where it is?
Lord, the last page, my lord. The last page, top left. Top left, item 280, just below 277, my lord. Losses will see XYV 137 8207. 280. 280. I have encircled it, my lord. So my name is reflecting in the 2026 SIR.
You casted your vote.
I'm sorry?
You casted your vote.
Yes, my lord. Did you cast your vote? You cast your vote, right? He's cast his vote. The only issue that the ADM is raising...
Where is the rejection?
There's no rejection. There is inaction, rather. There is inaction.
Who is up? Nobody is there. The petitioner has filed the present date application praying for a direction upon the respondent number 3 or the competent or any of the competent authority for issuance of EWS certificate so as to enable the petitioner to appear in the counseling for the MBBS seat.
MBBS seat, my lord.
For the MBBS seat, which is scheduled to be held on tomorrow. Scheduled to be held on 18th of August 2026. Police. Counsel for the petition submit that the petitioner has successfully passed in the NEET UG 2006 and secured 471 marks out of 720. And in the AIR seniority list, her name is appearing at 1,32,304. And in general EWS rank, her name is appearing at 16.
His name.
Her name. His name is appearing at 16,401. Full stop. He submit that the father of the petitioner, namely Prashanta Mukherjee, died in the year 2008. And his name of the father of the petitioner is appearing in the electoral roll of 2002. There is a discrepancies in the name of the mother of the petitioner. Before the marriage, the name of the mother of the petitioner was
Kakoli Mukherjee, Kakali.
Kakoli Mukherjee. But after marriage with Prashanta Mukherjee, she has changed her name from Kakoli Mukherjee to Rekha Mukherjee. As there was a discrepancies in the name of the mother of the petitioner, accordingly, the name of the mother of the petitioner has been deleted from the voter list during the SIR. Full stop. But the name of the petitioner has been included in the voter list and is appearing at serial number 280. And the petitioner has also casted the vote of the last assembly election held in the month of April 2026. As the domicile, full stop, as the petitioner is aspiring for getting his seat of MBBS in the college at West Bengal, as he has completed the MBBS and he has passed the NEET UG examination. But examination, and according the petitioner has applied for domicile certificate before the respondent number 3.
EWS certificate, I'm sorry.
EWS certificate before the respondent number 3. But EWS certificate has not been issued to the petitioner. Counsel for the petitioner submit that the petitioner has made several representations to the authority, but till date no decision has been taken. Though the interview or what verification?
No, document verification.
Document verification for allotment of MBBS seat is fixed on 18th of August 2026. He submit that if the EW certificate is not granted to the petitioner, the petitioner will not be able to appear before the authority for verification of the documents, and he will not get the seat of he will not get the MBBS seat, though he is a meritorious candidate of having secured 471 marks out of 720 in the NEET UG 2006. Petitioner has filed the affidavit of service showing that the notice has been served to the office of the government paid, but none appears on behalf of the state. This court finds that there is an urgency as tomorrow is as 18th August 2026, that is tomorrow is the date for verification of the record, verification of the documents of the petitioner for allotment of the seat of MBBS in any of the college in the state of West Bengal. In view of the above, the respondent number 3. But EW certificate, you have to comply with whether you are coming under the what is your annual income, how you have proved that.
Because I filed an affidavit to that effect also before the authority.
Respondent number 3.
Sure. Kindly pray for the accommodation. My senior is stuck in the heavy rain, sir.
Number 3 is directed to respondent number the additional district magistrate.
Yes, ma'am. ADM.
The respondent number 3.
The DM is the appellate authority.
Additional district magistrate, not 24 Pargana, new administrative building, not 24 Pargana, West Bengal, is directed to immediately consider the request of the petitioner with regard to issuance of EW certificate as the EWS certificate and to pass appropriate order, and if the petitioner is eligible for getting the eligible to get the EWS certificate, the same may be issued as early as possible by latest today at 5 p.m. Today at 5 p.m. It is full stop. Today at 5 p.m. It is today at 5 p.m. Let the matter appear, full stop. The petitioner is given liberty to communicate this on gist of the order to the ADM, and ADM shall act in accordance with the gist of the order and gist of the communication submitted by the petitioner. This order is passed only for taking into consideration that there is an urgency, as on 18th of August 2026 there is a date fixed for verification of the document. Full stop. Let the matter appear. Let the matter appear on 16th of September 2026.
I may not have been.
It is made clear that issuance of the EWS certificate by this order, if any, shall be abide by the result of the present date application, and if the petitioner will get the EWS certificate, he will file an undertaking before the authority as well as before the college authority. He will get an admission that he will not claim any right with respect of this EWS certificate if he failed to success in the present date application.
May I get a dusty copy? May I get a dusty copy?
Give gist of the order, supply that. उसको जल्दी कर दो फिर देख.
I may not have heard the exact direction, Lord. Your Lordship should kindly have the trouble of Lord just giving me one line direction.
जल्दी कर दो. Yes, next.
I'm so grateful. I'm very grateful.
Your Lordship, I'm for the petitioner, Your Lordship. I'm led by Mr. Shantan Addo. He's on the legs, Your Lordship.
I'm for the state.
Yes. What is the matter?
Your Lordship, I'm seeking short passover, Your Lordship.
No passover. What is the matter? You tell, otherwise next month. What is the matter?
Your Lordship, maybe it be fixed next month, Your Lordship.
Counsel for the petitioner prays for fixing the matter before the
My lord,
next month.
my
Let
lord,
the
may I
matter appear
complete-
on 10th of September 2026. Next.
My lord, may I? बोलबो? My lord, item number 4, my lord, I am for the state lordship. May I humbly submit one thing? Their prayer is for their peaceful entry in the Manasha Puja in their ancestral house. The puja is tomorrow, lordship. They are
He's asking tomorrow, what are you, next month, after what the court will do?
the
If you are staying on the petition, come this side, I will hear you.
I am not for the petitioner,
He's
lordship.
telling next month.
But
Yes,
in
lordship.
5 and 6 minute, I appear for the petitioner.
Yes.
I'll add a appear for respondent number 4, Government Marketplace.
To VC.
Now, my lord, but your lordship had the pleasure to hear this matter, my lord, on quite a number of occasions. And my lord, on the last occasion, my lord, there was a delayed counter affidavit filed by GM. Now, my lord, we have
Yes.
Yes. Now, my lord, we have, my lord, taken an objection to that. Now, my lord, if your lordship may kindly take a rejoinder today. My lord, pursuant to my lord's leave, my lord, we have filed a rejoinder. We are filing our rejoinder today. Now, my lord,
Yes, sir.
but only, my lord, for the sake of recollection, for half a minute, my lord. My lord, I intended to, my lord, drop my tender online. My lord, there were certain problems which were faced by me. My lord, I had, my lord, entered the help desk of GM. Then the GM the help desk, my lord, also could not, my lord, cure the defect. And my lord, finally, my lord, I could not submit my bid. Now, my lordship was pleased to, my lord, call for reports, my lord, which has come by way of, my lord, affidavits. The last one, my lord, which, my lord, my very respectful submission, is a completely, my lord, volte-face to, my lord, their previous, my lord, stand which was taken by the GM. Now, my lord, I have collated, my lord, the shift of stand, my lord, in my rejoinder which I filed today. Please have a look to, my lord, this rejoinder paragraph 8.
in WP number 12340.
Paragraph 8.
Paragraph 8. The shift of stand of the respondents from time to time is collated here under A. Email dated 20.
Yes.
Email dated at page 4. Email dated 28/5/2026. But this is the first response. One of our service experts will reach out to you shortly regarding your query complaint. This is at page 358 of the writ. Second email, my lord, on the same day and the next day, that is 28th and 29th, where they say we have checked bid had already been ended. Also, there is no provision to extend the bid once the bid is ended. So proceed further accordingly. But these were the contemporaneous stand. Now take, my lord, the third stand, which is C. Email of 2nd of June, as checked, shared video. Seller was at upload document step and directly jumped to last verify step. Due to this, he was getting error. Instead of this, bidder need to save upload document step and then take the next step respectively. Or in other words, where they say that for each step, you have to first save your documents and then proceed to the next step. Now, then the next stand is D. Paragraph 7 and 8 of the report says, in the present case, the petitioner was logged out of the system as it failed to complete a mandatory stage of bidding process, as is evident from the video recording between 1:08 p.m. and 1:24 p.m. submitted by the petitioner to the help desk of the respondent number 4. It is submitted that the system is designed in such a manner that each stage of the bidding must be duly saved before the user proceeds to effect final submission of the bid. As evident from the video recording submitted by the petitioner to the help desk of the respondent number 4, the petitioner accessed the upload document stage of bid submission process. However, it failed to save the said stage and instead proceeded directly towards the bid submission. And the last one is, my lord, by way of counter affidavit. Now, my lord, before, my lord, I place, my lord, subparagraph E, but I need to, my lord, bring to your lordship's notice that, my lord, before this affidavit was filed, my lord, I had virtually concluded my submissions in the final hearing of the writ petition. And, my lord, the matter was deferred because, my lord, the lunch recess, my lord, intervened. Now, the next day, when, my lord, I was only to show a few judgments, my lord, they come and pray before your lordship for the leave. My lord was kind enough to give them leave. Now, kindly see, my lord, what is the stand? After, my lord, I conclude my hearing. Paragraph 6.1 of the counter affidavit. The answering respondent categorically submits that the GM personnel or help desk representative did not encounter the same error as allegedly faced by the petitioner during the bid submission process. Irrespective of whether the GM help desk remotely accessed the petitioner's system through any desk, it was neither logically nor technically possible for the help desk to encounter or verify the same error. This is because by the time the petitioner approached the help desk for assistance, the bid submission deadline had already expired. Consequently, the help desk could not access the same bid participation interface or replicated the conditions under which the petitioners claimed to have experienced the error, as the relevant bid submission page was no longer available for bid participation after the prescribed deadline. Further, the help desk cannot provide meaningful assistance in such a case where the deadline for the bid submission was over. Now, a completely different stand. But in my, my lord, if your lordship may kindly come back to, my lord, D. My lord, between 1:08 and 1:24, my lord, the bid submission was till 2 o'clock. So I was within time.
No, there only the contention is that, okay, 1:08 to 1:24, you are there in the bidding process, but you failed to save them. Yes. Upload the documents and fail to save the stage instead of proceed directly towards the submission.
Right.
This is the only
Yes.
they have taken.
If that was the case, the help desk would have told me that, you see, you are not saving it, and instead of saving, you are jumping to the next stage. That could have solved the problem. And on the last occasion, kindly recollect, I have shown what is there pen drive that has been provided to us and to the court as well. But please have a look to it once again. But this is at 1352, where the lordship will get me at. But this is their annexure, it's in the form of an electronic record.
Video at
But kindly see at 1352 on the right hand side bottom on 28.5. But this is a running video.
What time?
At 1352. This is what they have provided.
1352.
Yes, on the right hand side, bottom, 1352, 28.5, 2026. Gone.
Actually, it's a video.
Well, actually, it's not moving, but it's a video. Well, it is there, evidence. नीचे हाथ दे
Oh, ठीक. Give.
Please see your right hand side, bottom, 1352. Miller is found there.
Yes.
When it continues, it starts from 1352 and it ends at 1353. 53 and maybe 54 also.
All sellers hereby notified strict action will be taken against them, so the account will be suspended.
OTP verification of the
But please wait for me about 30-40 seconds. Your lordship will find an OTP verification request. But at 1353 towards the end.
1352. Again, the
Your lordship found an OTP verification directive. Yeah, chole. But if your lordship permits Mr. Dotto to assist your lordship, if he can go over there to assist you. ये दोस्तों
वो तो जल्दी करना है कौन आएगा कोई आएगा वहां से ड्यूटी वाला कोई नहीं है मैं ना हूँ बस ठीक है करो हम कर उसे करेक्शन कर देंगे कोर्ट के लिए यहाँ लेके करके
this is the stage where they are asking for OTP verification. Please have a look to this one. This is at 1353.
And ever play button
yes.
Thereafter, after the if your lordship
presses the play
touches the play button, then your lordship will find where the OTP is given, and then I am put back to the login page.
Correct. That's why you have done all these things, but what about the saving of the uploading and saving?
There, evidence does not say that you have to save and proceed.
What the guideline says.
But there is no guideline on this. There is no guideline on this. At least they have not shown, subject to what they'll submit today. As of now, they have not produced any guideline before the court. Therefore, the fact remains, number one, I had made attempts to put in my bid within time. Number two, I had approached their help desk within time. Number three, the help desk did not advise me because they had accessed my computer remotely. They also could not solve the problem. And number four is this shift of stand from the 28th May till the last affidavit which has been filed last week.
It is an oscillating stand.
Every time the shift of stand, and kindly have a look to the order sheet where I had completed my submission. Thereafter, this affidavit comes. After knowing my stand. But I said so, at paragraph 3 of this rejoinder.
Because you could have been sent the mail to before the 2 p.m. but you have sent.
But my first mail is at 206. But it takes some time to at least.
So that's why they are taking the because of the time you approach the help desk after the time period.
That is the case.
That is the case.
But this 105 and 124 is before your lordship.
Correct.
Therefore, help desk was accessed by my client This is as per their affidavit. 108 and 124. But paragraph D, subparagraph D.
Yes. Submitted by yes.
No, but I'll not trouble your lordship anymore on facts. Now, my lord, what is the my lord, legal position, my lord, that your lordships have settled? Where your lordship have settled that, my lord, the tender process, my lord, the only right that I have is a right to submit my bid,
Right of participation.
a right of level playing field, and a right of fair my lord, consideration of my tender. This is the right. I do not have a right to back the.
Now, at this stage, what order you expect from this court?
But the only
Because the bidding process is so,
Yes.
financial bid is open.
No. Financial bid has not been opened. Your lordship had permitted them to analyze the technical bids.
But they have not identified who is the fine. The commercial.
No, that has not been identified. They had only processed the techno-commercial bid. Now, in this situation, 2 or 3 judgments, I'll just show what the courts have held. But my fundamental argument is that whether glitches, problems in the system, deficiency on my part also, take the highest case against me. But whether it can infringe
If one
or impinge upon my fundamental rights.
if at 1.08 and 1.24.
Yes.
1.24, what you have faced the problem? Because kindly see the D. Report of the respondent number 416 in the present case, the petition was logged out the system as it failed to complete
the mandatory
stage of the bidding process as is evident from the video recording submitted by the petitioner to the help desk. So you failed to complete the mandatory stage.
Yes, I could not complete the process. But after the OTP verification is when I will upload the documents. After the OTP verification is done, I am being sent back to the
So you have given the OTP verification has been done.
That is what you are.
Whether verification is done or you are not given the OTP.
It is given. That is the evidence that they have given. But at 1353, the OTP was placed. But kindly permit Mr. Dr. He can to go over there and show it to your lordship. Because the OTP is put. After OTP verification, I am to upload the document. What is the problem that I was facing is after the OTP verification, I have been put back to stage 1.
No, because if once the OTP is accepted, then you have to proceed.
Right.
Correct. No, after the you entered this OTP you entered. Correct. What is the OTP? Okay. Correct.
This is the problem.
But you mentioned in the OTP, you have placed the OTP. You are not given this. In the reply you are given. Which paragraph? Yes.
জানতে চাইছে আমাদের পিটিশনের রিকোয়ারমেন্ট যে আমরা ওটিপিটা দিয়েছি তারপরে রিডাইরেক্ট করে দিয়েছে পিটিশনের।
আচ্ছা। May your lordship may kindly take paragraph 8, if your lordship may kindly take paragraph 8 of my writ petition.
Paragraph
8.
Yes.
Well, of the writ petition, not the report. But this is my first stand, earliest stand before this court.
Yes.
On 28th May, the petitioner attempted to submit its techno-commercial bid in respect of the tender from 12:30 p.m. up to the respective closing time of the bid submission for the said tender. However, during every attempt to complete the final stage of bid submission, the GM portal encountered a critical technical malfunction. Upon OTP verification at the final submission stage, the GM portal automatically logged out the user session and redirected the petitioner number 1 to the login page. Without completing the bid submission, no error message, etc.
Also my 28th May representation.
But I have not, Millard, shifted stand. But this is, Millard, this is corroborated by, Millard, the electronic evidence that they have placed before your lordship. Millard, the electronic evidence which we are showing is what, Millard, they have given by way of a, Millard, pen drive. Now, Millard, kindly see, Millard, my first, Millard, letter, which is at 952 at page 361. Same. On the same day, Millard, what I have said.
Yes.
Please take me the second paragraph. Or I'll read me from the first paragraph. With due respect, we wish to submit that our organization was attempting to submit the above mentioned bids today from so and so up to the respective closing time of the bid submission. However, during every attempt to complete the final stage of bid submission, the GM portal encountered a critical technical malfunction. Specifically, upon OTP verification at the final submission stage, the portal automatically logged out the user session and redirected us to the login page without completing the bid submission process. No error message, validation prompt, or submission of confirmation was displayed by the system. Now, the saving issue comes later on. Then we're skipping over one paragraph. Please take the fourth paragraph. We immediately reported the issue to the GM, help desk, as well as to the concerned authorities. Screen recordings, etc., evidencing the issue has been preserved and are enclosed. It is pertinent to mention that the GM help desk remotely accessed our system through any desk for troubleshooting purposes and themselves attempted bid submission multiple times. However, even the GM representatives encountered the identical issue.
Yes.
But these are all contemporaneous, same day. Now, Millard, I have taken a lot of your lordship's time, Millard, on this matter, Millard. 2 or 3 judgments, Millard, and Millard, I'll.
Which judgment you are?
Yes. Millard, Millard. Please take, Millard, there is one judgment, Millard, of Bombay High Court, Nalanda Bahudeshiya. But I believe Millard, it was handed up on the last occasion, Tano Lata Day. There is one judgment, Millard. But please have a look at this judgment first. But please have a look at this judgment, Millard. This is Bombay High Court. But this is like our case, Millard, where, Millard, the help desk could not, Millard, solve the issue. Please take, Millard, paragraph number 5. With the page number, paragraph 5 at page 5. My page numbers are at the bottom, Millard, right hand side. Mr. Nitin Thakkar, learned senior advocate, submitted that all the tenders are non-competitive and non-commercial in nature and are only for technical evaluation of institutes seeking empanelment for providing coaching for the competitive examinations to the targeted groups, that is so and so. The tender provides for empanelment contract for a period of 3 years, which include multiple batches. In WP number so and so, the petitioners were prevented from submitting their bids before the deadline on 3rd July, 5 p.m. due to error, namely Java heap space on the Mahatender website portal, which the support staff also could not resolve. But this is my case. Even after taking access of the petitioner's computer. Therefore, the petitioners in both the writ petitions submitted their bid documents by email. The petitioners seek a direction from this court against the respondents to consider their bid documents for determining their eligibility and empanelment for the upcoming examinations. This was the submission. Now, kindly take with paragraph number 12. At this stage, it is pertinent to note that the National Informatics Center in its affidavit at paragraph 4 confirmed that the petitioner had made 3 calls before the deadline and 2 calls after the deadline, and also provided transcripts of the conversation between the petitioner and the help desk. The transcription of the confirmation confirms that the petitioner computer was accessed by any desk application. However, the help desk was unable to resolve the issue. Then kindly take me to paragraph number 16. This court video order, actually, we can skip over paragraph 16, that was a direction. Now kindly come to Millard, paragraph number 23. This is a case where the petitioners were doing its best to upload the document but could not anticipate the possible technical hurdles. This is also my case.
During the submission process.
That is during the submission process. Now, finally, Millard, kindly see what is the relief granted. Para 28. For the reasons above stated, writ petition deserves to be allowed and is accordingly allowed, the petitioner having paid the requisite EMD and process amount. The respondents are directed to accept the documents of the petitioner by granting an opportunity to the petitioner to submit the remaining documents and due compliance under e-tender notice within a period of 1 week from the date of receipt of this order, so as to consider the petitioner's bid for evaluation. Now, this is what I am praying.
Yes.
This is number 1. But the other one is, Millard, your lordship may kindly take Millard 2022 SCC Online Bombay 11778.
Yes.
Broadcast. Please take me paragraph 12. Having heard rival contentions, we observe that although petitioner uploaded packet A documents on the portal of the respondent on 17th May, the same is also disputed by the respondent corporation. At the time of uploading packet B, the portal showed error and no documents were uploaded. On 18th May, an error with the remarks "no user certificate available" was shown, and the petitioner communicated its grievance to the respondent on 18th May, 19th May, 20th May. We also observe that the respondent corporation has not cared to respond to the request made to the help center on 18th May as well as to the email dated so and so. Nor has the grievance committee taken any step in response to the petitioner's communication of 20th May. Pursuant to clause 8, I skip over that. Please take over the next page. Next page, the second line. Although respondent does appear to have a record of the attempt made by the petitioner to upload packet A, but submits that since the relevant columns indicate current version and read as blank, the bid cannot be considered. We're pausing here for a moment in my case also, where the electronic evidence shows that, Millard, there are record with the GM personnel that Millard I have made endeavors. Then please take away the next paragraph, that is paragraph 13. This is not a case where the respondent corporation has established that the glitch was from the petitioner's end, and it was due to petitioner's system problem, internet problem, user ID, locking, etc. In fact, as can be seen from the submissions, that the petitioner was well within the scheduled time, communicated its grievance to the respondent, but without any response or resolution. The respondent corporation has informed us that the financial bids which were to be opened at 4 p.m. today has not yet been opened. We are therefore of the view that it would be the interest of justice to allow the petitioner to participate in the tender process, as no prejudice would be caused to any of the other bidders and would only increase competition for better achievement of the project objective for universal education. And finally, at paragraph 15, the directions are.
Last judgment of English for traders. Delhi High Court Division Bench.
Therefore, my participation will not affect anybody else. And the final one, Millard, your lordship may kindly take me, Vishwa Traders.
Paragraph 10.
But this is Delhi High Court's view, Millard. But please take me to paragraph 10, 11 and 12.
জেমের প্রিভিয়াস টাইম ছিল তোমার কি ডিসপিউটটা রিজলভ করে দিয়েছি, এখন পুরো উল্টো স্ট্যান্ড আছে, ওগুলো রেখে দিয়েছি শিফট অফ স্ট্যান্ড।
We have heard the learned councils and considered their respective submission. GM portal has been developed for the government to migrate to a completely transparent online bidding process with minimal human intervention. Adoption of technology is always preferred since its purpose is to increase efficiency, ease of doing any work, and also to reduce inefficiency and corruption which may result on account of greater human intervention. At the same time, it would be of no use if the technology as deployed has such inbuilt limitations and lacks flexibility to deal with exceptional situations. It would give no solace to the petitioner to be told that the problem faced by it in respect of the tender in question is very rare. In most cases, the GM portal is able to deliver the goods efficiently. In our view, the portal developed by GM should have the flexibility to deal with such like situation where it should be possible to override the system with the express permission of the highest ranking authority and under adequate supervision, so that persons who may have been left out of the bidding process for no fault of theirs due to technical glitch in the system are able to participate. We are also we may also observe time and again we are informed that in cases where technical disqualification of bidders is held to be bad by this court, the GM portal does not have the facility to open their financial bids in case the financial bids of the other qualified bids are already closed.
Yes.
This again demonstrate lack of proper programming and anticipation of on the part of the respondent. Para 13 Millard is the clincher, very important. The fundamental rights of citizens cannot be sacrificed only because the system developed by the respondent number 1 has such limitations. It is for respondent number 1 to deal with such limitation. You can't point fingers at me. But I can understand they say that I did not enter into the system and I am trying to make out a false case XYZ. Now kindly take me para 14, 2 more paragraphs. In response to our query, it is not denied that the petitioner's bid are accepted even now manually. I'm sorry, if the petitioner's bid are accepted even now manually, it would still be possible to process the tender in question and to award the contract to the technically lowest bidder. Since only the technical bids have been opened and there is still no comparative evaluation of the bidders in respect of the financial bids, we see no impediment for the respondent being directed to accept the manual bid of the petitioner even at this stage. The evaluation of the technical bid involves only the examination of the technical qualification of the bidder with the technical evaluation committee of the respondent number 2, which has already evaluated other technical bids, would undertake. In view of the above, we allow the petitioners permitted to submit its bid. But this is my prayer from day one, that you please accept my bid manually and consider with the other bidders. But here, Milord, your Lordship was pleased to protect us. Your Lordship was pleased to protect us, Milord, by directing Milord the ECL not to Milord open the technical bids. Subsequently, Milord, there has been a modification. Your Lordship was pleased to direct them to allow them to evaluate them, but not to declare the results. Now, what is very important is whether, please consider one thing. Let us presume for argument's sake that I had committed some error. Whatever they are saying is correct. Take everything, Milord, as they say. Then also, Milord, these are, Milord, in my very respectful submission, insufficient to, Milord, impinge upon my fundamental right. My fundamental right is a fair consideration and a participation. Let that be, Milord, allowed. Milord, this could have been solved as I was saying. Except it manually.
James will answer the answerable respondent. We are nothing wrong.
My lord, I appear for respondent number 4, Jem. My lord, I am there for Jem.
Online.
Yes. My lord, so with great respect, if we have a look at para 8 of the rejoinder, which is at page 4 of the rejoinder, there is actually no shift in stand of Jem at all. My lord, firstly, as was also pointed out by your lordship, the bid closed in writ petition 12340 at 2 p.m. And it is also the petitioner's case that he first raised a grievance at 2:06 p.m. To the help desk after the bid had closed. Similarly, in the other petition, my lord, at 12345, the petitioner started trying to submit its bid from 12:30 p.m. But eventually the bid closed at 3 p.m. and it is his case that he started raising a complaint on the help desk after 3 p.m. So my lord, with that perspective, if we look at para 8.
Now, what about answer to the para D of the rejoinder?
My lord, para D, if we see para D, it reads in the present case.
You are telling that
my lord, para D says that as is evident from the video recording, between 1:08 and 1:24, my lord, that's 1 minute 8 seconds and 1 minute 24 seconds of the video. It appears that an impression was meant. This is the timestamp of the video. The impression that was conveyed that this issue was raised at between 1:08 and 1:24 is not correct. When the video recording was also played for your lordship, the time that was shown was 1:53, which was 8 minutes before closure of the bid. So, my lord, the 1:08 and 1:24 referred here is the timestamp of the video recording that was shared by that we have filed along with the petition. So, it is nobody's case that before 2 p.m. they contacted help desk. My lord, in that perspective, the first email that was sent by the 28 May 26, page 358 of the writ petition. My lord, that was at 2:12 p.m.
Now you are making it a new case. Whatever the last several days, JAM authority advocates.
My lord, I will explain. My lord, I will explain. According to me, there is no new case.
This court will not allow this case, sir. Changing of the advocate is not allowed to change the case. The JAM advocate who had appeared before this court, he had made other submission, which is in my records. Now you are making a new case, then you have to suffer.
My lord, with great respect.
This court is the last court who will allow the advocate.
My lord, my lord, the advocate that is there, he can appear if that is an issue. Mr. Ayan Podar is in court, he can appear. But my lord, with great respect, we are not changing our case.
Changing the advocate will not change the case.
My lord, with great respect, the case that we are trying to convey is that, my lord, on the first date, on 28th May, we simply told the petitioner that our service expert will reach out shortly. And my lord, after that, we just, our consistent stance since the beginning is that the bid had already ended. My lord, apologies. With great respect, I'm not making if I made any submission that is in contradiction to the previous lawyers, my lord may take it. But my lord may just take that after that, at least when it came to the submission of the help desk on the first 2 dates, my lord may see that the stand was consistent that the bid had already ended. That is why the help desk was not able to.
That's correct. That is admitted with regard to 206 they have made. It is but what about in between the 230 onward after they have made the request and you tell that your authorities tell that you have it shortly. What is the meaning of that?
My lord, I will explain. So the first email dated 28 May 26, which is mentioned at para 8A, my lord may see. My lord, 2:06 p.m. the request is made. Within 6 minutes, there is an automatic response from the help desk.
You come to 358, page number 358.
My lord.
It is your mail.
That's right, my lord.
Correct. Come to the third paragraph.
Just a second. My lord, they will come back shortly is an automated request from the help desk, because there are almost 5,000 bids every day in the GEM ecosystem. So that is the first reaction after a bid is sent. My lord, within another 13 minutes.
That's why if the petitioner has made a complaint to you during that period and you stated that your person will reach to the petitioner, correct? You have not reached. In the meantime, the time period is over to then they have made a representation. And they, you have created, you have given the OTP, they have, OTP has also been generated. Thereafter, the system is not taking. Whose fault is that?
My lord,
Your contention is that he failed to save the document and upload the same. Where is that? Where is that?
My lord, so the video demonstration that was, my lord, one thing I want to clarify, that the request was made after 2 p.m. My lord, at
Again and again, you're telling a request. I am asking when the petition during the period has requested, you accepted that your person will reach. So how you can again and again telling that after the period they have approached you? What about I am asking the clarification from you between the tender period, petitioner has informed you with regard to they are facing trouble, and you have response to that, and your person will reach to the petitioner, and your petition has not reached till 2. Then they have made the request to you.
My lord, you may have a look at 3 emails. And firstly, the petitioner's request, which was raised at 2:06 p.m., which is mentioned in mentioned at page 352. My lord, at para 352 of the writ petition, on the right top,
Yes, where is the advocate who is appearing here every day? Where is he?
I believe he's in another court. But my lord, I can easily assist your lordship.
The respondent authorities have failed to submit the matter. The interim order is
My lord,
till 10th of September 2020. Let the matter appear on 10th September 2020.
my lord, I'm just making a request.
So what can be done?
I apologize, my lord.
You are telling that you have no submission, and the GEM authority changing the idea every time.
My apologies, my lord.
The advocate who is appearing and telling you the clarification here coming again and again, 2 p.m. communication. Call the matter.
This is my application, Malad. Let me just point out, Malad. Here, the petitioner is a director of several companies, Malad.
Yes.
Malad, being a director, Malad, since he's a director of many companies, Malad, suddenly in the end of 2025, I come to learn that while I was trying to upload Malad documents for other companies, I come to learn that I have been disqualified. The dean has been disqualified, and Malad, the dean has been deactivated. Malad, these two provisions are not there in the companies. I'll show that, Malad. Just giving a short background. Now, the reason is, Malad, under 164(2)(b) of the Act, Malad, where, Malad, they say that if I have taken some loan, if I had not repaid back, Malad, then my dean can be cancelled. There was nothing of this sort. But the main point is, Malad, no notice given, no hearing given. It's just got cancelled. I write to them. They do not take any steps. I also write to them that there might be some managerial disputes between two brothers in the company, but that is not under 164(2)(b). It is not under 164(2)(b). But Malad, they do nothing. Now what has happened, Malad, obviously since my dean gets cancelled, all other companies, Malad, it's come to a standstill now, Malad. So therefore I've come before your lordship.
Why are you not going to the tribunal?
Well, a tribunal doesn't have the jurisdiction for this.
Why?
But because tribunal's jurisdiction, with humility, I say, Malad, is all under, Malad, operation mismanagement 58-59. 430, Malad, your lordship's judgment is there, Malad, which says it's not a complete bar. But I had the occasion of arguing. So I can't go there, Malad. And here the main point is, Malad, no notice given to me, absolute violation of natural justice, Malad. I could have explained it to them. Malad, kindly see the document once.
Provision of the Companies Act to disqualify maintenance.
Malad, first kindly takes page 73. And a report was also called for as far as I remember last time. Malad, page 73, Malad, this is my DIN status. Kindly see the bottom of that page, Malad. Right bottom. 3. DIN status. Disqualified under section 164 2B. Now, Malad, kindly comes to the section, Malad.
How many directors are there?
One.
Petition.
Malad, I am a director in several companies. So, Malad, there are several companies, Malad, where I am a director and others are directors, Malad. And Malad, I have been able to identify that there could be a concern with one company where, Malad, there is a problem with filing of the annual returns because of disputes between the two branches. But that is not here because, Malad, kindly see 164 2B first, Malad. I'll just start from 164 to no person who is or has been a director of a company which, now takes B, has failed to repay the deposits accepted by it or pay interest thereon or to redeem any debentures on the due dates or pay interest due thereupon or to pay any dividend declared, and such failure to pay or redeem continues for 1 year or more. Now kindly see, shall be eligible to be reappointed as a director of that company or appointed in other company for a period of 5 years from the date on which the said company fails to do so. So, Malad, the provision is that even if it is 164 2B, Malad, I will not be allowed to be reappointed or be,
has failed to repay deposits, so and so shall be eligible to be reappointed as director of the company or appointed in other company for a period of 5 years from the date which the said company fails to do so.
Malad, yes. Malad, first of all, I have not, 164 2B, I have not taken any such loan. It's not applicable to me. But other than that, but I don't want to repeat my submissions, kindly sees what is the penalty. First sees that. Shall be eligible, as in it shall not be eligible because no person shall be eligible to be reappointed as a director of that company. One, or appointed in other company for a period of 5 years from the date on which the said company fails to do so. Malad, there is no provision here for suspension of DIN.
Yes.
No provision. Now, Malad, why I say this, Malad, kindly sees, Malad, the DIN can be suspended or, Malad, can be, Malad, rules. Malad, kindly has a look at the rules, Malad. Malad, just give me a moment, Malad. Okay.
Which rules?
Yes. Malad, this is the company's appointment of director rules 2014.
Appointment of directors.
Yes, Malad. Kindly sees, Malad, rule 11, Malad.
First.
Malad, may I assist your lordship? I will assist your lordship. I'm very sorry, Malad, because, Malad, it's raining, so, Malad, book is in the car, Malad. এটা কি আমার বই দেখতো একই না আমি একটু দেখবো একবার চট করে বুঝলি এখনো সিনিয়র লাগে দেখলি Malad, kindly. Sometimes seniors are still required, Malad. Malad, kindly sees. cancellation or surrender or deactivation of DIN. So, this is the only provision which talks about this. The central government or regional director or any officer authorized by the regional government may, upon being satisfied on verification of particulars or documentary proof attached with the application received from any person, cancel or deactivate the DIN in case DIN is found to be duplicate. It's not the case. DIN was obtained in a wrongful manner. Not the case. Of the death of the concerned individual. Not the case. Concerned has been declared as a person of unsound mind. No, my lord, I'm still sound. My lord, if the concerned individual has been adjudicated.
Have you disclosed the certificate?
My lord, that is what I was saying, my lord. My lord, I would love to, my lord. So, my lord, if the concerned individual has been adjudicated insolvent, provided that before cancellation deactivation of DIN pursuant to clause B, an opportunity of being heard shall be given to the concerned individual. So if it's a cancellation or deactivation, I was needed to be heard. There was no hearing given, my lord. I had given several letters. There was no hearing given. Now, my lord, the problem is, my lord.
What is the date of this disqualification?
My lord, no date given. This I have found, my lord, I pleaded, my lord. As a matter of fact, just give me a moment.
MCA website?
Yes, from the website, my lord. My lord, while I was trying to put up other, my lord, necessary, my lord, annual returns for other companies, suddenly I was prevented because obviously my DIN has been stopped, my lord. And I have stated that in paragraph 21, my lord, around December 2025, I've come to learn about this. After that, I've written them several letters. One will kindly see my letters. My lord, 76 onwards, all letters given. And as a matter of fact, I have also not kept anything away from them, my lord. I said that yes, there might be a problem with filing of a return, but that is not under 164 1B. My lord, kindly 2B. My lord, kindly sees 164 2A for once, my lord.
Yes, who is you are appearing?
Your lordship.
Yes.
I'm for all that.
But I'm also covered by a judgment. If your lordship wants, I can give that for completeness, my lord. My lord, this is, my lord. একটু নেবেন একটু একটা বেটার কিছু নেই আমার তো ডাক দাও
2021 224 company.
Yes.
এটা দেবাংশু বসাক দেবাংশু বসাক নয় সব্যসাচী মানে দিচ্ছি ওনাকে একটা দাও মানে কাইন্ডলি সি Yes, Judge, পেয়ে গেছে মানে কাইন্ডলি সি that straight away take your lordship kindly sees 235.
Yes.
From 16 mallet.
Yes.
It's not the right mallet. Upon considering the arguments of both sides and legal provisions question evident that the opinion of a division bench of the Allahabad High Court, as well as learned single judge of this court, in the 4 judges side by the petitioner, disqualified DIN of a director for the default of a particular company, of which the director cannot disqualify the said director from acting in the said capacity in the other companies which did not allegedly commit default. As such, in any event, the disqualified DIN of the petitioners could not operate with the other companies and the defaulting companies. In the event of a DIN of a director to be deactivated, not merely the name of the company struck out from the register, the said person has to be given notice individually and heard and given an opportunity to establish he was not liable for the alleged default committed by the company. But I was never given this, Malad.
Yes.
Malad, this was my submission. I don't know whether they can show that I was given a notice and hearing was given. And Malad, once paragraph 19, Malad, if you touch kindly sees, Malad. Sorry.
18 in absence of such provision of the activation of 18 next.
Malad, last page, Malad. At page 236, in the middle, Malad, is the absence of any such provision of deactivation of DIN in the 2013 Act. Malad has got that, Malad?
Yes, yes, yes.
Malad, that is what I was providing, I was showing from 164, Malad. The mere disqualification of the 164 2A of a company cannot give rise to consequences of deactivating the DIN. Malad, so the same provision is for 164 2B, Malad.
Yes.
There is no provision. That is what I wanted to show your lordship, Malad. Malad, whatever they submit, I'll try and give a reply.
Yes.
Your lordship. Firstly, your lordship has said that they haven't filed the necessary documents for consecutive 3 years or 5 years. They haven't filed their necessary documents to the ROC for consecutively 5 years. And they actually submitted their case under section 164(2)B.
Yes.
But it's a mistake, Your Lordship, because the Register of Companies West Bengal has recommended the disqualification of the petitioner under section 164(2)A. And I'll show to Your Lordship what 164(2)A.
Yes.
164(2)A, Your Lordship. Has not.
Yes.
Has not filed financial statements or annual returns for any continuous period of 3 financial years. They haven't done that as a director of the Saffron. Saffron Trading Private Limited.
Correct.
And for that reason, Your Lordship, no notice is required because this happens by operation of law. And if some rights is extinguished or rights is accrued by operation of law, notice is not required, Your Lordship. The principle of audi alteram partem doesn't apply in such cases. And I'll also show to Your Lordship 167. 167. 1. 1A.
Section.
Section.
167.
1A, Your Lordship.
That's the provision.
He incurs any of the disqualifications specified in section 164.
Yes.
Provided that where he incurs disqualification under subsection 2 of section 164, the office of the director shall become vacant in all the companies other than the company which is in default under that subsection.
Same.
So it is, my lord, my simple submission is that notice is not required.
But your disqualification is with regard to 64(2)B.
No, Your Lordship, it's a mistake, typographical mistake. I am technical mistake, Your Lordship. It's a technical mistake.
And come to the 63, 70, page 73.
Page 70, it's written there, Your Lordship.
Yes.
Technical error, we can rectify that. I am instructed accordingly.
So when it was uploaded? When it was uploaded?
2020.
After it was uploaded after they were disqualified. After they are disqualified.
Correct. When date? Which date? You are telling that it's a technical. You have technical. Now they have taken the benefit of this. They have taken this because so 164(2)B is a different thing, and now you are taking the 64A. If the 64A, so how the court can assume it 164A, not 164(2)B? How this court can assume?
Yes, I understand that, Your Lordship. But the date is the fact that they have not filed the returns and the balance sheet and all the
That is
documents
different
for
thing. That is
consecutive
different thing. If I will accept your submission, okay, by mistake in the website,
No,
it
it's
has
not a
recorded.
mistake of the human.
That's why.
Yes.
That's why I'm asking the
Yeah.
date when this disqualification was done and when this was uploaded. When this was uploaded,
It was.
you have not rectified. When what?
No, Your
That's why I wanted to know from you on which date you have uploaded this.
Your Lordship, the date is not known to me.
So
I can take the instruction on that.
So if the date is 2 months, 3 months before, so why you're not corrected?
Your Lordship, this is after disqualification. After disqualification, I'll get instruction. I'll come back to Your Lordship.
Malad, I can only
the date.
Malad, may I just say this, Malad, if Your Lordship kindly permit, I'm sorry, I'm interjecting. Malad, I have taken this out in April 2026.
Correct.
So, Malad, from there also, Malad, 3 months are over.
When you receive the writ application, when you receive the writ application.
Writ application.
176.
And Malad, from page 77, Your Lordship will find I've written in December. Page 77.
76, 9 December.
76, 9 December 2025 written to them.
Yes. December 25, they have written to you, written by the petitioner to you.
Demand justice.
I'm at
But you're not-
24 June demand for justice.
But you're not taken care of it.
2 months more.
Page 156 is my demand for justice also. my lord. আপনি এটাকে withdraw করে দিন, তারপর আমাকে নোটিশ দিন, আমি আপনাকে এ করবো।
না না ও বলছে যে হিয়ারিং যা প্রভিশন
Judgment.
Yes.
Your
If
lordship.
suppose you're not, but they have given the representation, you not consider the
No,
representation.
your lordship, there is no provision under the Companies Act to consider the representation under.
No. I am not telling his representation. They have given, so you have not corrected in between, because after December they have given the representation to you. You are not corrected the 64A as a 64B to be.
No, but the disqualification date is not confirmed yet. I have to verify, your lordship.
Disqualified and not confirmed.
No, I don't know. It's not verified. I don't know. Your lordship, kindly allow me to get further instruction. I'll give all the dates necessary for this. Let the thing
And this is judgment.
প্রাইম মিনিস্টার হয়ে গেছে
অন্য কোনো অর্ডার বোধহয় কারেকশন করছে, তাড়াতাড়ি দিতে হবে বোধহয়।
Judgment to too big of a দেখে নিচ্ছি
তিনটে আছে, আদালত ডিভিশন দেখো জাজমেন্টটা কোথায়। না দাদা খুব ফেয়ার।
তাহলে কথা বলতে হবে ডিপার্টমেন্ট থেকে, যে তোর চিঠিটা দিয়েছিস, দ্যাট ইজ প্রায়ার টু ডিসকোয়ালিফিকেশন ডেট আর আফটার ডিসকোয়ালিফিকেশন। হ্যাঁ, তারপরে তো হয়ে গেল, সিস্টেমে ঢুকে গেল। দেখা 164(2) এ দাঁড়া দেখবো। দাঁড়া আস্তে আস্তে তুই পড়েছিস, আমি পড়িনি। বইয়ে
হ্যাঁ তারা আছে, ওই সকালবেলায় এটা 3 নম্বর ম্যাটারটা বোধহয়। এই তো আলাদা কমিশন একটা দেখিয়ে রাখি সব কিছু। সিঙ্গেল বেঞ্চ পছন্দ হচ্ছে না।
আমি চুপ করে যাবো একটা কথা। ভালো কথা।
$22 come. एक मिनट, नहीं
জায়গাটা বল, এত বড় গান।
জায়গাটা বল, প্যারাটা বল।
একটা পেনের দাগ।
হবে না, জলদি করকে দেনা। Yes.
Your lordship, I'll,
When you will come,
your
consider.
lordship, whenever your lordship, at least 7 days, your lordship.
No, मतलब 7 days मतलब
But your name is disqualified.
And not only that, मतलब 31st, मतलब within 31st, मतलब there is a scheme which has been framed, for which if I मतलब put in documents for other companies also, मतलब there will be penalties will not be imposed, मतलब. So मतलब that is why मतलब kindly let him do it by tomorrow, मतलब, because I'll point out मतलब that.
Come on,
20th, your lordship.
Learned counsel for the petition has argued the matter at length, full stop. The content, learned counsel for the respondents press for time to take instruction. Accordingly, cases adjourned. Let the matter appear on 20th within 5 matters.
And मतलब I'm also handing him over the division bench also for his consideration, and also मतलब I'll place that on the next occasion if required, मतलब. I'll do it the next time. Grateful, man, very grateful.
Grateful, man.
In this matter, I appear for the petitioner. Mr. Ahmed is assisting me in this matter.
Yes.
My lord, what we have done, your lordship was pleased to hear this matter for, I think, on 2 or 3 occasions. This is regarding, my lord, the introduction of online queue management system at the Indo-Bangladesh border. My lord, what we have done, my lord, the pleadings have been exchanged, and what we have done for the lordship's kind consideration and for the lordship's convenience, my lord, we have prepared a comprehensive list of dates covering, my lord, the documents in the entire pleadings, covering the repetition documents, the documents in the AO, and the also in the affidavit in reply. My lord, learned Advocate General, my lord, was appearing in this matter for the state, and the state is the main answering respondent. So, my lord, may I, yes.
With the Advocate General is coming. Only one thing, in this writ petition, they have challenged almost 7 notification of Transport Department, which is they are saying ultra-virus to the government. Well, the only point is Transport Department themselves is not a party in the whole writ petition. Very surprising.
Transport Department?
Not made a party.
Just 1 minute, my lord. Kindly give me a second, my lord.
Kindly see the.
But that we can do the leave of the court. We can add if sorry.
My lord, this is, my lord, if Mr. Roy Chaudhary takes this kind of objection when the learned Advocate General is appearing, but this is too, my lord, this is, my lord, to quote the Honorable Supreme Court, quote the expression which your lordship sometimes use, venial objection, my lord. My lord, this is too venial. My lord, state is one. State is one. We all know that. My lord, if they are ready, my lord, I can proceed. If they are not ready, my lord, that's a different thing.
No, Transport Department is made a party. Man, we issued all the notifications and they challenged before this court.
That means, my lord, Mr. Roy Chaudhary is representing Transport Department.
No.
He used the expression we.
No, he's telling that he is of the view that if you made a specific department, then he will be benefited.
He will be benefited. That I can do. That we will do, my lord. That obviously, my lord. My lord, that I appreciate, my lord. This is for, my lord. This is for the bar, my lord. We are united that way.
Mr. Mojumdar doing fully well because he once upon a time appeared for the state. Well, the question is all the notification issued by the Transport Department.
Okay, made the transport issue notice.
Yes,
then they automatically.
What the services required since
My lord, may I just humbly submit, my lord, subject to lordship's kind consideration. The matter is pending for quite some time before lordship, and we are troubling our lordship for quite some time.
Correct.
A fixed date and time may be given, my lord, so that we can conclude the matter. Other technical aspects, my lord, we will take care of in the meantime, my lord.
Waiting for the state submits that. though the petitioners have challenged several notifications issued by the Transport Department, but the Transport Department has not made party in the present writ application. Writ application. Considering the above, the petition is directed to implement the Transport Department of the Government of West Bengal as party to the, as respondent number.
Well, it will be the last respondent.
Number 13.
13, monthly.
In course of the day, and to serve notice upon the added respondent.
Land advocate representing the matter.
He will accept.
Malad, Mr. Roy Chaudhary is appearing. Malad, we can serve a copy.
To the state. The land advocate appearing for the state. Within a week from date. Full stop.
In case of need, we can file an affidavit also.
File affidavit.
Malad, the state has filed an extensive affidavit
State was filed.
in this matter.
Affidavit is there. Affidavit, affidavit in opposition is there.
Yes.
11, 12.
Dealing with all notifications.
11,
Dealing
12,
with all notifications.
11, 12, all are filed. All are filed, all filed.
Yes, madam.
Full stop.
Yes,
This is the matter. 24 September at 12 noon.
Grateful, my
Grateful,
lord.
grateful, my lord. Grateful. May I take your lordship's kind leave, my lord?
Yes, thank you. Today you do that. Yes.
8 and 9.
Next.
I am for the petitioner. My lord, in this matter, my lord, my mother gifted property in my name by dint of a gift deed.
Mother
Gift deed
gifted
is-
property to?
In my name, in my favor.
Who are you?
I am the son, only child.
Correct.
Now, my lord, that gift deed was registered.
But only son and gift has been made.
Yes, yes.
Okay.
Deed was properly registered and stamped. Now, what happened, my lord? Some mistakes was there in the deed. Now, I filed a rectification deed, and what happened? The rectification deed is revalued. The property was revalued, and they have taken the full stamp duty which they have taken earlier. That is the grievance. The
What is the ratification?
I'm
Area.
area
of the land.
area. Kindly see, I have applied for refund. Now the order of impugn, my lord, kindly come page 65, annexure P7.
No, ratification for what?
Boundary.
Boundary.
Yes.
Not area of the land.
No, not that.
Area is same.
It's same.
Is it as the
So,
origin?
Yes, it is KMC property. Premises is same, area is same.
Area is same. Only the
boundary. Only the boundary.
in the schedule.
Yes, yes, yes.
Okay. Then where is the rejection?
Rejection, kindly see page 65, annexure P7. Second paragraph. The deed of rectification, it's the boundary of donated property was significantly altered. Their allegation. And name of Mauja was changed in rectified document to Godsa from Gorfa. The deed of declaration was executed by Doni as the donor died before the execution of the said deed of declaration. Plan attached with the deed, next page, my lord, page 66. My lord, may I read, my lord? Plan attached with the deed of rectification come declaration is appeared to be showing different picture than the decline then that of delineated in the earlier plan attached with the earlier instrument being such and such. This is the only thing they have found, and they are saying matter should be revalued and valuation of the market value has been increased.
Yes. Who is appearing for the state?
But I shall appear. Though I am not assigned, but I have assigned it. Any
This is
unattended.
my affidavit service, affidavit service. Kindly see the earlier valuation receipt. That is page 27. 27. আপনারা কি পাননি একদম?
ये तो काट दिया था, इसको क्यों किया? ये तो काट दिया था ना, ठीक कैसे नीचे
এটা 8.
Yes.
But
You are appearing.
The copy, but I have instructions if the matter remain unattended, then to appear in that case. And
There is the affidavit of service. Received, delivered.
Yes.
Delivered.
My lord may keep it.
Give the copy.
If you give a copy to.
I'll hand over.
Learned counsel for the petition has filed affidavit of service. Let us semi-cut with the room. Learned counsel for the state submitted that they have not received the copy of the writ application and the document. The petition is directed to serve the copy of the writ application or the document to the learned advocate appearing for the state in course of the day. Counsel for the respondents prays for time to take instruction. Accordingly, case is adjourned. Let the matter appear on 27th August.
My lord.
My lord, I'm grateful.
Grateful, man. Grateful.
Next.
Copy the mail.
Decision Davis.
My lord, direction was that.
Which was the petition?
My lord, I am for the petition. I am for respondent.
Yes, what is the matter?
Well, this is the matter, my lord, where my termination page 27, if your lordship kindly have a look.
Yes.
Well, today I have just served in court.
You want to file reply?
Yes, yes.
Recorded. The respondents have filed reply affidavit in opposition after serving the copy to the learned counsel for the petition. Petitioner prays for time to file affidavit in reply to the affidavit in opposition. Let affidavit in opposition reply be filed within 2 weeks. List the matter on 15th September. Next.
Well, this is an subject to correction, well, an incomplete petition, my lord. There is no backseat, nothing sorts of that.
Which one?
My lord, just earlier, item number 9. My lord, there is until blank.
You?
Let him file a survey fresh copy.
That's a good copy. What do you serve? You copy?
আরে আমি এটা না পেলে আমার তো অসুবিধা হবে না।
Yes. Which was the petitioner?
Except the exit. Everything is.
Okay, see. You compare from here. Yes. Which was the petitioner?
My lord, I am for the petition. My lord, on the last occasion, my lord was pleased to direct service upon the learned ASG, my lord.
Yes.
I have served.
Who is appearing?
They are appearing also, my lord.
Yes, what is the matter?
My lord, this matter, my lord, a service association of the postal department, my lord, their divisional conference, where election of their divisional committee was supposed to take place was withheld, my lord. Just 2 days before the conference was supposed to held, my lord. The order impugned, my lord, is at page 17.
Who are you?
My lord, I am a general member of the union.
General member
of that particular association, my lord.
You are the one of the member of the particular association.
Yes, my lord. And my prayer is just to just that the conference may be held and the election may go through, so that the body is elected.
How you are being affected if the association is not affected? How you are affected if the association has not challenged that order?
Yes, my lord.
The association has given an authorization to you.
My lord, I am a part of the association.
Maybe.
And the association furthers my cause, my lord, with the department.
Correct.
And that is how I am affected, my lord.
Correct. Where is the impugned order?
My lord, at page 17, my lord.
17.
17. The conference was supposed to be held on the 24th. And this order, my lord, on the 21st, withholding the entire conference.
So it was given to whom? Assistant Director Postal 1?
Yes, my lord.
Not to you.
Yes.
Grant a permission to hold. Who has asked for the permission?
My lord, the association has asked for the permission.
Then how the single petitioner member can file the writ petition without the authorization of the association or association without the association here?
My lord,
Association has not filed this writ petition.
association has not filed, but,
association has not
being a member, my lord, I have a right in the
You
constitution.
have a
of the
right.
body.
If you are right, but who will appear in the conference? Member of the association?
Members of the association.
Not
even my
it
lord,
is
I
not your case that you are not the member of an association, and because of the order, you are not to be able to appear in
no,
the
and may I put it this way also, my lord? My aspiration of becoming a member of this particular divisional committee, that is also being affected. If the election is not being held, my lord, that is also being affected. So that is how, my lord, I am affected. One is my cause is not being furthered.
What is your answer?
So kindly come to page 17.
Yes.
Tenure of this divisional committee expired on 16 December 2025.
Yes.
Thereafter, another.
That's why the single member has come here.
And
That's why the single member.
the tenure and extension of 3 months was given. Fellowship, as per the rules, this entire proceeding of this press election has to be conducted within the tenure or within the extended part. Now, Lordship, kindly see when they first gave their letter for holding the conference. It's in page 13. Letter dated 16th March, they want the conference to be, divisional conference to be held on 24th May. Whereas the grace period expires on 16th March.
So the person has, the association has to nominate some persons to attend the conference. Kindly come to the page 17.
Yes, madam.
Your association has nominated one Brijesh Vishwajit Karmuko.
Yes, Vishwajit Karmuko.
Correct. As divisional convener. ঠিক আছে তো?
Yes.
अभी जल्दी उसको कर लो, upload कर. Yes.
Yes, my lord, in the said order, may I place, my lord, paragraph number 5. Since the divisional committee.
Now, kindly come to read 4.
Yes, my lord.
Further, the appointment of Sri Biswajit Karmakar as divisional convener by the circle secretary BP Sunso has been examined and found to be untenable. Kolkata regional office intimated that Karmakar was expelled by the office bearers and primary membership was withdrawn. Then, since the divisional committee remained valid, but the withdrawal of the membership during the period holds relevance and valid. So, the association who has given the name of Mr. Karmakar, he has been expelled.
Yes. So this, my lord Vishwajit Karmakar, my lord, who was appointed as the convener, his appointment was not accepted by the department.
Correct.
I am not challenging that.
Correct.
My contention is only that the election may be held. Now, the tenure of the committee has expired. That is a fact, my lord. But that does not mean that the entire.
Who will conduct the election?
My lord, unless the department gives the permission, we cannot convene. Even, my lord, I will say that we the members, my lord, have paid the delegate fees also. We are all ready to convene this conference, my lord. But unless and until the departmental permission is given, and an observer is appointed by the department, my lord, we won't be able to hold the conference.
This is something else which you have challenged. Page 17 is something else which is not affected. You are right. Your assessor has given one name, he has already been ousted from the committee. So the authority have considered that with regard to your election, where is your application? When you have given the application to whom?
My lord, page 14, my lord.
14 what?
Page 13, my lord. The initial notice, my lord, page 13. This Imran Lashkar, my lord, he was the secretary. Now, as my lord, after 16th, he ceased to be the secretary.
Correct.
He cannot further the cause of the union, my lord.
Date he's asking for the conference on 24th May.
This is the conference.
He could have done it prior to the
Agenda at the divisional conference.
And
Appointment of observer
then again, my lord, I have given reminders also. For page 14, my lord, is the prayer for appointment of observer. Thereafter, my lord, page 15, my lord, is a reminder for appointment of observer. The association, my lord, has tried to hold a conference and the election, my lord. So only
But
the election.
kindly come to the paragraph prayer A. Prayer B. You're on only with regard to the divisional conference, nothing else.
Only the divisional conference.
How the divisional conference can be allowed unless and until you're having a elected body? Unless and until there is an elected body, who will allow you to go to the divisional conference? Whose matter you place before the conference? Unless and until there is an association. Association has to decide, yes, this point is to be raised before the conference, this point is to be raised before the conference, this point is to be raised before the conference.
My lord, precisely this is the reason why I have challenged this particular order at page 17. If this order is removed, my lord,
What
if it is set aside-
locus you are? What locus you are? You are only a member.
I'm a member.
And the person whose name has been given to be appointed as a person, to be a representative of the association, he was already been
not a representative, my lord, a convener.
Convener. He has also the committee has also taken a decision. He cannot be a member of the committee. Then he has been expelled from the office bearers of the committee. Then.
So only what is standing in the way of the conference, my lord, is this order at page 17. My lord, that is the reason why if this order is set aside, my lord, the conference can be held and the
Who are you to challenge this order? The name of Biswajit Karmakar has been given by whom? Association?
Appointed as a convener.
By the association. Yes.
By the association.
Association.
By the circle committee, my lord.
Maybe whatever it may be, by the association. And the authorities are not accepted because you have already the persons whose name has been given for as a convener. He has already been expelled from the association. So as a member, then
my lord kindly allows us to at least make a representation to the department so that the committee may be formed, my lord. Because unless and until that happens, my lord, the entire committee is dissolved. My lord, their existence is at stake, my lord.
The petitioner is one of the members. Of what association?
My lord,
Bharatiya Postal Employees Association.
Postman and MTS, my lord.
Comma, Group C, Bharatiya Postal Employees Association. What is our association name? The total name is same, 14.
No, my lord, it is Bharatiya Postal Employees Association, Postman and MTS. Postman and MTS.
MTS. ठीक है. Bharatiya Postal Employees Association, comma, Postman and MTS. Has क्या बोला? The petition.
She will kindly put East Kolkata Division.
Has filed the present date application.
East Kolkata Division.
East
Kolkata Division. Bharatiya
Kolkata region.
Postman MTS.
East Kolkata region.
East Kolkata Division.
Has filed the present date application challenging the order dated 21st of May 2026 issued by the ADPS, Office of the Chief Postmaster General, West Bengal Circle, Kolkata, wherein the appointment of Sri Biswajit Karmakar as divisional convener by the Circle Secretary, BPEA has been examined and found to be untenable on the ground that the Karmakar was expelled by the office bearers committee on 12th of March 2026 and his primary membership was withdrawn during the subsistence of then valid divisional committee. Full stop. The petitioner submitted the petitioner being a member of the association has filed the present date application. The petitioner further submit that the authorities are not appointing any observer for conducting the election of the office bearers at the divisional conference. So this court find that the petitioner has filed this writ petition in an individual capacity. The petitioner has not filed any authorization or resolution from the association that the association has authorized the petitioner to file the present date application. This court also did not find that from the impugn order dated 21st of May 2026, the petitioner will be affected anyway. If the petitioner has any grievances with regard for conducting an election of the office bearers, the petitioner along with them may make appropriate representation before the appropriate authority. But in the present case, this court did not. But in the present date application, the petitioner has not prayed for any such prayer for a direction upon the authority for appointment of observer for conducting election of the office bearers. Considering the above, this court find that the writ petition is not maintainable. According, same is dismissed. However, the dismissal of the writ petition will not prevent the petitioner from making any representation before the concerned authority for appointment of observer for conducting the election.
So the next matter is identical.
Identical, my
The
lord.
next matter is identical. Only
Just
the
the
name
un-
of the association is different.
Which one?
Item number
11, my lord.
11 is association.
Same.
My
same
lord,
matters.
only the association name is Bharatiya Postal Employees Association Group C.
East Kolkata.
Not the same hobe. Kali name Bharatiya Postal Employees Association Group C. Member of
The East Kolkata division.
East Kolkata division. Same one.
And my lord,
Also item number 13.
my lord. 13 is also similar.
Similar.
Just the association name will be different.
13 the 11, 12, 13. 10, 11, 12.
11, 13.
10, 11 and 13.
13.
In 13, the association
ভারতীয় গ্রামীণ ডাক কর্মচারী সংঘ
and also East Kolkata division.
10, 11 and 13. 13 the name is
ভারতীয় গ্রামীণ ডাক
কর্মচারী
Bharatiya Gramin Dak Karmachari Sangha, East Kolkata division. Yes.
Good.
Yes, next.
Then I beg to appear for the petition. Well, I am appealing for the respondent bank. So this is my appealing.
Affidavit in opposition, my lord.
ABL International.
All respondents.
For respondent, my lord, I am appealing. No, for bank.
Yes.
All respondents.
Yes,
The
yes,
affidavit
yes.
is all respondents.
All respondents.
Yes.
Bank is the only.
You file the reply.
Yes, yes.
Yes. What is the matter? Ready?
This is the, yes, yes.
Yes.
Lord, this is the matter wherein, my lord, I have claimed, my lord, the rent, my lord, as mentioned in the bank's letter, or my lord, the resolution dated, my lord, 4th, I'm just showing to lordship the document. আমার কপি দুটো দাও জজের কপি দুটো কই ওগুলো সরিয়ে রাখো দিয়ে এইটা বার করো হাইকোর্টটা হাইকোর্ট ব্যাস দেখুন কোনো পেজ নেই বাবা দুটো কেন আমার দুটো লর্ড জজের আমারটা কোথায় দুটো জজকে দেবো March 2024 at page 30. আমাদেরটা মানে ওর পড়াটা ওর মধ্যে আছে ঠিক আছে
Who are you?
I am the owner landlord.
You are the landlord.
Yes.
What is the case about?
Lord, the case below the bank branch is situated with my building.
Huh?
Bank branch is situated with my building.
Bank Office is in your building.
Yes, yes, yes.
Okay.
Branch office.
Branch office. Okay, then.
Lord, they have to pay the rent in terms of this letter.
Correct.
This letter was not prepared and given to the writ petitioner, my lord, in terms of the decision of the higher authority of the bank. Your lordship will kindly come to page 30, page 31. There are enhancements. Everything is mentioned here. Being the landlord, I have agreed to. And accordingly, the bank is running its business.
Correct.
My lord, the bank is not paying this amount, for which, my lord, I have claimed the amount, and I have also mentioned in the writ petition the details of the amount. My lord, your lordship kindly have a look of the paragraph 14 of my writ petition.
How the writ petition is maintainable?
Yes. My lord, the writ petition is, my lord, according to me, is maintainable. My lord, they have taken the points of, my lord, maintainability of the writ petition. Your lordship kindly have a look of their opposition. Only 2 points they have taken. I will answer all those points. Lord, they have taken this point. Lord, page 2, paragraph 4. That the dispute, not may I read?
Yes.
Page 2, paragraph 4, I. That the dispute which has arisen in the instant writ petition relates to the lease deed and in terms of the conditions executed between the writ petitioner and the landlord lessor and the respondent bank as the tenant lessee, wherein who have been in a legal relationship under a registered deed of lease since 2013. The lease deed is a purely private transaction between the respondent bank and the writ petitioner, where writ court has absolute no right to interfere, since the same lies beyond the jurisdiction of the writ court. Therefore, the writ petition is not maintainable in its present nature. This is the first point they have taken. On merits, they have said nothing. They have only merely denied and disputed. Only the first point they have taken this. Lord, here I am not come before your lordship paying for the execution of any lease deed. Here, my lord, I am come here and file the writ petition for implementation of their, my lord, approval. Or the letter by which, my lord, the bank has agreed to pay the rent to me. So, Lord, I have come before your lordship, my lord, in respect of their own, my lord, approval, or rather, my lord, the confirmation which is given by the higher authorities of the bank that yes, we will do our business at branch office of the bank and we will pay this amount. That has not been implemented till date.
If they have not implementing that, so what the writ court will do?
Yes, but writ court, my lord, I will show your lordship the judgments of this honorable court as well as of the honorable Supreme Court, whereby, my lord, it has been directed that, my lord, the 2 things are there. One is, my lord, the bank is no doubt a authority under Article 12 of the Constitution of India. This is one aspect. The second aspect is that the bank is doing its public duties towards the public. It is a public law in nature. So, my lord, bank has a legal right to pay the amount, and, my lord, the petitioner has a legal obligation or duty, my lord, to have that. The bank has the public duty to pay the amount, and the petitioner has a legal right to have that money. No, I will show that judgment because your lordship.
This is not with regard to the bank transaction. This is not with regard to the bank transaction. It is your civil dispute. You is the tenant. You wanted to increase the rent.
No, I did not want to increase the rent.
Whatever it may be, bank has given one option to you or whatever it may be, and subsequently they are not implemented. Whether the writ court can implement that you pay this amount, not this amount.
Lord, if the bank
show me which Supreme Court has stated that the
yes,
rent dispute can be done by the writ petition.
Lord, 3 judgments, my lord, instantly, my lord, I can submit before lordship. One judgment I have already annexed before your lordship. Lord, kindly see my writ petition passed by this. Then there are several judgments where, but at page 87 of my writ petition. Same point as taken by the bank.
Yes.
Lord, the portion, Lord, which is the reason to file this, to pass this judgment, Lord, your lordship kindly have a look at that. This is the judgment, Lord. But your lordship kindly come to page 98.
Page?
Page is not 98. Paragraph 28. Not made it. Page 98, paragraph 28. To answer the question whether there is an inaction, iniquitous disposition, or arbitrariness in not adhering to the duties to be discharged by the bank towards the petitioner with regard to what the parties have agreed to in the said lease deed, the court finds the answer is affirmative. The challenge raised as to the very mentality of the petition is thus to be negated. Before that, not several judgments were cited and considered. All above forms, this code is allowed this writ petition, and the writ petition so is allowed. Connected applications are disposed of. The respondent bank shall immediately pay to the petitioner on account of rent payable to the petitioner in terms of lease deed. Here, I am on the better footing. They have admitted that.
Yes.
Thereafter, this order was assailed before the Honorable Division Bench of this Honorable Court. Next page, page 100.
ওই ডিভিশন বেঞ্চটা দাও আমার করা চিফ জাস্টিসের ঘরে ঠিক আছে
This is.
I am deferring. Even division bench, I am deferring. I am sending to the larger bench.
Thereafter, I am coming, thereafter, in terms of this division bench, they have complied with the order. This judgment was passed by this Honorable Court by the Honorable Single Judge on the basis of the judgment cited by the Honorable Supreme Court, as your Lordship will find from the judgment itself. I am fully laying upon that judgments of the Honorable Supreme Court. Thereafter, today, before your Lordship, I want to cite two current decisions of this year. This is reported in AI Act 2026, Calcutta 185. This is the division bench of this Honorable Court. Here.
2026 Calcutta page
185. Division bench of this Honorable Court. This is also reported in AIR online 2026 Cal 133. This is paragraph 5, 6, 7. Your Lordship kindly have a look. এটা কত নম্বর প্যারাগ্রাফ? Page 5. কিসের? প্যারাগ্রাফ বলো। 5.
And this is with regard to the payment.
Yes.
Contract payment.
Yes.
That is settled laws. Contract payments admitted.
Yes, according to me, the document
here you wanted to implement you wanted to implement the proposal given by the bank.
No, proposal has been finalized. They have taken the possession from from me, but they are not paying in terms of that. Here, the fixation has already been done. I am not praying, before your Lordship, about the higher rent or lower rent. I am not disputing anything. Your lordship, if your lordship will go to the particular document which I have shown to your lordship at page, my lord, kindly have a look of that, my lord. At the cost of repetition, my lord, I am very sorry, my lord. Kindly see the document. Fourth merge document. Thereafter, my lord. My lord. At page 35, page 34 and 35. On the basis of that, they have taken the position.
Page 35.
Page 34.
Yes.
Page 34, they have decided.
Which paragraph?
Paragraph, our views, recommendations. Middle portion. Premises at ground floor is not available and rent demanded by the landlord is lower than prevailing market rate. As such, we endorse the recommendation of so and so as under. Renewal of lease of first floor having carpet area so and so at per square feet and annual outgoing of so and so, including 50% municipal tax, 100% surcharge and occupied portion. So for the municipal tax and surcharge, they are regularly paying. I am not claiming anything. Only the rent. Lease will be renewed for a period of 15 years, so and so. Surrender of part area of first floor measure out so and so. Rental area of 9 months amounting to so and so. For returnable carpet area so and so per square feet. Thereafter, to ensure that thereafter, they have done their own job, and they have taken the position. So, I want that this should be implemented because there is no dispute at all. Because if I agreed to accept this, then there cannot be any dispute. If I don't agree that no, 40 rupees 40, I will not take. Then disputed questions of fact will come into.
Yes.
Lord, here, my lord, I am simply submitting before your lordships that, Lord, in terms of their recommendations, in terms of their opinion, in terms of their, decision on the issue, Lord, I am praying for the admitted amounts, as I can say so. This is their absolutely, my lord, legal duty to. On merits, my lord, they are saying nothing. Only the ground of maintainability, my lord, of the writ petition. Paragraph 17 or 20. Here the only questions of that the rate they are fixed.
Yes.
Lord, according to me, Lord, your lordships can have a look at that. I am not disputing any amount. I am not saying for a single moment that I want not 40, I want 50. Then no dispute comes in. Then this cannot be decided in the jurisdiction. That's absolutely correct. Not I bow down to. No, when the bank has decided, I have accepted that, then bank has the legal duty to perform. Being the authority under Article 12, the state within the meaning of Article 12, the bank cannot deny that. This is the current judgment and the another judgment of Honorable Supreme Court that is also reported in 7th July 2026. Paragraph. Yes. No, এটা অন্য judgment. This is reported in. এটা তো রিপোর্টেড কোথাও হয়েছে জানি না এখন একদম রিসেন্টলি হয়েছে সিভিল অ্যাপিল নাম্বার সিভিল অ্যাপিল নাম্বার 8751 of 2026 decided on 7th July 2026 Ajoy Vich versus Indian Banks Association and others. Here, my lord, I am relying.
You give the judgment. Give the judgment.
Yes, I will give you. I am just bringing it. Lord, your lordship kindly have a look of the paragraph 13. Paragraph 13, 14, 15, 16. Versus people of Indian Bank. Ojibis versus Indian Bank Association.
Isn't it?
Yes.
And my lord, so far these other aspects of the matter is that, my lord, after this decision was taken by the bank authorities, my lord, we have demanded justice. My lord, the justice has been demanded. Upon that, my lord, they have also replied, but my lord, they have not stated on a single line that they are disputing the amount.
751 of
Yes.
The another point in their affidavit of opposition,
Yes. Yes, yes.
the another point in their opposition at page 3. Opposition at page 3.
Yes.
Roman 2.
Yes.
The writ petitioner has sought for payment of the arrears of rent together with the interest on delayed payment of rent in relation to a registered lease deed entered into with the respondent bank in a writ petition under Article 220 of the Constitution. A writ is an extraordinary public law remedy which is designed to correct clearing constitutional overreaches, failures of public duty, and arbitrary abuses of state power. Failure of public duty and arbitrary abuses of state power. It is not intended to serve as an alternate recovery mechanism for commercial or private contracts. Therefore, the writ petition is not maintained. So, 2 points they have taken on this. Apart from that, paragraph 5 onwards to the entire opposition, Lord, they have not a single line they have stated that the amount is disputed. They are not agreed with this amount.
Yes.
They are not also denying that particular, Lord, letter dated 4th March.
Yes.
So, Lord, according to me, Lord, the bank, the respondent authorities, Lord, is a state within the meaning of Article 12 of the Constitution of India. There may be a contractual obligation.
Yes. What is your submission, sir?
My lord. My lord, law on this subject to your lordship's correct.
You tell me whether you are admitting the
No.
letter.
No, my lord.
Where is your averment that you are not admitting the letter? In the opposition, the letter which they are relied upon, whether you are admitting or denying.
It is paragraph 10.
Yes.
Simply deny dispute.
So where is that? Can you come to the page 5?
Page 5, my lord.
Second paragraph in
My
the
lord.
middle. In the middle, you stated that around rupees 13 per square feet to rupees 14. Then also the respondent, although rejected the said demand, however requested writ petition to make a reasonable demand. Where is that request? Where is that request?
No, these are all between the parties during
Where is the-
negotiation.
Where is that request, sir? You cannot make out a new case. Other than
No, I am not making any new.
you are the bank.
I am
You
the bank.
now kindly come to the page 32. Sorry, 34.
My lord.
34 second, our views and recommendation. Once you are recommended, so whether the other authority have disapproved that, you show me, then I can proceed with the further.
No, this is not an admission. This
Why?
is the exchange. This is part of the exchange of letter between him and the bank.
So that's
my
why.
submission, my lord, my
Just a
submission,
minute, just a minute.
my submission, my lord, is completely elsewhere.
Hmm.
It is that law on the subject has been settled in Radhakrishna Agarwal's case, 1977 three-bench judgment. Your lordship, kindly see that. When it arises, contract arises in civil dispute, deed does not lie. It is not that deed does not lie, it lies. But there are three rooms. In my case, it does not lie. Now, there are plethora of decisions of High Court and Supreme Court.
Why in your case that it is not lie?
Because of the three-bench judgment, I am relying your lordship.
Your judgment will give seat subsequent.
No, your lordship, these judgment in making payment, delivery of payment by several high courts and Supreme Court too, even in ABL International, which is more celebrated, did not consider this. It is nice, your lordship, kindly say.
No, I am asking you, judgment is okay. So what is your contention in the writ application?
The question of admission does not arise, my lord, in my humble submission. Your lordship, kindly see.
Which paragraph? Which paragraph you are relying upon?
1977, 3 SCC, 458, second page.
I could see.
In the middle portion, just below the middle portion. It comes at paragraph 12 at page 463, more particularly.
Yes.
Where petitioner makes a grievance of breach of promise on the part of the state in cases where on assurance or promise made by the state, he has acted to his prejudice and predicament, but the agreement is sort of a contract within the meaning of Article 299. This is clause 1. Clause 2 is where the contract entered into between the person aggrieved and the state in its exercise of a statutory power under certain act or rules framed thereunder, and the petitioner alleges a breach on the part of the state, and where the contract entered into between the state and the person aggrieved is non-statutory and purely contractual. This is my case. And the rights and liabilities of the parties are governed by the terms of the contract. And the petitioner complains about breach of such contract by the state. I fall in this category. And furthermore, my lord, which has consistently been ignored by all Supreme Court judgment and all High Court judgments, is the 5-bench judgment of Horashankar. This judgment has considered that. In 5-bench judgment, Horashankar's case, Supreme Court unequivocally stated that in contractual matter, it does not lie. Now, the mystic part of this, that Supreme Court granted relief. Say, for example, if I am allowed, ABL International is the most celebrated one. More than 500 judgments have been delivered by High Courts, I have checked, following ABL International. But ABL International has not done it on the basis of this law, but on the fact, I am placing it before your lordship, international background, that the petitioner has already suffered huge time gap. Now, if he goes back to suit court, what will remain to him? Hence, Supreme Court granted the relief. So, an authority of any judgment, not in this subject, I submit before your lordship, subject to your lordship's correction, has to pass these three tests. And this is a three-bench judgment of 1997 when we had 14 judges. Now we have more than 38 judges. Three bench are constituted every day. But in those times, three bench did not used to contact on every day. Now we are not in a position to settle that. It is still a three-bench judgment, which I submit should not have been. This is ABL International, my lord. The ABL International has been followed in the single bench judgment. ABL International did not consider this judgment and Harasankar's full Supreme Court full bench.
Yes.
Harasankar bar koro.
Which paragraph you are relying upon?
Last paragraph. Paragraph 54.
Paragraph
54. 54 is the conclusion of the Supreme Court. No,
you have supplied only till 52.
Oh, my lord. So, my lord,
supplied this
no, I have another copy. Your lordship kindly take this. It is missed. Single page. And most interesting part is ABL International is done by Dr. Manu Singhvi. And Radhakrishna Agarwal has been done by his father, Dr. L.M. Singhvi.
I am not interested with that.
No, these are interesting part.
Point which has been raised.
No, my lord,
The court is
in legal literature.
The court always interested with the point decided not by the judge. Name of the judge.
And then I have concluded my submission. Kindly see your lordship. The clause 3.
Yes, page, paragraph.
Paragraph 54 of the ABL International is the reasoning for which the relief has been granted.
Yes.
And not, that is, I submit sincerely, subject to your lordship's correction, is not in consonance with the discussion. The law which has been discussed in ABL International.
Okay.
And ABL International misses this three-bench judgment. So it is par incurium in my humble submission.
Okay.
And the single bench judgment he has placed, my learned
Which is par incurium?
The ABL the single bench judgment which he has relied.
Single bench judgment
of Justice Rai Chattopadhyay, which he relies on because he did not consider this judgment, which is more specific and applies to the fact. A judgment, my lord, is an authority on what it decides and not what can be logically deduced from it. And the division bench judgment he relies also did not consider Radhakrishna Agarwal's judgment. But in other case, where I appear, this same division bench, presided by the Honorable Chief Justice Sivaganam, held otherwise when this Radhakrishna Agarwal was cited. Same division bench, same subject matter, different judgment. Same bank. Paragraph 5 of the judgment I referred, where I argued at page 3 of the division. পড়ে দিলাম এটা হচ্ছে এফএম এর 14 ওই তো পরেরটা এবিএল ইন্টার্নস ওটা ফেমাস মানলেই পেয়ে যাবে। হ্যাঁ হুম হুম হুম। আর এইটা আমি যেটা দিচ্ছি FMA 14/2023, 14/2023 PNB ভার্সেস তাপস ধারা, PNB ভার্সেস তাপস ধারা। ভরসা করে ওটা কোন জায়গায় আমি ওইটা লিখেছিলাম, এটা তাহলে ওইটা করে এটা প্যারাগ্রাফ 5, এটা পেয়ে যাবে, এটা তোমার বার করে নিতে হবে, SSC অনলাইনে পেয়ে যাবে 5, প্যারাগ্রাফ 5 এটাও দেবেন। ওটা না, সরি বলছি, এটা 1975 one Supreme Court cases 737. And this is the Horasankar's case. You know, this is the full bench judgment.
Yes.
Which says, in appeal before the Supreme Court, preliminary objection was taken that such of the appellants
Yes.
who offered their bids in the auctions did so.
Which paragraph you are reading?
What? I will ask him. This is your report. It is contact. Yes. Paragraph 17.
17.
17. It is at page 746.
Yes.
Last line. This court held that the appellant's appointment was contractual in its nature and the duties or obligations arising out of a contract could not be enforced by the machinery of a writ under Article 226. This is the full bench judgment. Horasankar's case. Horasankar has been considered in Radhakrishna Agarwal. But Horasankar and Radhakrishna Agarwal, one 5-bench judgment and one 3-bench judgment, has never been considered in any of the judgments, my lord, I have checked. In all cases, in more than 500 cases, today we can find out how many cases has been referred and pleaded. In these two cases, even the queer parties, when these two judgments were placed before Justice Sivagganam while he was presiding the revision bench, in two cases, the judgments were different. In one case, relief was granted. In another case, when Radhakrishna Agarwal was placed, relief was not granted.
Yes. That's all.
That's all, my lord. So
Yes.
that last type, what I plead is that since there is explicit difference of opinion in the High Court at Calcutta, made by division bench, presided over by Honorable Justice Sivagganam, and since in ABL International, which has been followed, which has not been followed in both these judgments, these
ABL International, which has not been followed by?
ABL International has not followed Horasankar's full bench and the Radhakrishna Agarwal's case. Hence, in my submission, subject to your lordship's correction, I invite your lordship to appreciate that ABL International, since it did not consider these two judgments, is per incuriam if we take it as an authority. But ABL International, which is very nice to see, has granted relief on equity, that the petitioner should not be placed to show hardship after 5-7 years. He has fought for it. So the reasoning and the conclusion are not coming together. This is a jurisprudential failure.
Yes.
So it should be taken not in 141, but in 142.
Yes.
And Radhakrishna Agarwal is the authority. Clause 3 of Radhakrishna Agarwal covers my case.
Yes.
Here, High Court does not interfere. Only in these three categories, I fall on clause 3. This is my submission.
Clause 3 of?
Clause 3 of Radhakrishna.
Achha, 12.
12.
Okay.
So, since there is difference of opinion and the question of per incuriam I have raised before your lordship, I invite your lordship, what your lordship has held primarily, just which has fell from your lordship, to place it before a bench which can consider which your lordship thinks fit for a special division bench also. This is my
One line, my lord, I can answer my learned friend's submission. At page 5, paragraph 10, but what has been stated in this page 5, paragraph 10 of their affidavit, that is contrary to that. That is contrary to their approval dated 1st February 2024 at page 31. That is contrary, completely contrary. My lord, the second aspect, my learned friend had referred, my lord, several judgments which deals with the disputed questions of fact. There, my lord, all the judgments, my lord, have been, my lord, decided that disputed questions of claim or disputed questions of fact cannot be decided in. I am also admitting that. I am not saying for a single moment that this is not correct. But here, my lord, I am on the basis of that page 31 of my writ petition. This is number one. So far, the other judgments cited by my learned friends, my lord, all are dealt with by the honorable single judge of this honorable court, which I have annexed with the writ petition. You will also kindly have a look up there for a moment. At page, it starts at page 87 of my writ petition. I'm just showing to your lordship. Page 90. At page 90. Lord, the bank has submitted all these judgments. Can you see? 2002-1 SCC, that is State of Beer versus Giant Plastics. Your lordship will consider it. Thereafter, Lord, next page 91, Bini Limited, Tata Motors Limited. All these three are cited. Thereafter, next, your lordship kindly have a look at the page 93. Page 93, paragraph 15. The Sanjana, the Hindustan Petroleum Corporation Limited was also relied upon by the honorable single judge. Thereafter, my lord, the Godavari Sugar Mills, paragraph 16. Then, my lord, kindly come to paragraph 18 at page 94, ABL International. Page 94, paragraph 18. And then, my lord, your lordship kindly have a look at page 95.
Yes.
Page 95, paragraph 21, G Telefilms. Thereafter, my lord, my learned friend has very much cited over that 1975 1 SCC 421 Sukhdev Singh versus Bhagadram. That was also dealt with by the honorable court. All these things are dealt with. Thereafter, the honorable single judge has come to these findings. And against this judgment, my lord, they have preferred the appeal. Before the appeal court, my lord, they lost, and thereafter they complied with that. Here, my question is that, my lord, so for the lease deed or, my lord, the terms and conditions of lease, I am not concerning about that. The terms and conditions, the tenure, other part, amount, disputed amount, I am not concerned about that. Only the question is, they have agreed regarding 40 rupees per square feet. I have also agreed. So your lordship, can you have a look at the once more?
Yes, anything further?
Not so far. My responsible submission is that, my lord, since there is a specific claim of the petitioners and the specific acceptance of that, Lord, there is no questions of disputed questions of fact. So, my lord, my writ petition should be, my lord, disposed of by directing the bank authorities to pay the benefits as mentioned in the writ petition at paragraph 14. I'm grateful.
Hearing concluded. Yeah, samgaj mein. Summary ammo. Yes, next.
I'm grateful to you, Lord.
Is it order reserved?
Yes, judgment reserved.
Yes.
I'm grateful to you, Lord.
নামটা দিয়ে দাও তো ঠিক করে।
चैम्बर में भेज देना। Yes, call. But I'm appealing for the state.
Appearing for page number 15.
Page 15. Disposed of.
15.
Disposed of. Disposed of.
Page number 17.
Disposed of.
Page number 52.
Disposed of.
Page 21.
Disposed of.
Page 19.
Disposed of.
Page 20.
Disposed of.
Page 20, Lordship.
Disposed of.
Page 19, Lordship.
Disposed of.
Your Lordship, 30 petitioners, only family members could.
Give the fine. Dismissed.
Dismissed.
Dismissed. How 131 will be? Huh? Whatever it 31, this how the maybe address might be how mother, father, son, daughter, that can be, but total villager, total persons of the same constituency, how the court can allow this? You want to, I will allow you. Yes. This court find that the petitioner has altogether 31 petitioners have altogether filed the present date application. According, this court find that his petitions were having their own cause of action, and so all the cause of action cannot be, and all the petitioner cannot file a single writ application. Accordingly, the petition is dismissed. However, the dismissal of the writ petition will not prevent the petitioners to file a separate application if so advised. Next.
Page number 63.
My lord, item number 153, page number 23.
Disposed of.
Your Lordship, item number 153, page number 23.
Disposed of.
Item number 153. And my lord, item number 154 and 155. Your Lordship, the petitioner's OBC NCL application is pending. And my lord, for the same, they could not participate in competitive examination, which is required. And SDO.
Okay, first you get the name you recorded 150. 155.
My lord, in OBC NCL application is pending for that reason, your Lordship. Kindly see the page number 58, your Lordship.
Page 58.
Disposed of.
They specifically stated
34.
Disposed of.
37.
Disposed of.
33.
Disposed of.
43.
Disposed of.
32.
Disposed of.
Yes, 161.
None appears on behalf of the petitioner. No accommodation sought for.
Dismissed.
WP is dismissed. Next.
162 others are there.
161, 162, I am appealing on behalf of the petitioners. My lord, 13 petitioners, 162 page.
How many petitioners are there?
13, 1-3, my lord.
1-3.
From the same, my lord, AC, they are the poor villagers, man.
Dismissed.
With
Next.
liberty.
With the
With liberty, man.
Same one. Yes, next.
163 23.
Disposed of.
इसका है ये वाला. Page what?
Page 21. Disposed of. Page 18. Disposed of. Page 21. Disposed of. Page 22. Disposed of.
Lordship, in this matter, Lordship, there is something different, Lordship. There is Lordship, my name, I have valid voter in 2002, I have voted, Lordship.
Yes.
2002, I have voted. Now my age is 48, Lordship. My verification report has been stopped.
Under
SP.
adjudication, SDO
There
has
is
been
no delay, nothing, only adjudication. The SP has not been issued the VR report to the district magistrate, Lordship.
Where is your adjudication application?
Lordship, that is page 35, Lordship.
No, 35 is the voter.
35, Lordship.
No. Item number?
168, Abu Taher.
160. Yes. No. Where is your application before the district magistrate?
Lordship, my name, Lordship, medical has been completed, TR has been completed, page 53, 54, all are verification report, Lordship.
Where is the application before the
No, there's the SP, Lordship, Superintendent of Police. All verification, Lordship, went, Lordship.
Where is your appeal pending?
I have not filed any appeal, Lordship. Only adjudication due to my name.
Adjudication
Page
application.
35, Lordship. Can you see the
35 is the voter list. Can you see the voter list?
Lordship, can voter list my 612, Lordship. Serial number 612. Abu Taher.
Where is your application to the election officer, chief election officer, or the district magistrate?
I have
Or
not
the
made-
adjudicating authority.
No, Lordship, I have not
How?
made any application because
Who will
Lordship,
decide?
only for the adjudication, Lordship. The SP did not issue my verification report to the DM, Lordship.
Acha Dhara, let there be a direction upon her to file an application and
No.
dispose.
If there is not, why? If the court is not giving some, there is no appeal or application pending before any authority or appellate authority.
Lordship, can you
or
grant me to leave to file?
Deciding the issue by any authority according to
They have not issued any deleted, Lordship, can you leave?
dismissal of the writ petition will not prevent the petitioner could make appropriate application before the competent authority for consideration of his case for inclusion of name in the voter list. Next.
Page 14,
Disposed of.
page 18,
Disposed of.
page 14,
Disposed of.
page 14.
Disposed of.
My lord, page number 28.
Disposed of.
My lord, page number 23.
Disposed of.
My lord, page number 24.
Disposed of.
8 full mark.
এই নাম্বারে করে দেবো তো?
respondent number 4JM.
Hmm.
But my lord, we have given the wrong slip. Advocate Ayan Poddar was not appearing today. And my lord, in the slip, we have given the name of the appearances, we have given Ayan Poddar. So it should be deleted. Ayan Poddar's name.
Hmm.
I have talked with the stenographer. The order has been typed and it is before your lordship.
So what you want?
I want only the deletion of the name of the advocate Ayan Poddar, Mr. Ayan Poddar.
Who has taken?
So, deeply obliged.
But
Yes.
he was kind enough to let indulge me let.
Hmm.
2nd September was on given. Just now taking instruction from my client. I understand what is troubling your lordship let they have already joined in the work. Let for these duties. Training is already over. Let can it be upon any date? Otherwise, entire matter will be infectious. Let us take my. I will trying to pursue lordship.
The problem not that. Your colleagues are watching from the door. Correct. What is going in that matter? I allow this, then they are coming with another. Achha, that are allowed. Then they started as like a aunt queue. This is the problem with the bar. Initially, I fixed the matter. Thereafter, 5 matters that came. I directed all 5 matters with there. And again, they are coming my teacher's matter and census matter. Then the court has to be created. That is the problem. I have no problem to hear anybody. Whoever came before this court, I am taking the writ petition. Correct. But the problem is that not today I will allow you, tomorrow before taking of the matter again to writ petition. My lord, this is a census matter. Without ascertaining what is the fact, what is going on. So that is the problem with this court, with the bar.
Understand.
They are not understanding. Okay, one order will be passed, that will suffice to all teachers. And I already fixed the guidelines given to the SGI. ESGI already assured before this court, he will sit with the officers and will come with some solution.
I follow that, man.
So,
So far, since my prayer is something else,
and you
have heard-
being the senior person, you file with the union. The teachers, their own grievance, how the union will maintain all writ petition. Union, I appreciate union will maintain, but some see the cause.
The prayer I have made.
Because if you come with the union, then the all West Bengal teachers will be there. But then how the authority will execute the work?
That's why I have said that my prayer is not to avoid duties, but I am in fact discharging from 16 from yesterday I have joined. My prayer is something else. I do not want to avoid that duty. This is a sovereign duty. I have to.
Okay, कौन सा matter so कल कर दो census matter के साथ रहा. Yes, next call the list.
Your Lordship, my learned senior is on her legs before court 1.
Yes. Who is for the petitioner?
I am for the petition.
Yes.
For service. My lord, with I start with the
Yes.
prayer first. Prayer will give an idea about all.
Yes. What is the matter?
Here is my lord 171.
171. So big writ petition. What is your challenge?
I reduce it to only 20 to 25 minutes. But not. It's big petition because so many.
What is your prayer?
Yes, I'm just reading first one, and there is an alternative prayer. There can be an alternative. For the issuance of appropriate issue commanding the respondent to the purported consultation of the governors, branch promukhs of the state concerned for executing
community under Constitution, Scheduled Tribes Order 150, issued in purported exercise of powers conferred under Clause 1 of Article 3 of the Constitution of India, consultation with the governors and in gross contrast to petition number 550 published in the Gazette of India, read with petition number 3563, so and so under authority of Secretary of Government of creates money, in as much as the omission of the same from the Constitution Order Scheduled Tribes 1950 has been the gross inclusion of the rights community as enshrined in Article so and so, further depriving them of the benefit of the
So they have not been included in the scheduled caste, scheduled tribes,
included below in the backward of the West Bengal.
backward classes.
Backward caste two.
Which group A, group
Group 2.
Group 2.
That is group 2. Now I shall be, after so many permutation and combination, I shall be satisfied if the central government or state government can just disclose the basis of my inclusion in the backward list. Because till date, I do not know about my SPCs. Well, I have learned 6 grounds.
So you not made a representation to the commission? No, commission hearing was not done.
So I'll just stop it.
There is a commission here.
There is a commission, but that was 1990.
No, subsequently every 5 years one retired judge of the High Court is to be appointed for the Scheduled Caste and Scheduled Tribes Commission. So he used to call the meetings whether any groups is to be included or not, and he will recommend and be sent to the government, and the government, that procedure is not adopted.
The state government has itself referred it to settlement, but that has been not considered. And well, I have just 6 grounds. I just take 20-25 minutes. What are those grounds? Those grounds are very important because that is supported by pre-constitutional government documents, pre-constitutional judicial orders, pre-constitutional anthropological records, and genetic record, which is scientifically proved now after 2009 onwards. The reports that have come, Constitution itself, and post-constitutional order of the Honorable Supreme Court. So let first your lordship may come.
Page. Sole petitioner. Sole petitioner. One 131 of
These are the 2 records, government records, in which
the Bihar and Orissa.
Bihar.
Hmm.
And
1930.
Now what happened? When English law enacted Succession Act 1865, they the principles of this and on those they were excluded from that. I am one of them. So if you are considering the C, 2nd May 1913, my name is included along with others like Purao, Sadhar, Puls, Bhumi, Karyas, and Pulis. Actually, it should be Puna, but anyway. And in 1931, again the same happened. When the previous law of 1865 was withdrawn and the new Act 1925 was enacted. again the same and in 1931, they again excluded all these types of Sudan, only Sudan in that Sudan 406 happened to only some parties of the so they again excluded these types. So if I go by this 1951, then my name appears in the private English. And one of the order is 5. Page number
201.
First, I start.
So how the High Court can consider?
Why will the interpreter, whatever they have, if I belong to private, I'm not right. That is the point of this. Honorable High Court of 1945. High Court. So if you are not seeing the case,
What is their contention?
yeah.
Now, what is their contention? They filed affidavit. Affidavit they have filed.
Yeah, right.
What is their contention? No, that's it. I am asking only. What is their contention?
They have not done that. That means they have declared because Article 346 that a commission is required to be appointed.
That's what I'm telling.
Yes.
Because unless and until the commission will not examine the persons and with regard to the other whatever the documents and the materials, then the commission has to make an opinion. Commission has to make an opinion. Then the opinion, though it is not totally binding, but yeah, it is not totally binding, but it can be taken into consideration while notifying the criteria. That is the thing.
And at 31, category we have not done unless and until an approval. How can we know that they are not to me and they are to me? How are they different from the Kumis of Bihar? Because they are from they are people. We are totally. We have
Yes.
nothing to do with the.
Yes, 224. Judgment of the Bihar High Court.
Yes.
Patna High Court, sorry.
Now we do not admit of the same ground where the are receiving and aboriginal tribe. They are the most numerous communities that speak topics. They have overflown into the neighboring state. They have no concern whatsoever. Accent of name is the Dravido Aryan individuals and medium caste of Bihar. This important and however most steps faster than great minds of the district there is often the field of variation in this or rather equal position of impact and some areas that by which between the act that is as distinguished from the entirely distinct behind us. On the ground that we have customary and inheritance incompatible that indicates that the whole type at least had not become illegal if all would be considered as the act. sometimes, you know, part of the previous are redundant against such a high. The ethical case of selling of so even where it is practically required, if being as on the contrary, it is at least consistent with the experience and probabilities that is likely as carried on after the adoption of is also a view of the highest quality of the further the candidates on the person maybe the party that adopted structure or data. I don't think that and begins part of the country.
Number 12 is a big one that may be taken as read, my lord. I am reading para 13. The lordship then held on evidence that whatever Hindu customs had been introduced into the family, the customs of succession by adoption has not. Similarly, in the present case, the points of inquiry were first whether the general Hindu law was substituted for tribal customs in respect of inheritance as part of the personal law of the parties, and if so, whether it was the Abhaga form of the Hindu law on the point. On both points, the onus would be on the plaintiffs, whereas if the parties had been persons unquestionably governed by the ordinary Hindu law, the onus in the first matter to prove a customs at variance with Hindu law would be on the person who asserted the existence. The last is only a repetition, para 15, Miller, and in the footnote gives a list of the 5 commissioners divisions of Bengal, Manbhum, Bihar and Odisha, and certain districts in Assam, in Bengal.
So how the area has been notified as the aboriginal tribe area?
Which one, Miller?
The petitioners were residing which area?
Jhargram area.
Jhargram. That is not the aboriginal tribe area. That is not the tribal area.
Actually, the entire Milord Chotanagpur plateau is a tribal area.
That's why I'm
because we have even I am from.
If a tribal by original.
Exactly.
If the tribal by original and where they have been shifted or they have grown up from the places.
Yes.
So that has been taken as the aboriginal tribal area.
Yes.
So the normal person cannot enter.
Cannot enter.
Cannot.
And your lordship may be surprised.
It is a totally the government has to see with regard to
absolutely. And your lordship may be surprised by this.
Their custom cannot be disturbed by the local people.
Local people. Yes, madam. And your lordship, this is a very important information so far as Jharkhand is concerned. Here, their land is not under CNT. Chotanagpur Tenancy Act. Chotanagpur Tenancy Act is existing at Jharkhand, Milord. Their land came to be recognized under CNT in 1962 after prolonged Milord representation before the government. So land got recognized as tribal land, but the community has not been Milord recognized as tribal.
Okay.
And third, Milord, I refer, Milord, anthropological record. I will not read. Your lordship, just see these books. I have referred from these books, Milord. This is the most authentic book, Milord, written on anthropology of this entire, Milord. This is Riesle, Milord. Before that, बुक का तो इसमें लगा हुआ पिटीशन जो रेलेवेंट पैरा है तभी तो इतना मोटा हो गया this is the most authentic, Milord, quoted by the Anthropological Survey of India. This is the most authentic book. Previously was one
published by government.
It is this government, Milord. Yes, Milord. By the Anthropological of India, I mean, today they refer this book for anthropological regions, Milord. So now this book says, Milord, that I am a Dravidian tribal. There was some mistake because they did not have the, Milord, this genetic report. Genetic report started coming, your lordship may be aware, from 2009 onwards. 2009 onwards, Milord. I'll refer to that because I sent, my lord, blood sample of 366 from this community, my lord, of this entire tribal, Chota Nagpur plateau to, my lord, BHU. BHU has published so many reports, including Onge, my lord. Onge people of this Andaman, they are considered the oldest tribe, having migrated to India from Africa, my lord. Yes, from Africa, my lord, after 65,000 before. 65,000 before, they are considered the original tribe. They are called the, my lord, early Indians of Indian tribe, my lord. And when I sent this, I got surprised by this report, my lords. I have included in my lord, reply affidavit, because you just can see that what they have to say. And this person who is the head over there, he agreed to even come before your lordship to depose. That is not required, but kindly see the report, my lord.
No, that's why, because I am afraid, because how the writ court, unless and until the government, what is the affidavit I will hear?
Yes.
Unless and until the government say, if it is a commission, then the matter has to be referred to the commission. The
Commission,
commission
yes,
has to
yes.
examine the witnesses.
Absolutely.
He has a right. He has a power to examine the persons, and
Government decide not to conclude that, not to recognize me as tribe. That is government's power, because I am not challenging under
correct,
342.
but
But at least, my lord,
if the representation
Correct.
is made, that has
Correct,
to be
Mr.
decided. Then it will come to the once
yes,
before the commission, all the documents, materials has come before the commission, then the report can be brought
Absolutely.
before this court, and this court can come to the
Correct.
conclusion.
And my lord, BHU is a government body. BHU, kindly just come to page 7, my lord, of my rejoinder, reply affidavit to their counter, my lord. একটু help করো, এটা পাতলা, এরকম পাতলা, দেখো, এরকম পাতলা। 23rd May 2025.
So nowadays these tribes is going to be abolished. I don't know what.
Page 7, my lord, because he sent it. This report was supposed to be published in Cell or Science, my lord. Unfortunately, they have not yet published. So he sent that report, my lord, in my WhatsApp. So I just read para 15, my lord, that to enlighten the Honorable Court, the petitioners crave leave of the Honorable Court to reproduce the genetic findings of BHU about Kurmi on mitochondrial DNA in brief, herein below. This mitochondrial DNA, my lord, comes from mother to daughter, daughter to, and Y chromosome is from father to son, my lord. Your lordship is well aware of that. So this is geneticist of India, Mr. Gyaneshwar Chaubey.
Then there is several litigations. If tribes marriage to non-tribal.
Yes.
If the male married to the non-tribal,
It's okay. But if female, then she's out. Because that is their succession act. That is the problem with their succession. So your lordship may come to next page straight away. This is from, I just wanted to refer his name. Now see, 70% of their mitochondrial DNA, total 366 blood samples they collected, my lord. In fact, this gentleman came along with his scientist. He went to Jhargram, he went to different parts of Odisha, Jharkhand, and also Bihar, my lord, and collected 366 as per his, my lord, understanding. Because he is the scientist, we are not. So he wanted to take from the remote corner of the villages, my lord, not from the people who are residing in, my lord, for obvious reason, my lord. So your lordship may come to page 8. 70% of mitochondrial DNA fell within haplogroup M. Now, this is the finding of Anthropological Survey of India, that if in any community 60% of the mitochondrial DNA is falling into a particular, my lord, that is M, then it is a tribe. It's not my finding, my lord. It's the government of India says so. That if it is more than 60%, it is a tribe. Here he has found 70%, my lord. And now your lordship may come to this next one, which is the most important. Notably, one sample belonged to haplogroup M31, an Andaman specific haplogroup that has been present in India for approximately 65,000 years. So even if one person is carrying this M1, that means this tribe belongs to, my lord, that group, particular group, my lord, which is there. Additionally, 19 of 366 samples fell into one of the most ancient haplogroup M2, which is over 60 years. My lord, actually it is 60,000 60,000 years,
60,000.
60,200 years as per the geneticist. And the last one. Furthermore, 27 of the samples shared the same haplotype with haplogroup R6, which is characteristics of Munda group, including Birhor, Ho, Mawasi, Santhal, Baiga, Gabada, Juan, and all. This R6 has come from Cambodia and Vietnam. They came from this Chinese side, they are these people, Munda group, Munda Santhals and others. So there appears to be an intermixing between them also, because all these tribes are part of this entire Chota Nagpur plateau. And this particular community is not found in any part of this country, only in the Chota Nagpur plateau, all of them. Even if now it is divided.
Who is appearing for the? What is your instruction? That file have detailed, but how the writ code can go on? Because whether you have a commission, schedule type commission.
Already before previous other forums, and it has been adjudicated, orders have been passed. Your Lordship, the nearest
No, because what I am thinking on, because every state and every union territory having their own commissions.
Commission, yes.
With regard to the tribal, caste, schedule, OBC and all these things. Unless and until the commission is not examined and submit the report, it is difficult.
already examined since 63.
No, that's correct. So whether the commission has examined, commission report is there.
Your Lordship, in the affidavit in opposition, there is a report.
Is correct.
And this is absolutely the jurisdiction of Parliament.
Parliament will come later. See, Parliament will come later. You have already notified. Parliament already made a law. Scheduled tribe, scheduled caste, OBC, correct. Then OBC, ABC, scheduled caste, whatever it is. So now the tribal, the government has already notified which area, this Santhal, this, Bhil and all these things of this area. Subsequent to that notification, if any persons is having any grievance, yes, I have been left and I am also coming under the purview of this tribe or this caste or this schedule. So then that cannot be decided by the authority or by the court or directly by the parliament. It has, that's why I am not remembering, there is act, because the commission, every state is having the commission.
1993 Act. It is there, 1993 of West Bengal. Yes, commission for.
Commission.
Yes.
So
OBC
that
and
for the
SC.
commission, every state appointed at the level of retired High Court judge or Supreme Court judge have been appointed the chairperson of the committee, the commission. Then he will, if he received any objection, then he will call objection, claims and objections. And he has a right to examine all the persons, evidence he can record, he can take all these things, he will collect and he will send it to the concerned government. If the concerned government is of the view, yes, it has to be added, then it has to be sent for the notification. That is the law. I don't know what has been adopted here. So that report, that affidavit, whether you have taken that there is any commission
from affidavit, your Lordship may just take para 13.
Affidavit in opposition.
Opposition, yes.
No, I don't want to continue because this court can't decide.
Yes.
That's why I want, if there is a report of the commission, then this court, because I cannot go through all books and all this, the court cannot research whether it is coming under the ST or SC or whatever it is. So first it has to be decided by one commission or one authority. So that's why I want to know whether this in the affidavit in opposition, have you disclosed any commission's report?
The matters which had happened with regard to same issue.
The
logic comes to page 25, paragraph number 13.
At least 26.
Page 26, paragraph number 13. learned, yes, he requested that he will conclude, he'll reply on the next day.
Correct. That law can be made to whether it is coming.
This is law, my lord. This is the statement
the
of law, what is
yes.
existing today. But what they are saying at para 13, my lord, kindly see. They are admitting that either under 340 or even the state government under its Act of 1993, they have not constituted. Kindly see. The
Whether-
answering respondent submit that the
Because why
petitioner is-
in first there will be a recommendation or failure recommendation.
Absolutely. Absolutely.
Recommendation of recommendation, then both the things is to be considered. Recommendation, what criteria has adopted for recommendation? If not recommended, what criteria is adopted for not recommended? What are the reasons? Then only then either court or the parliament it can be. If the court is fine, then it will be referred to the left to the parliament or the state government for notification.
They have, my lord, included me in the backward list, but they have no data. That is the biggest problem. You have included me into the backward. That is.
Back in 60s.
That's why we.
Parliament.
Now, when you have been declared as OBC?
I was here. Long back, long before.
And you are taking benefit of that.
No, there is no benefit, my lord. Because as a tribal, the benefit is different.
That is different.
Because my land got, my lord, alienated in the entire Chotanagpur plateau because I was OBC.
Tribal is different.
Land is the biggest issue, my lord. Land got alienated because I was backward. Had I been, my lord, tribal, land would have been saved, my lord.
Yes, so you take instruction.
Your Lordship, one more aspect. This is an old matter. State has changed. They are not today here. Earlier they were being represented. So whether my learned friend has provided the writ petition to them so that they can also answer.
So that's what I'm telling. That's what I'm telling. Now you persons are appearing. If not, he will supply that. It's considered.
Union of India.
Correct. That is the only thing. And the
340
state,
is
who is
below-
appearing for the state?
340 only central government has to decide on under 340.
My learned friend may not have served the.
Who is appearing for the state? State is who are the party here?
Writ petition
I
and
think curbing affidavit. Sir,
No, state. State of West Bengal. And secretary, Mr. Backward.
Yes,
backward
only state of West Bengal and my lord.
secretary. Yes, main is this 4. 4 has to give the answer with regard to the state. What he had done, what he has done.
Yes, my lord. Secretary backward caste.
That
They
is-
are only saying that I have included their report.
Yeah,
which has-
there is no tribal welfare committee.
No, TRI is there. TRI has recommended my community to be accepted as a tribe to the central government. Central government has rejected, but without any verification, anthropological verification.
There in the affidavit. My learned
Okay.
friend has.
So you do one thing, you serve the copy to them, state as well as the GP and ASGI. So the copies you are having the copy all. You are having.
Only for state.
So you serve the copy to the state. Let the state come to the GP. Because first it has to be ascertained. If they will say yes, they will appoint a commission, then matter ends. Let he decide.
Oh, we have served, madam. My clerk is saying we have served to the new.
Where is the affidavit?
Affidavit of services.
That is the problem. Service. Yes. It is served. 29 July it was served.
सर एफिडेविट सर्विस में बोल रहे थे फिर सर्विस कर दिए थे
Who is appearing? It is served to GP. You're in panel.
yes yes
Give the copy. I am recording your name.
We'll give. Now, before just concluding, my lord, may I just give one order? Para 9 of this Honorable Supreme Court order. It says, my lord, the pre-constitutional, my lord, documents have a probative value. Para 9. And also it talks about, my lord, affinity test for recognizing a tribe or a backward whatever. Para next, my lord.
So
Para
that's
9.
for this the evidence is required.
Yes, my lord. That is
Evidence
that
is
what,
required.
Despite my representation, nothing is happening. Nobody
Without
is-
the evidence, how it can
Yes.
be? The writ court cannot hold the trial.
Yes. No. It is talking about the pre-constitutional documents. I am referring to the
Pre-constitutional document
2013
is
and
okay.
2031 document.
No, pre-constitutional document, then this has to be corroborated. What is your
Yes.
contention?
I-
So how
bow
to
down.
corroborate?
Yes.
So pre-constitution document which you wanted to take the benefit, then you have to corroborate, yes, this is, I am coming under this. So how you can prove that?
Correct. And also the judicial orders if
Judicial.
they are in my favor.
The London advocate appearing for the Union of India present okay, उससे पहले होगा. Affidavit of service filed by the petitioner, let the same be kept with the record. None appears on behalf of the state. Full stop. What is the good name, sir? So is present in court. He has been directed to appear in the matter and to represent the state and to take appropriate instruction from the respondent authorities. The petition directed to serve a fresh copy of the writ application and all of the documents including the affidavit in opposition and a reply to the advocate appearing for the state within a week from date. The counsel for the state is directed to take instruction. This is the matter on, give the date, 7th October at 2 p.m. Come with the total details.
We have already served the copy.
Give one copy.
We'll give me just now. We'll get a Xerox and I'm sure.
Yes, next. Yes.
Looking for the statement.
For the petitioner, you are appearing?
I am for the petition.
What is the matter?
My lord, petitioner before Lordship, my lord, appeared for my lord, National Entrance Cum Eligibility Test 2026, NEET, my lord. As my lord, OBC category candidate. The result was passed. My lord, petitioner, my lord, passed the said examination. My lord, same category rank of the petitioner is my lord, 526.
526,
my lord.
Out of 720.
My lord, kindly see, my lord. The result, my lord. My lord, page 26.
Yes.
My lord, category rank, my lord, 587, my lord. OBC category.
5087.
Yes, but 5087.
Yes. OBC category.
OBC category.
Correct.
My lord, it is a system, my lord, for my lord, renewal of the OBC category. But not in done, my lord, rejected, my lord.
Rejected?
Yes.
Where is the rejection?
My lord, page, my lord, 31, my lord.
Page 31?
Yes, my lord.
Why it is rejected? What is the,
mother
what is
of
the
the
reason?
applicant, my lord.
What is the reason for rejection?
My lord, mother of the applicant.
Group A employed.
Group A. It is a teacher, my lord. My lord, is school teacher.
And you for OBC?
OBC. My lord.
So what is your annual income?
My lord, rule, my lord, says, my lord.
What says?
On
Rule?
that 8, my lord.
What the rule says? What is the income?
My lord, age 40, when my age was 40, my lord, on that time, my lord, 6 lakhs. My lord.
Today?
So, my lord, kindly see, my lord, also. Para, my lord, 10, last, my lord, E. Para 10, E.
Yes. Yes, Group A.
Group A. Yes, my lord, but my lord, my submit, my lord, I am not Group A.
Which group you are?
My lord, teacher, school teacher, my lord, it can be my lord, Group B, Group C.
That is that you're talking about the class
group, my lord.
Group A and B.
Well, that will, my lord, Group A means I.
Not a
IPS,
class.
ICS.
It is not a class. Yes, Mr. Menon. Certificates.
Yes.
Mother is what then proceeding at the time of joining. At the time of joining. Now it's maybe
2002.
now another thing, but at the bottom. The wealth of father is the income tax paying. Mother is also income tax paying.
Better position to assist your lordship, can you take my instruction? Rejection of his PCSPL certificate, my lord, was that the mother is Group A employee. Or if my lord can come to page, the first paragraph of my instruction, my lord, back in 2006, when his mother was joined, she was having a great pay of 4,800. With regard to this, my lord, I teach your lordship to come with page number 10 of the instruction, my lord. It's a notification that starts from page number 8. My lord, that's a notification date 23rd February 2009. I have only extracted the relevant portion for your lordship. Page 10, my lord, it's clause 13 of that notification.
Yes.
When Group A has been clarified and classified, government employees holding all posts in pay band numbers 4 and 5 with great pay ranging from 4,400 to 10,000. That means she was Group A. And my lord, with regard to the proposition, my learned friend was showing, my lord, that clause, if my lord can be come to page number 1 of the instruction, my lord, it's the guideline for issuance of OBC certificate. While my lord, page number 2, clause 8 specifically says that the applicant does not fall under criminal. 8F, my lord.
8F page 2. Page 2.
Technically 3, my lord, annexion page 2.
Yes.
8F, the applicant does not fall under criminal.
Correct.
This, my lord, kindly see clause, kindly come to page 4, clause E. Regarding the determination of criminal, the following points shall be considered. May I read it for your lordship? First, the first status of the parent is to be ascertained. If any of the parents of the applicant holds a constitutional post or belong to class 1 or Group A service of the central or state government before the age of 40, he is considered to be belong criminal. Here, when at the age of 34, his mother was getting 4,800, which is beyond 4,400, falls within Group A. With this kindly.
Now, how you telling that the at the age of 34 years, she was getting the
4,800.
4,800?
First paragraph. Instruction when the
2006.
Yes, 2006. Before her age of 40 years. Now, with this, my lord, kindly when my lord can come to page number 5, point number 2, E2. The criteria prescribed for determining familiar status of sons and daughters of persons in government service, mutatis applies to sons and daughters of persons holding equivalent and comparable posts in PSU, bank, insurance organization, universities, and educational institutions. Also having equivalent or comparable posts in private employment. Here it is an admitted fact that the mother of the petitioner is
working as a teacher.
As well as she was drawing 4,800 rupees when her age was 34. So she is falling within the defined in the 2009 notification, and thereafter also falling within the determination as prescribed in 2015 notification. This is the reason for his rejection.
Okay.
One copy, my lord.
That's all.
Kind one copy, my lord.
Yes, what is this? It is settled. Your mother is working, your father is income tax paying, 4,800. Coming under the.
There, my lord, my instruction, father, my lord, is a contractual.
Declaration was C category, my mother.
You might be.
That was not been examined, my lord, not been.
Not necessary. Your mother and father. Your mother is teacher.
Contractual.
4,800.
Father is not a teacher. My father is not employed anywhere.
Not employed, but he is the income tax payee.
Income tax payment, my lord.
Income tax payment means what is the annual income? Taxable income?
It is, my lord, only the mother's income has been.
Taxable income is?
Impugned order, can you look at? Mother's income only has been.
Correct.
Only
Mother
mother is A category.
correct. Mother
Is
is
mother A category?
yes.
But I am putting a question to myself, mother A category has been classified in the notification.
Give the report. Give the report. Page 10, classification of
Government employee holding all posts in the pay scale. I am not a government employee, first of all.
You are not a teacher.
No, no, no. Full teacher is not a government employee. It is under the council or the board. It is not the government employee. That sense. I am not a government employee.
2015 notification, education.
Yes.
But I am only praying this, but let it be clarified by the district magistrate. Since I have this shortage of time, I could not prefer any appeal. There is a provision for kindly give me a liberty to file. Because it is a case where I have been selected. I have been selected to be eligible for the purpose of admission in the medical course.
But what can be done?
And only because of this,
If you are not coming,
I was an OBC.
If you are not coming under the OBC, so
if I am not OBC, let it be decided by the district magistrate. Only liberty. But I know that, but that I could not make because of the urgency and the close date fixed for the purpose of the schedule.
But
yes.
Yes, but that is exactly. But I am.
That for the purpose of obtaining in a government college.
He wanted to that.
That is exactly, I am otherwise eligible. I am a good student, according to the authorities, I am entitled to give for medical student.
Go for a good school, college. Why you are going to the government college?
No, I am entitled to, even medical college, if I am an OBC, I can get the medical. That is subject
so
to.
What do you want to withdraw?
Subject to.
How can I pass an order?
Subject to decision of the district magistrate, I am taking my admission. Subject to decision. Ultimately, GM is holding that I am entitled to OBC.
No. Prima facie, I am satisfied with the rejection. Prima facie, I am satisfied. If you want, then I'll pass a judgment order on merit. If you want to withdraw, you want to file appeal, I will give that liberty. That can I do that? If you withdraw with the liberty to take appropriate decision before the appeal.
Do that.
Or you want the order on merit, then I have to discuss all this.
It will close all hope. At all, anything is there. If at all anything is there, of course.
Counseling has already started.
That is
Yes.
there.
Tomorrow is the last date, I think so.
No, my counseling for I have applied for, my quota has not come. In the general category, I have already.
Counsel for the petition intend to withdraw the present writ application with the liberty to take appropriate decision before the appropriate forum. In view of the above, WPA number so and dismiss as withdrawn. Liberty to take up with the liberty to take appropriate decision before the application.
Yes. Rounds are going on. Obliged to Lordship. Grateful.
Next.
My lord, this is that section 107. My lord has held in several, almost 15, more than 15 judgments, my lord, that section 105. In fact, we have prepared a compilation also that section 107, my lord, is required to be.
My lord, I am for the HDFC Bank, my lord.
My lord, what has happened here is, my lord, this initially they had freezed my account. Later, upon my writing to them, they have defreezed. But twice over, my lord, I run a electronics shop. Somebody purchased a mobile phone for 1,62,000. First, initially they freeze my account. Then they defreezed and they made a lien over for 1,62,000. I was even okay with that. Then they again did another lien, and all the letters from the respondent as also from the bank show that it is pursuant to 2 police complaints. There is no reference to any order passed by the magistrate. I can just show, my lord, those 3 letters.
Yes, who is appearing?
Yes. My lord, I am for the bank, my lord. My lord, as per the LEA communication, my lord, we were under obligation to mark the amount under lien, my lord. My lord, now, my lord, and since your lordship had already considered in several other matters, my lord, a similar
What is the
order.
disputed amount? What is the disputed amount?
My lord, the disputed amount, they were aware, my lord, 1 lakh totally, it's
1 lakh, I just show, my lord, there are 3 letters, my
yes,
lord. Kindly first see page 40.
40?
40, my lord. Just 3 letters, please bear with me. I'll just show the 3 letters. Kindly see, we wish to inform you that account number such and such has been marked debit freeze. So initially there was debit freeze. Now kindly see after this page 41. Page 41 is my mail, where my lord will see. Kindly see page 41.
Above mentioned accounts which were marked debit freeze on directions from SAS Nagar, Punjab, due to some UPI fraud, our lawyers got in touch with the said police station, made a representation to them, post which they agreed to release our account. The bank, under instructions, defroze our account but held back 1,63,000. Then kindly see the next para. On November 2025, again, our above mentioned account marked debit freeze on instructions from same cybercrime. Then kindly see, however, in the last line of that, however, another amount of 1,63,000 was held back by the bank for a second time. Now kindly see after this page 42, which is the communication from the bank, where my lord will find that both the complaints are mentioned. This is to inform you that amount has been put on hold. Then kindly see the reference is to two complaints, my lord, by in respect of the same alleged, my lord, offense, and where, my lord, 1,62,000 twice over has been attached. And kindly see after that the next page, page
No,
40.
1,62,000 on
Into
single.
Twice. They did it twice.
Twice.
And then that becomes, my lord, very clear if my lord sees page 43.
Two
This
lakh
is to-
18,000.
43. My lord, kindly see page 43. This
Yes.
is from the bank. This is to inform you amount has been put on hold. As per MHN notice, hold amount of 2,18,000 has been marked in such and such account and 1,08,000 in the other account. This is total, it comes to 1,63 into 2. Then kindly see complaint currently with police station. So it is purely based on a complaint made by the pending before a police station against some third party who purchased a phone from my shop. So admittedly, there is no exercise under section 107. There is no magistrate's order. They have not annexed any magistrate's order. Even my learned friend who is appearing is not in a, I'm sure is not submitting otherwise.
No, my lord, we are not. But in that case, my lord, the investigating authorities' presence also be required. If
No,
my learned senior friend is referring that 107.
Yes, they served. They have been served. The affidavit of services.
Yes, my lord. In most of the cases, we have seen that never the investigating authorities are appearing, my lord. So, my lord, I can.
And my lord, give the compilation. My lord has kindly see my lord's decision, my lord, in Zenitist Technologies, my lord has considered this question, my lord, and of course in several other judgments. But my lord has held, my lord, that attachment cannot be done under section 107. All of them have been served, my lord. We'll see the delivery notice page.
My lord, attachment is not there, my lord. It is only the amount is under.
No, that is an attachment. That of course is an attachment. Is delivered, my lord. All page 9, 8A, 7, all the respondents have been served. Four parties are there, everybody has been served.
Yes. You are appearing for whom?
The Reserve Bank of.
So what is your contention?
They can approach the banking ombudsman before filing the case.
No.
Ombudsman will do.
My lord, there is no requirement, my lord. My lord, your lordship has already hold on several other matters.
Ombudsman is having a specific 2 lines.
Yes, my lord. No requirement of that, my lord.
Receive the complaint, closed.
Thing is that the petitioner approached the ombudsman through an advocate.
Oh, my lord, I have in my note, my lord, I have mentioned as many as 10 judge orders, my lord, passed by this honorable court, my lord. Similarly placed parties have got the relief, my lord. Before
Yes, my lord. Your lordship.
The Kerala High Court, even before the Delhi High Court.
The petitioner has filed the present date application praying for a direction upon the respondent bank for freeze the account.
No, defreezing for.
No, my lord, it was initially freeze. Now it is being under operation.
Kindly see the other reliefs, my lord.
No, now at present it is a not freeze.
No. Kindly see.
No, my lord, it is not freeze, my lord. Only the amounts are under.
See prayers, kindly see declared the debit freeze lien of 3,26,000 imposed upon petitioner number. So it is, my lord, a freezing or lien of 3,26,000. I am able to operate the bank account, but an amount of 3,26,000 has been attached
to file and drip. Praying for a direction upon the respondent bank to lien free the account of the petitioner, as the bank has kept an amount of rupees 3,26,000 as on lien. ठीक है? Counsel for the petition submits that initially the bank has kept an amount of rupees 1,63,000 on lien. When the petitioner has approached the bank, the bank has informed the petitioner that on receipt of the complaint from
My lord will see Punjab SAS Nagar.
Punjab SAS Nagar
Kharar.
Kharar
Police station.
Kharar, and on the basis of the said complaint, the petitioner, the bank has kept the disputed amount on lien. Subsequently, the bank has defreezed lien freed the said amount, and again,
no, my lord, that amount is attached twice over.
No, first it was released, no?
No, it was what was released. My operating the bank account. Okay. Initially, it was a full freeze.
No, initially the bank has freezed lien free mat karo. Freeze the account of the petitioner for a disputed amount of rupees 1,60,000. 1,60,000 so?
My lord, they had frozen my account. Then, my lord, upon my representation,
freeze the account for a total.
No, they froze my account altogether. Then, upon my
freeze
representation,
the account on the allegation that the bank has received a complaint from the Punjab SAS Nagar Kharar, wherein the disputed amount was rupees 1,60,000, but the bank has freezed the total account of the petitioner.
Then
subsequently,
my lord, there was a direction upon me to mark a debit freeze, my lord.
Subsequently,
Specific direction was there by the police authorities.
Of the direction from the investigating agencies, the bank has defreezed the account of the petitioner. Again, the cybercrime police authority has made a complaint to the respondent bank, and bank has kept the disputed amount of 1,60,000 in lien, and again the same amount was further kept on lien, that is totally an amount of rupees 3,20,000. 3,20,000. Subsequently, the petitioner has made several requests to the bank authorities, but the bank has failed to lien free the said amount. You are operating the bank.
Yes,
but the petitioner is operating the bank account. But how that can be lien freezed? How the lien?
Because my lord, that is an attachment, my lord.
But unless and until the investigating, it's not been
My
covered.
lord.
No,
So
because
how it can be?
107 says, my lord, they have to have.
That's correct. That's
magistrate's order.
That's why what my order is that I am defreezing the account, but allowing to operate the account, keeping the amount.
No, even today, even if they keep 1,63,000, that's fine, my lord. But they are twice over. They are doing the same
twice
amount,
how it
same
can be?
transaction. Same transaction, my lord. 2 times they have attached. Even we are willing to keep
Then counsel for
1,63,000.
the
It may be
petitioner
recorded.
submit
My
that.
lord. No difficulty.
And counsel for the petitioner submitted. The bank has freezed kept the lien amount of kept an amount of 3,20,000 as lien, but there should be only a disputed amount of rupees 1,60,000.
Yes, sir.
1,60,000. This could find that the petitioner has made the investigation. You have not made a party.
Yes, party work.
Has made the investigating agency as respondent number 3 in the present date application, and the notice has been served to the investigating agency, but in spite of service of notice, the investigating agency has not come forward, nor any report has been submitted. Counsel for the petitioner prays for a direction for lien freeze of the total amount of rupees 3,20,000. This could find that before passing any order for lien free the said amount of rupees 3,20,000, one further opportunity should be given to the respondent number 3 to submit the report whether the said amount is required further investigation or not. the respondent number 3 is directed to submit the report before this court within 1 week or 2 weeks. Within 2 weeks from date, from 2 weeks from the date of receipt of this order. It is made clear that on receipt of this order, if the investigating agency, that is the respondent number 3, will not submit any report whether the said amount is further required for investigation, this court will pass appropriate order. The petition is directed to communicate this order to the respondent number 3, and the respondent number 3 is directed to file the report on the next date fixed, list the matter on the tarikh. List the matter on 3rd September. Within 10 minutes.
Grateful.
Most grateful. Next. Original side.
Hello, your lordship, been pleased to call the original side now from 3 o'clock. My lord, item number 16, the very next matter, the order of blacklisting, which was under challenge. If it could be given some precedence tomorrow, my lord.
16 is the number 1. Now it will tomorrow. It will be up.
Very well. Very grateful. Very grateful.
वो लेके जाएगा.
No.
Yes.
On matter of today's daily list, item number 116. Your lordship, this has substantially been heard by your lordship. I've been led by Mr. managing this matter. Other side was Jishnu Choudhury. Jishnu Choudhury was there, lordship, in this matter. Your lordship, after hearing almost both the sides, due to scarcity of time, their order could not be found. Lordship, kindly fix it at any convenient day, your lordship. Your lordship will finish it.
Fix after puja करते हैं. After puja करी थी 116. कौन सा डेट है? After puja तो फ्री होगा ना? Before my diary is packed. If you want to take the chance, let the matter remain in that.
We don't want to take it.
116 record करो. Record an order. As per the prayer made by the counsel for the parties, let the matter appear on. बीच में है. 24 September. 24 September at 3 p.m. Yes. Call the list.
My lord, I appear for the petitioner. My lord, this is the affidavit of service of all the, my lord, respondents lordship wanted us to serve, as and when they'll be required, they'll be called upon. Except for Mr. Mitro, who was, my lord, the main respondent.
But you have to, again, you have to amend this.
We have.
After the change of circumstances.
I think we have amendment for it. Amendment for it. Amendment. That we have, that order was given, and my lord, we have amended and served on that.
Subsequent to.
Yes, pursuant to my lord's order.
That's earlier, now recent.
My lord, in the recent one, there are nobody in this list.
Sure.
Yes, nobody in the list. Either way, my lord. Neither on this side nor on that side. It was only in the earlier one.
Sudeep Dey?
Sudeep Dev was there. Sudeep Dev was, is already served. So he will be, my lord, not required.
No, but if the name is there, then
his name would be there. Only his name needs to be expunged then.
That's why I'm telling.
Only one name has
Only
to be.
one?
Yes.
No other?
No
You
other.
have to expunge the name.
Mr. Dev, Justice Dev is the only one who needs to be expunged. But at the time when Lordship passed the order, my lord, he was.
He was there.
Yes.
Now that's what I'm telling. Now
Only one name will be required
to be.
Yes, we'll do that, my lord. Now, my lord, with regard
Who
to
is appearing?
Mr.
Mitro is leading me, my lord. He is coming, my lord.
He's told me that he'll be there. Now, my lord, this matter, my lord, pertains to, my lord, the 38 of us. In fact, my lord, sadly, one of us is no longer there. 37 we are now. As lordship knows, Mrs. Banerjee is no more with us. Now, my lord, 37 of us whose names were deferred. Out of them, my lord, the petitioner is one of them. Now, my lord, I straight away come to page, my lord, 40, my lord, 6, which is the first notification of 2018. As now, my lord, this issue has.
So what you have prayed for?
My lord, I have prayed for initially, I am only asking for the records to come before this court.
Now, what is the prayer? Record will sit.
Yes, my lord, kindly comes to the prayer. Lordship has already seen the prayer. My present, my lord, the instant prayer that I asked, which my lord would nobody would be prejudiced, is prayer C, my lord, at page 40. And I'll show, my lord, this is the consistent view of 8 high courts and the Supreme Court also regarding these matters.
What?
That, my lord, the record should be called for before the court, because, my lord, affidavits from their end or my end will not serve the purpose. The records will speak for itself. Records are to be called for before the court. Yes, some courts have made it, my lord, that the respondent and the petitioner will look into the records, nobody else. And other courts have made it public, like Delhi High Court has made it public in nature. So that will be on my lord's discretion. But, my lord, all courts, including the Supreme Court, has taken a consistent view in view of the Supreme Court judgment to maintain transparency that the record should be called for, which will speak for itself.
So what is your ultimate prayer?
My lord, my ultimate prayer, if I, my lord, succeed, is that, my lord, the, my lord, deferment could not have been done, because that's not part of the, my lord, notification even. And, my lord, secondly is that, my lord, the procedure in which, my lord, the first one was done, it has to be the same for the second one, because, my lord, it is the continuation of the first one. And I am not against, my lord, getting rid of everybody at the present moment. I don't want that, because that's not the idea of the petitioner also. Because that is exactly what has happened in the high courts, my lord, is that once the records are called for, they have all been, my lord, provided with the, my lord, the issue which is before my lord. Because the records will speak for itself. I cannot change the records, my lord, nor can Mr. Mitro.
Oh, I appear for one of the added parties. I also appear for some of the added parties. One of the added parties. Lord, there is an issue of maintainability.
That's why I'm asking if any issue of maintainability, then first I will hear with regard to the maintainability. How many set of lawyers are appearing?
I am appearing for at least 7 or 8 added response.
8. I appear for 1.
And I will give the details of the respondents.
My main respondent is the administration, my lord. I am not against, my lord. Lord, she wanted them to be made a party to be heard. If, my lord, the question, my lord, is with regard to setting aside of the entirety.
The designation, Lord, was awarded to 80 of the advocates. 81. Now, Lord, this 81 designation was not an issue insofar as my learned friend is concerned, because, Lord, the representations that he made was in respect of the rest. So, Lord, even in the representations that he made, Lord, there was no issue raised with regard to
your appointment.
The designation being awarded to 81.
Perhaps that is why Lordship had said that if required, I'll call for the other respondents. Just serve on them.
If the writ petition is limited to, my lord, the disapproval, then, my lord, we have practically nothing.
That is exactly what we have stated, my lord. That is why Mr. Mitro was asked to talk to the, my lord, Chief Justice.
The problem is that
the Lordship can take the prayers. The Lordship will find from the prayers that not only the disapproval, but also the decision regarding my designation of the advocate.
That's what I'm telling.
But that is only, I made it very clear at the first instance, that is only once Lordship sees from the records like other high courts, my lord, of the Supreme Court, that there is any discrepancy. There is any discrepancy. That is subject to, my lord, seeing the records. I am not pressing, otherwise I would have pressed that on the first day. I am not. Because I am saying, my lord, that the records will speak for itself. And, my lord, I am only on the issue, my lord, today, that let the records be brought before the Honorable
I am also, Lord, of the, I want to take the point that, Lord, the decision of the full court is not, Lord, justiciable.
Yes.
This is the decision of the full court is not justiciable. There are two different stages. One is, Lord, the selection committee. Then, Lord, selection committee places the matter before the full court. And
it is absolute discretion of the full court. That's how, Lord, the latest Supreme Court judgment says. And Lord, that is not justiciable. That decision can't be challenged. If, Lord, on the first point we are deleted, Lord, then of course, I don't want to.
In fact, my lord, I had never made them a party. It was my lord's wish to make them a party.
Just adding what was submitted. My lord, we are concerned with Rule 82 of the Calcutta High Court Senior Advocate Rules. If we take Rule 82, it is selection by simple majority, which means voting. My lord, a decision taken by voting can never be justiciable. It is voting, yes or no. And even, my lord, provision has been made in the rule that it can be by a secret ballot, but it can be avoided. So, my lord, so we are on, my lord, so far as, my lord, the disapproval is concerned, my lord, my learned friend can definitely, my lord, we will not stand in the way. But, my lord, if my learned friend insists that the records of, my lord, 26/11/2024 that are also required to be produced, then obviously, my lord, your lordship would kindly, subject to your lordship's kind consideration, would hear us on the point of demand.
No, that's why if you all wanted to argue the matter on demurrer, then I will hear first the respondent. First the respondent. If you will say no, you will not, you will go and give the answer.
My lord, may I just make it once more clear, my lord? Lordship will remember, my lord, they were not made parties to original
That's
petition.
correct. That's correct. They are not
Lordship made them parties.
because this court has made a party.
Yes.
Because we don't know what would.
Now, my
be
lord,
the
may I just indicate? May I just indicate
neither,
what?
neither myself nor you.
Correct.
We don't know what
Correct.
would be the result.
Now,
so if the result will go against, that's why that precaution, that is the first precaution the court has
may
to
I
take
just, my
whether
lord,
the
help
affected
that out,
party.
my lord? May I just help that out also, my lord? Mr. Mojumdar is saying, my lord, if the records of the original meeting is called for, then he has something to say. But, my lord, I have said on the first day itself, and that's my lord, pleadings also, that the first records are being called for due to the reason to show that there could not be any deferment. My lord, that perhaps, my lord,
rightly, wrongly, whatever, there is a deferment.
Yes.
Correct. First initially 81, thereafter subsequently what are the remaining was deferred, and deferred the next meeting, the candidature of the deferred candidates have been taken into consideration. None of the persons have been considered for designated as senior.
Grateful.
Correct. This is the main issue. Now you have a two issue with regard to the deferment on what ground. Second, if the deferment on what ground. Second, if the second stage when the meeting was taken up, on what criteria has been taken into consideration for not giving.
Correct, madam. So my simple issue is that the criteria which was for all, where Mr. Mojumdar's client is there, should be the criteria for myself also. I mean the petitioner also. That is all. So that in no way prejudices the rights, my lord, of the original who have been conferred.
Then in that event, my lord, subject to lordship's kind consideration, well, since my learned friend is insisting that the records of the first meeting, I mean the meeting regarding designation of seniors, which should be called for. In that event, my lord, kindly hear us on the point of view.
No, I am also not with regard to the call for the record. If you want to argue the matter without the affidavit, then I will hear the matter. If you want that this writ petition needs to be decided on merit after the affidavit, then the affidavit does.
But only thing is this, my lord, if affidavits are called for, it can always be called for. But my lord, the affidavit will not improve the case. It is the records will speak for itself, and that is exactly I'll show the judgments also.
Okay, in that case, you argue the matter on merit.
Yes.
I will hear the matter.
My lord, let them argue on, my lord, the demurrer point first, my lord. Let me hear him.
No, their demurrer point if the record is called for.
Yes.
So I am making it
Very
clear
well. Let me, my lord, argue.
I am making it clear at this stage, this court is not going to call for any report. If you want, you argue the matter. If this court find that yes, for taking decision, record is required, then automatic.
Then, my lord, I would also argue, my lord, why the records are called for. Why is it required? Now, my lord, kindly sees, my lord, the petitioner before my lord is a candidate, my lord, who was, my lord, called for initially in terms of page 46. Initially, my lord, in terms of page 46, by a notification, my lord, of 12th of July 2018.
Yes.
My lord, kindly takes page 46 once more.
Yes.
Now, my lord, herein, lordship will find that, my lord, clause 4 states, my lord, that the Chief Justice shall constitute a permanent committee to be known as Committee for Designation of Senior Advocates.
Correct.
Now, I'll show, my lord, today the Supreme Court says, my lord, that this committee is gone.
Yes.
No committee is to be formed now. Then, my lord, kindly sees 5. The permanent committee will be headed by the Chief Justice, 2 senior-most judges of the High Court and Advocate General for the state of West Bengal. The above 4 members of the permanent committee will nominate a member of the bar who himself is a senior advocate to be the 5th member of the permanent committee for a term of 2 years. So this is how the committee is formed, my lord. Now, my lord, will kindly come to straight away, my lord, to clause 10, the next page. All matters relating to designating of senior advocates in the High Court shall be dealt with, this is very important, shall be dealt with by the permanent committee. Then, my lord, 12, the honorable judges of the High Court may in writing propose names of learned advocates regularly practicing in the High Court to be designated as a senior advocate. Now, my lord, the petitioner before my lord is a candidate who was, my lord, referred to by a senior judge of this honorable court. Then, my lord, kindly sees 13. On receipt of a proposal from the honorable judge, the secretariat through its secretary shall inform the advocate of the proposal of the honorable judge and seek his consent for consideration of his name for being designated as a senior advocate. In case the advocate consents to have his name considered.
Before taking the matter on merit,
yes,
any of the parties are having any objection taking by this court the matter?
Oh, no.
No, I am taking because.
And in fact, that has been cleared also by a judgment also. 2 judgments, one of this High Court and one of Allahabad High Court.
Even though, because it is.
Perhaps Mr. Mitra also has never said.
Yes.
Yes. Now, my lord, kindly sees 13. On receipt of a proposal from an honorable judge, the secretariat through its secretary shall inform the advocate of the proposal of the honorable judge and seek his consent for consideration of his name and being designated as a senior advocate. In case the advocate consents to have his name considered, the secretary of the secretariat shall request the advocate, the word is request, my lord, request the advocate to furnish the particulars in a prescribed pro forma with supporting documents and a declaration in the pro forma described herein under duly filled up. So, my lord, 12 and 13 are the, my lord, crucial issues, my lord, of the clauses by which this candidature was selected.
First is the proposal, then the candidate.
And he gave consent.
Correct.
When the secretariat had asked for.
Correct.
Now, my lord, kindly sees 14. On receipt of the application in the prescribed pro forma in either cases, the secretariat will compile the relevant data information with regard to the expertise, reputation, conduct and integrity of the advocate concerned, including his or her participation in pro bono work, reported and unreported judgments of matters in which the concerned advocate had appeared, and my lord, this is very important, and actually argued, evincing formulation of legal points for answer by the court as evident therefrom, and the number of such judgments during the last 5 years preceding the application submitted in the pro forma. So, my lord, admittedly, he has to argue matters and not assist. Then, my lord, will kindly see the, my lord, criteria which would, my lord, not enable him to, my lord, apply is that kindly takes, my lord, 14B. Secretariat shall collect information, data in respect of the applicant advocates from the following sources. Bar Council, D, I am showing, my lord, Bar Council of West Bengal as to whether, my lord, any proceedings are pending. Police authorities with any criminal proceedings pending. And, my lord, civil courts in regard to civil proceedings. So, this, my lord, the data they would, my lord, procure. Then kindly comes to 15. The Secretariat shall publish the proposal of designation of advocate in the official website of the Calcutta High Court, inviting suggestions, views from the stakeholders within 2 weeks From such publication, the suggestions, views of only those stakeholders who disclose their identity and addresses would be considered as valid. So, my lord, first step is that if there is any complaint, his name would not be suggested or considered. Once he crosses that, then, my lord, his name would come in the website, and, my lord, stakeholders with names have to oppose. This is a candidate, my lord, who went through all this and his name was published. Then, my lord, the marking system is stated in 18. Very important, my lord, kindly comes to, my lord, 19 and 20. All members of the permanent committee shall provide separate marks in individual score sheets, and the marks of all the members should be compiled by the secretariat to calculate the percentage of marks secured by each of the applicant advocate. So, my lord, the compilation of the mark would add up to the percentage that he has obtained. And, my lord, 20, only those advocates who secure at least 60 marks. This is very important because, my lord, in the next notification, I'll show that this has been reduced. 60 marks shall be designated as a senior advocate. However, in a deserving case, for favorable consideration, the permanent committee may relax the benchmark of 60 marks up to a maximum of 10 marks and designate an applicant advocate as senior advocate. So it can come down to, my lord, 50. Then, my lord, kindly takes, my lord, 22. Names of advocates cleared by the permanent committee shall be placed in the meeting of the full court. Upon considering, the full court will take a final decision by 2/3 majority of the total number of judges present in the full court. So, therefore, my lord, there has to be a final decision taken by 2/3 majority, not by any other means, my lord. And then, my lord, kindly sees, my lord, 26. All cases that have been favorably considered by the full bench may be reviewed, reconsidered after expiry of period of 2 years following the manner indicated above, as if the proposal is new. Now, my lord, this was the, my lord, initial, my lord, gazette notification which came out. Apropos that, lordship kindly comes to page 52. This is, my lord, the notification which came out on 25th of July 2018, where, my lord, invitation is given, those who want to apply. Then, lordship, my lord, will come to page 53, wherein, my lord, I have enclosed the original, my lord, letters copy, but I have, my lord, particularly blurred the name of the honorable judge. My lord, this was the, my lord, recommendation sent in my case of the petitioner, which is at page, my lord, 53. And then, my lord,
53.
53, yes. My lord, I have particularly, my lord, the name I have not put in there. Then, my lord, kindly comes to page 54, which is 31st of July 2018, where I give my consent. And accordingly, my lord, after, my lord, the 2 steps that there are no proceedings against me, no complaints against me, my lord, my name comes out in 2018 list, which starts from page, my lord, the next page itself, my lord. And, my lord, my name is there, lordship will find at, my lord, my lord, page 62, item number 55. My lord, I should not call item number as the lawyer, my lord, with serial number 55. Page 62, my lord.
Yes.
Now, my lord, this went on. There were proceedings filed against this notification, and ultimately, once the proceedings were, my lord, disposed of, lordship will kindly come to page, my lord, 65, wherein the present notification comes in. My lord, this is dated 27th of July 2023. Now, my lord has seen that in the earlier notification also, there was no question of deferment. No rules, my lord, which framed was that it can be deferred. Now, my lord, kindly comes to 27th of July 2023. Now, my lord, this kindly sees records the writ petition number that has been disposed of in the first paragraph, and then lordship will kindly come to, my lord,
clause 3, my lord, at page 66. The Chief Justice shall constitute a permanent committee to be known as the Committee for the Designation of Senior Advocates. Again, the same. The permanent committee shall be headed by the Chief Justice. It shall include 2 senior-most judges of the High Court, the Advocate General. The above 4 members of the permanent committee shall nominate a senior advocate from the bar to be the 5th member of the committee, and the committee shall have a term of 2 years. So, my lord, this was identical to the earlier one. And my lord, only thing is that, my lord, the term was fixed for 2 years. That's my lord 2, my lord 3, subsection 2.
Yes.
Now, lordship will come to the changes that come into clause 5 at page 67. These are the changes which comes in, my lord. If the Chief Justice or any other sitting judge of this court is of the opinion that an advocate, by virtue of his ability, standing at the bar, or special knowledge or experience in law, is deserving of such distinction so as to be designated as senior advocate, the Chief Justice, the judge, may, in writing, recommend not more than 3 names of such advocates. So, my lord, now there was, my lord, no restriction. Here, not more than 3 names for being considered for designation as senior advocate. Such recommendation shall be submitted to the Secretariat. No judge shall make more than 1 recommendation within a span of 3 months. So this was also included, which was not there in the last notification, my lord. Then, my lord, kindly comes to 2. No person shall be eligible to be designated as senior advocate unless he is ordinarily practicing and actually argued cases in the High Court at Calcutta or its circuit benches and or courts subordinate to it, including tribunals within its jurisdictional territory, for not less than 10 years preceding the last date of submission of his application for designation as senior advocate. So, my lord, he has to argue and he has to have a practice of 10 years. Kindly now, my lord, kindly comes to 2 Roman 3, which is at the bottom of that page. The permanent committee and the full court shall take into account the caliber, merit, ability, and academic distinction of the advocate concerned, including his character, conduct, and behavior towards the court and other members of the bar. So, therefore, my lord, if there is something, then that has to be included as to how he is ineligible. Because, my lord, the notification points out about his character, conduct, and behavior towards the court and other members of the bar. Not that, my lord, I don't like somebody and I can be deleted. Now, my lord, kindly comes to, my lord, next page 68, kindly takes, my lord, 7.1. On receipt of the application as prescribed in Appendix A, in either cases, the Secretariat shall compile the relevant data and information with regard to the expertise, reputation, conduct, and integrity of the advocate concerned, including his participation in pro bono work, reported and unreported judgments of matters in which the concerned advocate has appeared and actually argued the case, and the number of such judgments during the last 5 years preceding the application as submitted in the pro forma. So again, my lord, he has to argue the case and not assist. Clause 3, my lord, sets out 2 weeks' time, my lord, for any objection to come in. Now, my lord, will kindly come to clause 5 at page 69. After receipt of the suggestions, views of the stakeholder, the Secretariat shall compile all information, data, views, suggestions of stakeholders, and also the information directed to be collected by the permanent committee, and put the same before the permanent committee for scrutiny. Now, my lord, there is a change here. Earlier, lordship has seen, my lord, after gaining all the information with regard to my any proceedings pending or not, my lord, it was put in and stakeholders were invited. Here, stakeholders' consideration is also made and then put before the permanent committee. So once my name goes, my lord, I am through. Even there is no, my lord.
2 steps you have cleared.
Yes. Grateful, my lord. Now, my lord, kindly comes to clause, my lord, 7. All members of the permanent committee shall provide separate marks in individual score sheets and the marks of all members should be compiled by the secretariat to collect the average percentage. It remains the same. And 8, my lord, only those applications, this is very important, my lord, who have secured the cutoff mark as decided by the full court shall be designated as senior advocates. So, my lord, the cutoff marks, my lord, has to be, my lord, maintained. They cannot be a candidate, my lord. That is why, my lord, as far I'll show the judgments also, my lord, why the records are called for. They cannot be a candidate who is below the cutoff marks. And I'll show the Supreme Court judgment also, my lord, that transparency is the epitome, my lord, of this procedure. So, my lord, two things are there. There must be a cutoff marks, and, my lord, nobody can be below the cutoff marks.
Once the cutoff mark fixed, it cannot be below the cutoff mark.
Correct. Correct. Now, my lord, therefore, my lord, there has to be a cutoff marks, and, my lord, nobody can be below the cutoff marks. Now, my lord, kindly sees. Now, kindly sees, my lord. If any of the information supplied by the applicant is found to be incorrect and or misleading, his application shall not be considered. Now, my lord, kindly sees, my lord, very important 8 as I read out. Those who obtain the cutoff marks, their names would only be considered by the full court. So, my lord, 3 things then. My lord, 1 is that there has to be a cutoff marks, because that is very important. 2 is that, my lord, the cutoff marks has to be obtained by the person who is being designated. And 3 is that, my lord, those whose cutoff marks are, my lord, above the cutoff marks, their names can only be referred to the full court and not anybody else. So
first is the cutoff mark.
First is the cutoff marks.
Yes. And cutoff mark persons is to be considered.
Second, my lord, is thirdly is that, my lord, the full court will only consider those who have obtained above the cutoff marks.
Yes.
So 3 things has to be, my lord, followed.
Yes. So below the cutoff mark cannot be considered.
Cannot be considered. Most important. Now, my lord, kindly sees 8. Very important. All the names of the advocates with the points awarded by the permanent committee shall be placed in the meeting of the full court. Upon consideration, the full court shall take a final decision in simple majority. So, therefore, my lord, 2/3 majority is no longer there. This is the change. Simple majority of the total number of judges present in the full court. The quorum shall be at least half the total strength of the judges in the High Court. So, therefore, my lord, there has to be a minutes where this is recorded. That, my lord, the number of judges who are, my lord, there present in the full court, and, my lord, the strength by which the simple majority this has been allowed. Now, my lord, kindly comes to, my lord, rest are not, my lord, important. Yes. Now, my lord, kindly comes to 5. The final decision of the full court shall be communicated, my lord will kindly see the word, applicants. So this includes all who may be, my lord, given and who may not be given. It does not distinguish, my lord, that who has been conferred.
Yes.
The final decision of the full court shall be communicated to the applicants individually. In case of these 38 people, now, my lord, as I sadly said, my lord, 37 of us, including, my lord, Mrs. Banerjee also, none of them were, my lord, intimated post this particular, my lord, resolution. Nobody was intimated. It was only intimated when, my lord, in December after a year. Now, my lord, kindly sees one more thing, my lord, is very important.
No, when the senior designation notification was issued?
It was issued in November 2024.
November 24. That is the before deferment, after the deferment.
In that only it was deferred.
Deferred.
But no applicant was intimated.
Before deciding the deferment persons, they have been notified. They have been notified. And subsequently, after a year, you have got the deferment.
That also I'll show could not have been a year because it says only 4 months.
No, I am telling
Yes,
you, after 1
yes,
year,
yes.
the deferment case has been taken, and deferment person's names have been considered and not considered for the designated senior advocate. And when
This came in December 2025.
And when the meeting was held,
I think, my lord, my lord, a few days prior to that only. Whereas it was 4 months. I'll show that, my lord. Now, my lord,
ডিপার্টমেন্টের থেকে বড় কথা হচ্ছে যারা থাকবে না এখানে, যারা এখানে থাকবে না তারা থ্রু দিতে দেবে, কিন্তু ওই যে পরে যে প্রসিডিউরটা করলো, যেটা আমাদের রিজেক্ট করলো, সেখানে বললো কি না কারা কারা ফেভারেবল কমপ্লিট।
Now, my lord, kindly takes, my lord, 3 and 4 once also. The judges who are on duty but not on principal seat of the High Court may express their opinion via video conferencing in full court's meeting, or send their opinion in a sealed cover or through the email of the Chief Justice, and the same shall be presumed to be voting as a person present for voting. So this proves, my lord, there has to be a minute. There has to be a minute, and there has to be, my lord, decisions given either in by email or by sealed cover. Now, my lord, 4. All cases that have not been favorably considered by the full court may be reviewed, reconsidered after the expiry of a period of 2 years from the date of publication of the notification designating the senior advocates. Such review reconsideration shall be on the basis of fresh application received pursuant to the notification issued under Rule 6(1)(a) or proposal under 6(1). But, my lord, there is no clause by which it could have been deferred. And this is the issue. Why, my lord, the Delhi High Court deferment was remanded back by the Supreme Court, and now all of them has been allowed. There is no clause, my lord, which says that, my lord, there could have been a deferment. The only clause which suggests, my lord, is that you reject me or you review me, which you will review only on a fresh application after 2 years. Yes. So therefore, my lord, in this particular, my lord, notification, there is also no clause which says that it can be deferred. So, my lord, no deferment, and I should have been, as a petitioner, my lord, I should have been individually informed, which also was not done. Now, my lord, kindly comes to, my lord, the residuary, my lord, clause, that's at page 71, which is, my lord, clause number 13. My lord, how I came into this new, my lord, application, because I was a continued candidate. I'm not a fresh candidate under this notification, my lord.
Yes.
My lord, kindly sees. Kindly comes to 13. For pending proposals, applications available to the Secretariat for the designation of an advocate as a senior advocate, the advocate concerned shall resubmit their application online under present pro forma Appendix A with soft copies of the documents submitted. Such candidates shall have the liberty to update or replace their applications within a stipulated time determined by the permanent committee. So, my lord, I, as a petitioner, was a continued candidate. I wasn't, my lord, a candidate who came afresh. And I was given the liberty because we were, my lord, given a special number who were continued candidates. Now, my lord, kindly comes to, my lord, 16, very important.
So what benefit you will get here?
My lord, only thing is that I will get a chance of, my lord, making my profile better, because I have already reported judgments from 2018, and my lord, the ones that I have new, I can add on. So that's the only advantage.
So this residuary pending, okay.
This is only for candidates who were there in 2018. Correct. This does not apply to the new candidates. Now, my lord, kindly comes to 16. On any questions relating to the interpretation of these rules, the opinion of the permanent committee shall be final. And it's not, my lord, stated that the full bench will be final. Kindly seize, my lord. So this allotment of marks, which was there earlier, is no longer there in the new one. Whatever permanent committee sends, that is sacrosanct.
Correct.
So marks given by the permanent committee in the earlier one could have been, my lord, reduced by 10, and my lord, from 60 it could have been 50. Here in this notification, that rule or that clause is taken away.
Correct.
And it is decided that, my lord, the permanent committee's opinion shall be final. So if, my lord, a candidate gets a marks of, my lord, 50 or 40,
Where from
my lord kindly takes, my lord, 16, interpretation of rules.
Yes, only question relating to the
Any question on any questions relating to interpretation of these rules, the opinion of the permanent committee shall be final.
Correct.
So, my lord, the permanent committee, my lord, therefore is not, my lord, it's not a, my lord, body, my lord, which is only collating, my lord, my candidature, but it is, yes, that is exactly what
they have to take a decision. They have, then matter is to refer to the full court.
But the full court,
for
my lord,
approval.
yes, but the full court, my lord, in the earlier decision or in the earlier notification, my lord, could have, my lord, reduced the mark, the cutoff mark.
10%.
Here, my lord, there is, my lord, no reduction, my lord, which can be done. Whatever marks the full court, my lord, the permanent committee has given, that is exactly what is to be looked into.
Correct.
So no relaxation.
So the in your case, the petitioner's name is of 2018. Correct. 2018. And the mark, but the mark was in the permanent committee along with the all persons.
Yes. Yes.
Persons. So
Yes.
the question of again reduction will not.
No, my lord, perhaps this I must clear. Initially, when the notification of 2018 happened, my lord, there was no, my lord, permanent committee which could not work. There was a permanent committee form, could not work because of the court orders.
Correct.
It was only now that the permanent committee worked and, my lord, gave the marks.
Correct.
So, my lord, it was with all candidates.
Correct.
So, my lord, initial notification said that let us take, he had got 60.
Correct.
But, my lord, considering overall, my lord, it could have been reduced to 50. But
10.
here, whatever permanent committee gives the mark, my lord, it is, my lord, sacrosanct.
Correct.
No full court will, my lord, have the right to reduce it.
So there is no benefit to you. Because
I am not on benefit. I want, my lord, equality.
Equality.
Never on equality.
Equality. So here it is not your case. The earlier permanent committee has given the marks.
No.
That this is not.
I am on this notification.
Correct. This notification, his name has been considered along with the other persons.
So, my lord, if I have got, my lord, a marks which is given by the permanent committee, then, my lord, the consideration cannot be of a marks which is below me, which can be, my lord, increased, or, my lord, my marks can be reduced.
Okay.
I am on that.
Got your point. Yes. So next.
Yes, my lord. Now, my lord, kindly comes to, my lord, my candidature. My lord, kindly comes to page 79, which is, my lord, the new, my lord, the application which I have to do with the old number, which is at page 79. And, my lord, my number is, UID number is at page 80, which is more clear, my lord, at page 81. My lord, if your lordship sees the last heading, the UID number 000059, that's the unique identification number which I, my lord, gained from the earlier application.
Yes.
Now, lordship will kindly see, apropos this, a list comes out. I clear everything, page 83. My lord, which is at page 83, 19th of January 2024. And, my lord, my name figures at page 85, my lord, serial number 58. 58, my lord.
Yes.
Now, my lord, my reported judgments and all, my lord, the list are enclosed. Very important thing, what happens is, kindly comes to page 100. My lord, this is why I say why transparency has not been maintained. And, my lord, there is no equality.
Page 95.
Page 100, my lord.
Yes.
In directed to inform that phase, this is sent on 26th of September 2024, at 1:03 p.m. In directed to inform that phase 1 of the interaction process for the ongoing senior advocate's designation has been scheduled for today. 31 learned applicant advocates have been requested to report before the committee today at 1:40 p.m. Additionally, please be informed that all remaining applicant advocates who have duly completed necessary formalities be contacted for a similar interaction process in subsequent phases. You will be notified of your scheduled interaction in due course as decided by the permanent committee for designation of senior advocates. Now, my lord, this pick and choose is not part of the rules.
Why?
There is
Why you telling the pick and choose?
Because, my lord, only 31 candidates have been called for.
Maybe part by part.
I'll come to that, my lord. There was, my lord, a protest made on the same day. On the next day itself, all were called together. So, my lord, that is why I say that, my lord, this 31 was only called on that day and nobody else. Out of, my lord, 140 candidates. And there was a protest made from the bar, in view of which on the next day, my lord, the remaining entirety was called. So, my lord, first thing is that, my lord, I would have understood phase wise. But, my lord, why 31 and on the next day, all of them? I would have understood phase by 7 days, my lord, they would have called. That never happened.
What it help you?
My lord, there is
help you.
No, it does not help me in the sense that I do not wish to, my lord, show something else, but to show that, my lord, the touchstone is equality and transparency of this process.
So, my lord, if it is not that the next day they call all and all have not present but considered, that is not the case.
My lord, the next day, upon a protest being made, my lord, all of them are called together. So I would have understood, my lord, that there was a phase manner, 31, 31, 31, 31. Fair enough. My lord, one can be called earlier, one can be called later on. But this 31 and then the rest, that is, my lord, perhaps, my lord, shows that equality not being maintained. Now, my lord, kindly sees, my lord, 102 is, my lord, is the notification which comes out on 26th of November 2024.
This is the selected.
Now, my lord, kindly sees, not only selected, kindly sees the first paragraph. In exercise of the powers conferred by 16(2) of the Advocates Act 1961, read with High Court at Calcutta, designation of senior advocate rules 2023, the Honorable Chief Justice and Honorable Judges of the High Court of Calcutta have resolved in the full court meeting held on 21/11/2024 to designate the following 81 advocates as senior advocates with effect from the date of this note, and deferred the selection process of the remaining 48 applicant advocates till the next full court meeting scheduled to be conducted. My lord, will mark two things, deferred and 2nd of April 2025. So by 2nd of April 2025, my lord, this meeting should have been held. And my lord, as I showed, there is no clause which could have deferred the, my lord, 48 candidates. My lord, the rules have to be followed in toto. Either you reject me or, my lord, you have to, my lord, accept me. It is deferred and also the 2nd week of April 2025. My lord, kindly considers this is all after cut-off marks being considered. All of the 48 and majority. Now, my lord, kindly sees what happens after that. My lord, I made, my lord, a representation at page 109. My lord, immediately on 2nd of January 2025, for, my lord, certain, my lord, information to be given under RTI, which was not given. Appeal preferred. The appeal, my lord, directed, my lord, that, my lord, representations made should be considered and given.
Now, where is the RTI application? 109?
Yes, my lord. Kindly sees, my lord.
When is the appeal?
106, my lord. Sorry, 106, my lord.
106 is the RTI.
Yes.
Yes.
This is the question.
And my lord will kindly find my lord, I have raised all these issues in fact. And then my lord, I have also raised the issue, my lord, page 107 L and M. What documents were on record which resulted in deferring the 48 applicants who were otherwise entitled under the rules? Then my lord, I at page 107, what was the cutoff marks decided by the full court to designate the senior advocates from the list of the total number of applicants? And what was the marks, my lord, J, obtained by all the applicants individually? So, my lord, this would show from the records itself as to how, my lord, the rules have been followed and where, my lord, it has not been followed. Now, my lord, kindly comes to, my lord, the order, my lord, I am not taking the RTI orders because that is a separate fora, my lord, where it should be, my lord, gone into. But 112 way, lordship will find the appeal was allowed and the deputy registrar was, my lord, directed to give reply to the applicant, my lord. Page 112 capital A, that's a better copy, my lord, the last paragraph.
যে আমরা বলেছি কাট অফ মার্কস কত জানো ফার্স্ট জিটা পড়ানো
112.
Yes, madam.
Directed to give reply to the appellants. Yes.
appeal allowed but till today not given.
And it has not been given till date. Now, my lord, since, my lord, it did not take place within July 2025, so, my lord, a letter was written not by the petitioner but by other, my lord.
What has happened to after this order?
My lord, after this order, my lord, it has not been given, and I think they have preferred, my lord, before the, my lord, forum in New Delhi, my lord. They preferred it before them.
No, at page 113, the reply.
No, it was not given. That's what it's rejected. So against that, my lord, they have, my lord, the preferred the, my lord, proceedings before the forum which is there in New Delhi, my lord, and I think from there it goes to Delhi High Court, my lord. My lord, that I said, my lord, 113 records the rejection. And against that, my lord, it's a public document. Still then, he has given some reasons as to why it cannot be given. Although other high courts have disclosed it, 8 high courts have disclosed it. Supreme Court has directed to be disclosed. Delhi High Court had made it public recently, my lord. But be that as it may, it has now been challenged there. Now, my lord, kindly comes to, my lord, page 117 and kindly sees the date. My lord, on 3rd of September 2025, my lord, one of the candidates, who is not a petitioner, my lord, requested convening of the meeting. Because, my lord, long was the date of April 2025, which has passed. Even after receiving this, my lord, no steps were taken. So again, my lord, in 119, the same candidature wrote a letter on 20th of November 2025. No reply given to either of the letters, nor, my lord, any, my lord, meeting held. Now, my lord, at page 122, lordship will find, my lord, a letter given by most of the candidates, my lord, which is dated, my lord, 12th of December 2025. So, April, we are in December 12th, my lord, 2025, where we raise these issues, my lord. My lord, kindly takes, my lord, page 122 towards the middle, my lord. The criteria which would disentitle the applicant are as follows. As on the date of filing of the application, whether the said applicants had any complaints filed against him before the Bar Council of West Bengal, whether there was any criminal proceedings pending as against the applicant as on the date of his application, whether any stakeholder, namely the President Secretary of the respective bar, including the Advocate General and the Additional Solicitor General, has filed a written complaint as against the applicant on the date of his filing of his application. Therefore, if the applicant had any of the aforesaid documents against him, would be straightaway to be disentitled as a senior designation from this honorable court. admittedly, none of the 48 applicants whose candidature was considered on 11th of December 2025 had any aforesaid disentitlement. In fact, most of them who had their cutoff marks of 40 and above fulfilled all of the aforesaid criteria which entitled them as a senior designation, just like the other candidates who were given the same in terms of the meeting held on 21st of November 2024. Now, my lord, kindly comes to the next page. Therefore, on 11th of December 2025, the procedure for granting the senior designation could not have been changed. To a new one, since the selection process of the designated senior advocate was a continuation of the earlier meeting dated 21st of November 2024. So, my lord, here 11 December it was rejected. So, my lord, that was on the ground that it is deferred. My lord, it wasn't rejected. I stand corrected. It was deferred. So, my lord, there is no rejection. So, if there is no rejection, my lord, then, my lord, there cannot be a subsequent rejection, because deferred means, my lord, I qualify. But maybe, although that's not there in the rules, that's my first preliminary issue before my lord, could not have been done. But maybe the full court thought that on a subsequent date, we will consider them, my lord, and would provide them. Now, my lord, therefore,
consider, provide, because see, total one, whatever the total, the 80 candidates' name has been considered and designated, and further 48 has been deferred to consider. So it cannot be presumed that it will be allowed.
First of all, my lord, is that the question is that, my lord, deferment was not there in the rules. Firstly.
That you are.
Secondly, my lord, if I am deferred, then, my lord, I am considered on that day.
Correct.
So if I am considered, I am eligible with the others. I could not have been considered, my lord, in isolation.
No, because if only that serial number it was considered and that serial
Let
number
us
has
take,
not
my lord.
considered.
No,
What
no,
will
no.
happen?
All serial numbers were considered. That is not the case of anybody, that all the 140 candidates were not considered on that date. Everybody was considered on that date. On the date, my lord, when the initial, my lord, notification came in.
Okay.
That has not happened.
It is not the case. If it is someone, suppose there are 120 candidates.
Yes, ma'am.
Correct. 120 or 130 candidate, whatever it is. It is not the case that yes, serial number 1 considered, serial 10 considered. It is not the case.
Correct.
It is serially whatever the serial list. It is your case as per the case you made out, and as per the list, the serially it was considered.
All 140.
140. Not 140. Serially it was considered till the 80. It was decided.
No. That is nobody's case.
That 80 to 45, 48, it was deferred.
No, that is nobody's case.
Then you read, then kindly come to the page 102.
Yes, my lord, kindly comes to 102. That is nobody's case, my lord. It is said that it is
Come to
deferred.
102. Deferred the selection, remaining 48. So remaining 48. So if it is considered, why the decision not been taken? That's why the 48 applicants had to till the next. So your candidature has not been considered on that day. So it was deferred.
No.
Read.
Kindly sees, my lord.
Read.
My lord, kindly sees, my lord. Kindly sees, my lord, the Honorable Chief Justice and the Honorable Judges of the High Court at Calcutta have resolved in the full court meeting held on such and such to the designate the following 81 candidates as senior advocates with effect from the date of this notification.
Correct.
And deferred the selection process of the remaining 48 applicants. Now, my lord, if that be so, my lord, the next my lord, box gives the answer. Kindly comes to the box.
Yes.
Serial number 1 is not considered. How can that be, my lord? Serial number 1 is not considered. 2 is true and 3 is considered. 5 is not considered.
Correct. What I am telling. Correct. What I am telling. See, you are having the list is there.
Yes, my lord. I have it with me.
List. Where is the list?
My lord, that list is at page.
Only come to the page 80, 83.
83.
84. 84. Correct.
Yes.
84. So now number 1 was not considered.
Yes.
Correct. Then 2, 3, 4. It was serially. It was went. Serially it is went.
Yes.
Serially it is went, and it was up till 80.
No, my lord.
Whatever it may be, still it was till which name it was considered.
My lord, let me show. 1 was not considered. 2, 3 considered, 4 was not considered, 6 was not considered. Then, my lord, 8, 9, 10, 11 considered.
Correct.
Then, my lord, kindly sees next page. 12 was considered, 13 not considered.
Correct.
Then, my lord, 21 considered,
17, 18.
17, 18 not considered,
Correct.
22, 23, 24 not considered.
So
Now, my
no,
lord,
no, then you come to this 48.
yes,
This 48 not within this 104, 130. This 48.
they are
not
all
within
within 140.
140.
Yes.
After 130.
No, not after 130. They are all 1 to, my lord. Whoever is not considered goes into this 48. Whoever is not considered goes into this 48. So let us take item number 1. He is one of the candidates in 48. নাম ধরে কি হবে? তুই চুপ করে বস না। My lord, kindly sees, my lord.
Page 84.
1 is not considered. He is one of the candidatures in page 40, in the 48. That's exactly what I'm saying. How could this happen? So therefore, my lord, 3 is not considered. Let us take, my lord, as I saw there, see, 4 is not considered. He is one of the candidates in 48. How can that be considered? Now, my lord, I am 58. Lordship, so I was 58. Now, my lord, kindly takes, my lord, 103. My lord, 55 is considered, 56 is considered, thereafter 60 is considered. So how can there be this pick and choose? I would have understood what is falling from, my lord, 1 to, my lord, 80.
That's what I'm telling. That's what I'm
I
telling.
would have been grateful in that case.
That's what I'm telling.
1 to 81
Okay.
considered.
Okay.
So, my lord, there is a pick and choose which is made. So, my lord, there cannot be said that I was not considered on that day. I was considered, and that is why I am calling for the minutes, my lord, which will speak for itself. I was considered and I was deferred, which could not have been. Now, my lord, the issue is that
Yes.
Now, my lord, the issue is that, my lord, therefore I am considered. I also, my lord, qualify. Because otherwise, on that day itself, I would have been rejected. But, my lord, I am deferred, which could never have been. This is very important. I am considered, I qualify, but I am deferred contrary to the rules. This could not have been, my lord. Either, my lord, I would have been rejected on that day. Being the 58 candidate, I am rejected. I would have understood. Considered, rejected. But I could not have been considered, qualify, and get rejected.
Yes.
And I have nothing against the others, my lord. I'm only talking about 48 candidates. Those who have been selected. I'm not on that. So, my lord, this shows, my lord, that the equality is not maintained. And, my lord, this calls for the transparency. When I'll show the judgments, the other high courts have done it. They've called for the records, which would speak for itself. The, my lord, mark sheet, the permanent committee records, and, my lord, the minutes of the 2 meetings. As to how a candidate who is considered and qualifies is deferred, which is not there in the rules.
Yes.
Now, my lord, kindly sees apropos this, as I was showing. My lord, this kindly, let us come back to that letter at page 123. This was sent on the day, my lord, that, my lord, the list was published in December. This deviation will cost an entire career of an applicant to be jeopardized, which definitely is not what he deserves. Equal opportunity is the touchstone of such selection process, particularly when relaxation of marks has been made in a meeting held on 21st of November 2024 to the extent of selecting candidates whose total marks was below 20 when admittedly the cutoff marks was 40. It is further pertinent to mention here that several candidates has been designated as senior advocates in the meeting held on 21st of November 2024 who did not have the required numbers of reported judgment argued singularly by them as a leading counsel. The aforesaid clearly demonstrate the flexibility offered to the candidates who were designated as senior advocate in terms of meeting dated 21st/11/2024. And my lord, I stand by saying, my lord, if that flexibility is given to X, it should be given to all. Now, my lord, kindly sees. I am not against the flexibility. I am saying if it is given, it should be to all. Everybody is entitled to it. Let there be flexibility, but I want it for every candidate who is there. Therefore, it is humbly submitted and humbly requested to your lordships, ladyships, to follow the same touchstone of the procedure of equality for the remaining 48 candidates, particularly who have fulfilled all criteria in terms of the application form, including obtaining marks more than 40 and above, and revisit the selection procedure adopted on 11th of December 2025 in full court meeting. Allow these candidatures who have attended such criteria by revisiting the full court meeting on 11th of December 2025 before publication of the decision arrived at in the aforesaid meeting, as the same would otherwise seriously prejudice the careers of the applicants. So as I said at the beginning, my lord, I am not against the 81 of them. I am not against them. I do not wish to also. What I want, my lord, is that the criteria which was followed by the 81 should also be followed for all of them, including the marks.
Yes.
Now, my lord, kindly sees, my lord, by my lord, at page 124, on 18th of December 2025, this is the first communication I get after more than close to a year, more than a year, in fact, my lord, by which I am being informed that, my lord, my designation has been disapproved. But the clause says, my lord, that I am to be informed on the day that it is decided for the others also, individually, as I, my lord, read out that clause before, my lord. My lord, that's clause, my lord, 5 at page 70. Now, my lord, under these circumstances, I filed the writ petition before, my lord. My lord, all that I am seeking for is that, my lord, at this moment, my lord, I may make a lot of statements, my lord, in court, that, my lord, is incorrect. Mr. Mitro, my lord, others I am not, because I am not against them. I am not even saying anything. Once they, my lord, they wish to, my lord, challenge my writ petition.
Mr. Mitro only.
Yes, because Mr. Mitro made an effort. So, my lord, I am only under I'm trying to be with Mr. Under Mr. Mitro. But others I am not, because if they, my lord, challenge the writ petition, because I am not, my lord, against them, I am not saying that they should be, my lord, not given or something. I am saying the same procedure should be followed as they have been given. Still, then, if they do, I will, my lord, argue, my lord, after maintainability is raised by them. Because, my lord, I am not posing any threat to them. Now, my lord, as far as Mr. Mitro is concerned and my petitioner is concerned, my lord, what will speak for itself is the records. Nothing else. No affidavit, nothing would, my lord, speak for anything else, but the records will speak for itself, as noted by my lord, whether this has been followed or not. Now, my lord, why I say so? But I want to show a Supreme Court judgment on the same issue. Huh? আচ্ছা ঠিক আছে কেন এটা আনা হয়নি কেন সবকটাই তো এনেছিল because my lord, now I think over this period from January to August, a lot of water has flown through all the high courts and the Supreme Court, which is, my lord, streamlined the process, my lord, including, my lord, the deferment which has been given to all of them, except one, because the cutoff marks there in Delhi High Court was, my lord, 15 years of practice, and he was 10 years of practice. And it is stated there with, my lord, great respect that yours would be considered in the second lot. So this is one of the latest judgment of 2025. এটাই দাগ দেও না আমি দিচ্ছি আমার এগেইনস্টে কিচ্ছু নেই No, my lord, this is, my lord, the judgment passed by, my lord, I'll just show it. My lord, it's Justice Oka and Justice Bhuiya. আমি আপনাকে দিয়ে দিচ্ছি আমি কথা
my lord, now that this is given to your lordship, my lord, this will form a part of the record.
Yes,
Not by personal of the judge.
No, no, it can be.
My lord, it is little marked there, my lord, I'm sorry. But we have a tradition, my lord, in the Bal Library Club, especially when we have a program, it is sponsored by the senior. So all that Mr. Mithru is doing, my lord, is that today evening I have to buy one and give it to my junior.
And when you are doing that, you can do it to a senior also.
I will, my lord, I will. My lord, kindly sees this order which has been passed under these circumstances only, my lord, by the Supreme Court. This is reported in writ petition civil number S61 of 2025. S, bracket S.
Numbers. Yes.
Number 61 of 2025. Raman Ali alias Raman Gandhi petitioner versus Registrar General High Court of Delhi and another. My lord, may I just read it? I'll give a copy, my lord. I'm sorry that this copy is not there. I'll give a copy today itself.
Yes.
My lord, heard the petitioner appearing in person, the learned senior counsel appearing for the petitioner in the companion petition, the learned senior counsel representing the Registrar General of the High Court of Delhi, and the learned senior counsel appearing for the interveners. The challenge in this writ petition is to a notification dated 29th November 2024 issued by the High Court of Delhi, designated 70 members of the bar as senior advocates in accordance with section 16(2) of the Advocates Act 1961. The process has been conducted in accordance with the rules framed by the High Court of Delhi in terms of the decision issued in this court in the case of Indira Jai Singh 1 and Indira Jai Singh 2. We have perused the report submitted by the Registrar General, which is kept on record in a sealed cover. So, my lord, firstly, paragraph 3 shows that the records were called for by the Supreme Court. We have also perused the affidavit of Sri Sudhir Nandrod, learned senior advocate, out of 302 applicants who have submitted applications for conferment of designation as senior advocate. 70 members of the bar have been designated as senior advocates. Out of the remaining applicants, cases of 67 applicants have been deferred, identical to our case, have been deferred, and the rest has been rejected. In our case, nobody was rejected. After having perused the affidavit of Sri Sudhir Nandajog, and my lord will now mark, and the documents produced by the Registrar General of the High Court of Delhi, we find that the only appropriate solution will be to direct the High Court of Delhi to consider afresh the cases of the deferred and rejected applicants. So, my lord, now that they have got all 82, they were rejected also has been included there. Rejected applicants in accordance with the existing rules, namely the High Court of Delhi designation of senior advocate rules. We are conscious of the fact that the prayer for reconsideration of the decision in Indira Jai Singh 1 and 2 has been heard by the bench of 3 judges bench of this court, and the judgment is awaited. We make it clear that the directions issued above are in the peculiar facts of the case to avoid possible injustice to any of the applicants. This is a fit case to exercise jurisdiction of this court under Article 142 of the Constitution of India. Then, my lord, kindly sees, therefore, we issue the following directions. The Registrar General of the High Court of Delhi will take steps for reconstitution of the permanent committee in terms of Rule 3 of the 2024 rules. On the requisition sent by the Registrar General of the High Court of Delhi, nomination shall be made by the government of NCT Delhi of the 2024 rules within a period of 1 week. The applications of the deferred and rejected applicants out of 302 applicants shall be again placed before the permanent committee, which shall be processed afresh in accordance with 2024 rules. We request the High Court of Delhi to complete this process expeditiously. And, my lord, after this, all of them have been given. Identical case where the records were called for, and, my lord, Delhi High Court was directed to, my lord, there was no question of deferment and rejection. My lord, they were all given. So, therefore, my lord, the question is that, my lord, the records, my lord, has been asked for by the Honorable Supreme Court also. And, my lord, I will show, my lord, now why I am asking for the records, my lord, is that the High Courts also, my lord, has done the same. My lord, may I just show the judgments, my lord, which would show this.
But kindly, this is a judgment, I'm not copy the is reported in 2020 SCC online, Karnataka, page 93. This is a quite detailed judgment, my lord. I will show, my lord, the entirety, my lord, deals with this. Correct copy though? আপনাকে আমি কপি দিচ্ছি
2020
গুছিয়ে রাখো নি হ্যাঁ আমি দিচ্ছি
স্যার আপনার জন্য
Now, my lord, here I would show now, my lord, since I am only dealing, my lord, with regard to the call for the records, I am not dealing with the other issues, my lord. Here, my lord, I would show.
And what are the other issues?
The other issues that, my lord, on, my lord, considering, my lord, the fact that there has been inequality or transparency, lordship can pass an order, my lord, for, my lord, it, as, my lord, Supreme Court has said, my lord, is that the, my lord, candidatures of the, my lord, 48 should be reconsidered. That's my issue. I'm not on, again, I'm saying I'm not on the 81.
So that is covered here.
Yes.
That is covered here. That's why I'm asking what is the new further.
That is covered in the Supreme Court judgment. I'm again saying, my lord, I'm not against Mr. Kaur's client or Mr. Mojumdar's client, my lord. Now, my lord, kindly takes, my lord, straight away.
No, in that case, then I will hear all the applicants, all the respondent in person.
But
Not
only
to engage the lawyer.
Because, my lord, I believe, my lord, I believe, my lord, strongly that, my lord, the 81 who has been conferred, my lord, cannot oppose the petitioner on the ground that, my lord, mine should be also considered on the same touchstone. That is my issue.
Okay, next.
Because I am not against them. If they are, then I'll argue, my lord. My lord, kindly comes to, with regard to inspection of records, paragraph 68. My lord, that's at page, my lord, 57. পেয়েছো এটা দিয়ে দাও ইয়েকে আরে জয়দীপটাকে দিয়ে দাও
58
57 প্যারাগ্রাফ my lord ও আচ্ছা paragraph 68 page 57.
Yes.
My lord, consideration of factual aspects. As per the order of this court, an inspection of the relevant records was given to the parties and the members of the bar. Some of the parties have filed their further pleadings based on the inspection of the documents. Therefore, oh, sir, judgment যেটা আমি পড়লাম সেটার কথা may I just read, my lord? Inspection of the documents. Therefore, we must refer to the said documents. The documents show that the meeting of the permanent committee consisting of the then Honorable Chief Justice, Honorable Justice such and such, such and such and such and such, and the then Advocate General and Sri such and such, Senior Advocate, was held at 6 p.m. on 11th of November 2018. The resolution passed on that day records that for awarding points for the number of years of practice, the period shall be reckoned from the date of enrollment till the last date for submission of the applications. The resolution further records that final awarding of marks has been completed and the permanent secretariat was directed to get the tabulation of the marks carried out confidentially by 12th of November 2018. On 12th of November 2018, a meeting of the permanent committee was held at 8 p.m. in which all the 5 members were present and final compilation of the statements of points awarded to the respective candidates and the final statement of points based assessment of the applicants was approved and the said final statement of point based assessment was ordered to be placed before the Chief Justice for further directions. It appears that the full court meeting was held at 5 p.m. on 15th of November 2018. The subject of consideration of final statement of point based assessment of the applicants' advocates for being designated as senior advocates in accordance with the provisions of senior advocates rules was placed at item number 3 on the agenda. The statement of points based assessment which was placed before the full court is also a part of the documents of which inspection was provided. Even the statement of compiled data and information with regard to the advocates whose proposals were received for designation is also part of the records. The data complied are in 20 columns under various heads such as date of birth, date of submission of the application, date of enrollment as an advocate, number of years of practice, reported and unreported cases, the legal aid work done, details of the publications, participations in seminars or conferences, association with faculty of law, pro bono work, and suggestions received from stakeholders. The consolidated statement of marks was placed before the full court, which is styled as statements of points based assessment in respect of designation of senior advocates, which contains the details of the points assigned by each member of the permanent committee to individual candidates and average of the points assigned by them out of 100. The points have been assigned to all 68 candidates except the candidate serial number 59, against whose name the word withdrawn is mentioned. For the sake of convenience, we must incorporate the full court resolution in this judgment. So nothing is kept hidden, my lord, because there is nothing confidential about it. The full court resolution dated 15th November 2018 on the subject reads thus: extract of the proceedings of the meeting of the full court held on Thursday, the November 15, 2018 at 5 p.m. in the conference room hall of the principal bench of the High Court at Bengaluru through video conference with Dharwad and Kalaburagi benches. To consider, item number 3, to consider the final statement of point-based assessment of the applicant advocates for being designated as senior advocates as per the High Court of Karnataka designation of senior advocate rules 2018. Then the resolution is also quoted, my lord. After taking note of the norms, guidelines formulated by the Supreme Court of India in paragraph 73.1 to 73.11 of the decision in Indira Jaising versus Supreme Court of India through Secretary General 2017 9 SCC 766, as also the High Court of Karnataka designation of senior advocate rules 2018, and the extensive exercise carried out by the permanent committee, the full court has deliberated over the issue of designation of senior advocates as per the statement of point-based assessment provided by the committee. The full court has also taken note of the fact that the designation of senior advocates in the High Court of Karnataka has not been carried out for last more than 3 years at present, and there are 65 advocates. Now, my lord, this is a division bench judgment which not only, my lord, discloses, my lord, the records in full from the permanent committee till the full court, my lord. Now, my lord, there is also an issue, as I said. This court made it very clear that, my lord, only inspection and notes can be taken by the petitioner and the respondents, not by anybody else. It will not be made public. And I also said, my lord, we have no, my lord, hesitation in doing so, because, my lord, we do not want to make anything public, but we want to argue something which is there in the court records as that of the Supreme Court before the Honorable Court. In camera, now, my lord, there is copy আছে এটা? Now, my lord, I have the single bench order also of that court. I have downloaded it from there. From this only the division bench order was passed. Kindly seize, my lord, what the single bench order was.
We have had the submission.
So it's identical what my lord is hearing now. But this is, my lord, kindly seize. This starts, we have heard the submissions. Lordship has taken it more. We have heard the submissions of the petitioner appearing in person in WP number such and such at some length. We have also heard the learned counsel appearing for the petitioners in WP number such and such and the learned counsel for the petitioner. We have also heard the learned senior counsel represents the High Court administration. Considering the submissions made across the bar by the learned counsel for the petitioner, and after hearing the learned senior counsel appearing for the High Court administration, we direct that inspection of the following documents, records to be provided to the advocates representing the petitioner and also to the other parties. Number 1, proceedings of the committee for designation of senior advocates dated 11th November 2018 and 12th of November 2018. Number 2, booklet containing the marks obtained by the various candidates which was placed before the committee for designation of senior advocates. Number 3, statement of point-based assessment prepared and placed before the committee in respect of designation of advocates as senior advocates. And 4, extracts of the proceeding of the full court meeting held on 15th November 2018 regarding the proposal and decision taken as regards designation of advocates as senior advocates. We direct the registrar recruitment to provide the inspection of the aforesaid documents on the 6th and 7th of August 2019 between 4 p.m. and 6 p.m. The inspection will be provided only to the parties and their respective advocates. So, my lord, this is followed by the High Court as well as to the Supreme Court. So, my lord, unless the records are there before my lord, it is impossible for my lord to come to a conclusion either way, rejection or approval. Now, my lord, this is not only with regard to Supreme Court or Karnataka, my lord, this has also been done by other high courts. Now, my lord, this has been done by the Patna High Court also. My lord, kindly I'll give that judgment also. Patna High Court. Basant Kumar 2005 SCC on law.
আমাদের ক্ষেত্রে আমরা আমাদের ইন্সপেকশন চাইছি না।
Copy the 2005 SCC online, page 196.
2005 SCC online.
Well, this is reported in 2005 SCC online, page 196. This is of the Patna High Court.
SCC online Patna.
Yes. My lord, by the division bench itself.
SCC online Patna page.
My lord, this is, my lord, 196.
21 page 243.
My lord, kindly seize this judgment. My lord, paragraph 21, page 246, my lord. Identical issues, my lord. I'll show, my lord.
Yes.
The petitioner at one point of time requested us that the complete records relating to the applications to be called in the court and he be allowed to peruse the same. We allowed this prayer and call the records and peruse the same. But we did not allow him to look into the personal records of those advocates. Fair enough. My lord, that is with regard to judgments reported and all. I am also not interested, my lord. I am not against them. We do not think that the petitioner has any authority to look into the records of all others because, my lord, I don't want to look into what judgments are reported by them or anything, my lord. If the petitioner says that he has a right of information and the transparency should be made the rule of the day, then we expect that the petitioner would be honest in his words and give the information to us which we are seeking from him. So that is why I am being allowed to inspect. For him, secrecy is the code, and for us, transparency is the rule. We, the judges, are not subordinate to the lawyers. If the judges have been conferred an authority to choose better people in comparison to others, then some scope or some discretion is left in their favor. Absolutely. I also agree, my lord. After all, a jeweler can judge the diamond and can value it properly. Every gem has its own value, but same are better in comparison to others. And if the best is segregated and put at higher pedestal, then there is nothing discriminatory and the equality clause enshrined in the preamble of the Constitution is not affected. This is exactly what I want. I want to see, my lord, that, my lord, the jeweler has done this only. That's all.
Yes.
Now, my lord, there is one more judgment on this issue, which, my lord, I think I can cover up today before I show the others. কোনটা বিষ্ণু বিহারী দেখাচ্ছে কোনটা এটা এলাহাবাদ 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 এটাই তো না 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 আগে বিষ্ণু বিহারী there is a judgment also of ওই যে তলারটা 6 নম্বরটা 6 নম্বর হ্যাঁ নিশ্চয়ই নিশ্চয়ই এটা ওটা স্যারকে দিয়ে দাও so this is a judgment again, my lord, of the, my lord, Allahabad High Court, reported in 2024 SCC online, a division bench judgment. Online, Allahabad 5363. But kindly takes paragraph 85. 5363.
Page 155.
Page 85, Lordship states. Paragraph 85, my lord, which is at page, my lord, 35.
No, 155 page.
Oh, sorry, 155. Oh.
Yes.
My lord, may I read this? Further submission has been advanced and specifically expressed by the petitioners that the permanent committee, though impleaded as a party respondent, it has not submitted any counter affidavit and there is no specific denial by the High Court to the material pleadings made in paragraphs 35 to 38 of the writ petition and other paragraphs of the writ petition. In the context of the challenge raised to the validity of the rules and bona fides of exercise of power made by the permanent committee and the full court, we had considered the challenge raised that with that much care. For that reason, my lord will kindly mark, for that reason, we had called for the original records of the permanent committee and the full court. Those records reveal the true facts as noted above. Being matters of record and that are before the court, the alleged lack, inadequacy of pleadings pales into insignificance. That is exactly what I am saying, my lord. I can say a lot of things, but the records will speak for itself. For that reason, we find the ratio of the decision in Bharat Sanchar Nivan to be distinguishable on facts. Therefore, my lord, I find, my lord, as I showed, records have been called for by all the, my lord, high courts as well as the Supreme Court. And there is one more judgment on this issue, my lord, which I want to show before I end today. Is, my lord, a judgment of the Allahabad High Court. This is a 3 judges bench. My lord, reported in 2000 SCC Online, Allahabad 502. Here, in fact, my lord, a submission was made that how did the petitioner and the others come to know of what has happened? And the court has dealt with that, saying that it should be known because this is something which there should be transparency in it. Now, my lord, kindly takes, my lord, paragraph 13.
Page 9.
Page, my lord, 9, paragraph 13, or this is page 2 actually. It follow Corona. My lord, kindly takes one. On behalf of the respondents, other two questions have also been raised, which we wish to consider at this stage. The first question is that petitioners are not disclosed the source from where they had obtained the recommendations made by the screening committee, which was not a public document within the meaning of section 76 of the Evidence Act. No one has made any application nor any copy of the resolution of the screening committee was supplied in terms of chapter 40 rules 1 and 12 of the rules of the court to anyone. Non-disclosure of the information, withholding the information is reprehensible and improper as laid down in R.C. Jain versus High Court of Patna. Hence, the petitioners are not entitled to any relief. This question was raised at the time of hearing of the writ petition. This is exactly, my lord, what has been raised by the others here. Learned counsel for the respondent objected that resolution of the screening committee, annexure Roman 4 to the writ petition could not be possessed by the petitioner and they must disclose its source from where they had obtained it. Learned counsel for the petitioners on the other hand submitted that it would not be proper to disclose the source as it may result in embarrassment to the court. Although, my lord, this petitioner has not done anything like that. Now, my lord, kindly sees the court's observation. Considering the delicacy, we did not insist learned counsel for the petitioner to disclose the source. In the case of R.C. Jain, in spite of the order of the court, petitioner refused to disclose the source. In the present case, we did not insist for the same. Hence, it cannot be said that the petitioners have rendered themselves disqualified for the relief claimed in the writ petition. However, we do not otherwise find any substance in the submission which is more technical in nature than substantial. Existence of the document, namely resolution of the screening committee, has not been disputed. On the other hand, along with counter affidavit, respondents have also filed a copy of resolution. The document is not confidential. The Act and the rules do not provide that such documents shall be confidential document. Kindly will mark, my lord. It cannot be disputed that the resolution of the screening committee passed through several hands in the process of preparing its copies for the purpose of distribution to all the honorable judges of this court, along with the agenda of the full court. Thus, it was not difficult for anybody to obtain the copy of the resolution. We do not find any force in the submission of the learned counsel that petitioner, by placing the resolution of the screening committee before this court, disentitles themselves for the relief in this writ petition. Then, my lord, the second objection is with regard to the other issues that I will, my lord, not require here. So, as I said, my lord, all high courts, including the Supreme Court, says, my lord, disclosure of the, my lord, the documents, my lord, which are there, my lord, part of the records of this court. And there is one more judgment, my lord. I can, my lord, multiply it, my lord, to a lot of. This, my lord, is reported in 2024 SCC online, Chhattisgarh, my lord, at page 854. This is a division bench judgment. My lord, will kindly come to paragraph. Paragraph 27, my lord. Eta holo page 16 of the judgment. 854. 854. My lord, may I just read it, my lord? In the present case, the petitioner has raised serious doubts regarding selection process and transparency in designation of senior advocate by the permanent committee, leveling allegations of the arbitrariness, bias, nepotism, illegal and unconstitutional process. And he has also aggrieved with the process of the permanent committee, as some documents which he had demanded have not been supplied to him by the respondent number 1. In this regard, it would be appropriate to mention here that this court, without drawing any adverse inference against the permanent committee for the designation of senior advocate, as an abundant caution, and to consider the apprehension raised by the petitioner with respect to non-compliance of the established procedure, we have also gone through the minutes of the meeting of the permanent committee for designation of the senior advocate, that is respondent numbers 12 to 13, and find that all rules of 2018 for the designation were strictly adhered to by the permanent committee of the High Court, and allegations leveled by the petitioner against the is absolutely baseless. So therefore, my lord, I want this only. The court has to look into, my lord, the records.
Yes.
So that is my first submission, my lord, is that let the records be called for before this honorable court, my lord, so that, my lord, the same will speak for itself as to whether there has been, my lord, any arbitrariness or, my lord, there is one more judgment. May I place it on the next day, my lord, on the same issue?
What?
On the same issue. The three judges. আর মাল্টিপ্লাই করো না, জাজ কোড গুলো বলে দিও, তাহলেই হবে। 2005, my lord, SCC online, Chhattisgarh, page 15, my lord. Paragraph 5. My lord, kindly takes paragraph 5. This is a 3 judges bench, my lord. Page ta dada holo 50.
1-5, na? 5-0.
Paragraph 5.
5-0.
5.
1-5.
15. 1-5.
1-5.
1-5.
In view of the said submission made by Mr. Such and Such, we called for the records of the registry of this court with regard to the designation of the respondents such and such to such and such as senior advocates of this court by an order dated 20th of July 2005, and pursuant to the said order dated such and such, the records regarding designation of the respondent numbers 5 to 21 as senior advocates have been placed before us by the registry. On a perusal of the said records, we find that on such and such date, the full court of the Chhattisgarh High Court has resolved that such and such may be designated as senior advocates. On perusal of the said, we also find that the full court of the Chhattisgarh High Court has resolved to designate such and such considering their standing. So, my lord, all that I am trying to show that, my lord, records have been called for by all the courts.
Yes.
And then only, my lord, we can make appropriate submissions, my lord, with regard to after the inspection of the records by my lord, as well as if your lordship restricts it to the petitioner and the respondent. That also, my lord, is, my lord, of no difficulty to us, because, my lord, we are not against. We only want to see that, my lord, as we state of that the equality which I showed from the records itself, which fell, 1 is not chosen, 2, 3 is chosen, 4 is not chosen. How is the cutoff marks arrived at when the permanent committee has the power and nobody else? What is the cutoff marks which is there? Whether, my lord, whoever has been given has obtained that cutoff marks. If not, then that flexibility should also apply to the 48 candidates who have been deferred. And, my lord, what is the reason for deferment when I am considered and I am approved?
Yes.
And when there is no clause in the, my lord, notification for deferment.
When they are not asked, when they are
And,
not
my lord,
willing to produce the record.
when, my lord, most importantly, the Supreme Court has even said, while remanding the matter to the Delhi High Court, which all of them have been given now, is that, my lord, since there is no deferment, and in fact, my lord, they were more, my lord, I would say, they had a better luck. Rejected candidates were also included, and they sailed through. All of them sailed through. All they were rejected also were Supreme Court directed that put them in, since the procedure was not followed.
Yes.
So, my lord, therefore, I say, my lord, the initial prayer that I have is in prayer in terms of prayer C, which would not prejudice anybody. My lord, is that the, my lord, records with regard to the, my lord, the permanent committee, my lord, and, my lord, the board, the resolution of the full court, my lord, should be called for, my lord. Thereafter, my lord, this matter can be, my lord, considered in full. That's prayer C, my lord, that I am seeking for. My lord, I will continue on the next day, my lord. If
Further continue, what remains?
if lordship, my lord, upon hearing them, if I have to reply, my lord, with regard to prayer C.
Page 42.
Yes. Yes. Yes, Mr. Mitra, next date.
Yes, ma'am. On which day convenient to your lordship, my lord?
It is ideally, my lord, it is, I want to hear Mr. Mitra only because records are with Mr. Mitra's clients. It has got nothing to do with the others, my lord.
As a modified to prayer, modified to prayer C.
So I to said, my lord, I to said that, my lord, if my lord, the records are called for, my lord, lordship
No,
can
he is
put a
telling that he is
stipulation.
not against the designation. That's why on that prayer I directed to the designated senior advocates be
Today, my lord, today as I said, my lord, that on that day also I said, my lord, that the records, my lord, we are not against them. The records
No,
will
but
speak
with
for
regard
itself.
to the prayer AI, that is the main crux.
My lord, I am not against, my lord, setting aside at the present moment. I'm not even saying.
Not present moment. That is the
Lordship,
process.
what is being said, my lord, is that, my lord, as I said, my lord, I want the same touchstone to be there, has been done for the others. And that the records will speak for itself.
Counsel for the petitioner has concluded his argument with regard to the production of the call for the documents from the call for the document with regard to the designated the advocates as senior and designate for designation of senior advocates due to paucity of time and counsel for the High Court administration could not argue the matter. Accordingly, case is adjourned. Let the matter appear on the date.
But only request, I think, which both of us have.
But if you not kindly give us hot date, my lord.
Date nahi. That is the problem.
And a time fix, my lord, like this on a Monday, my lord, it would be
Go to the
convenient.
September.
Well, that kindly will not do. Kindly will give some precedence to this matter, my lord. From January, my lord, we have waited. I would not say a word, both of us, Mr. Mitra and myself, my lord, for the court, because
I have not uttered a word as yet.
it is all because of full courts. So, my lord, as from the bar, we can never complain for that. But kindly considers that, my lord, and as lordship kept in a Monday at 3 p.m., my lord, it would be better. Admiralty matter করছে
Saturday ko to amar aputti nahi.
Yes, Mr. Mitra, when you will be available?
Lordship fixes a date, any date I shall come.
On a lighter note, my lord, Mr. Mitra suggested something which lordship did not hear. স্যাটারডে করতে আমার আপত্তি নেই, as is always fair on it, my lord.
25th August.
25th.
25th August at the top.
At the top, my lord. 3 p.m. that is, my lord. This is an original segment.
345 fixed. There was a 345 fixed pattern.
25th.
I am also that fourth time it's getting adjourned because of either resolution or somewhere or the other. Only thing is also item number 2. But let it retain its position in the list. Because if I request Lordship to fix, it will go to September. I don't want it to let it retain its position. Item number 2, we can tomorrow come any day. We can. Great.